take
For correction of order, my
correction you give to me.
lord, for correction. My lord, for correction.
If it is only unlisted, I will take. Otherwise, I will not take. Yes,
No,
call.
this is, may I have my lords the kind leave to me lord make an unlisted mentioning my lord.
What is expiring today?
Why you not mentioned yesterday?
The matter was supposed to appear today. Appear today as item 105. Can I come back at
Give the list supplementary. Give the supplementary.
My lord, similar prayer, my lord, item number 101.
Sir, you give it. It will be listed tomorrow. Sorry. Yes, call the list.
Item number 101, my lord, of my lord's list, my lord. Mentioned yesterday, my lord, for extension of interim order expires today. My lord, interim order is expiring today, my lord.
item number 1? I am for the petition.
Item number 101, my lord. Kindly, my lord, kindly take it up at 2 p.m., my lord.
Under group 9, it categorically group 6, my lord. I will be seeking your lordship's leave to release, and I will seeking also leave to correct the presentation form and the cost title.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted. Inadvertently, the petitioner has mentioned the group 6 in the presentation form, group 9 in the presentation form. The matter relates to group 6. Accordingly, prays for leave to correct the group in the presentation form and for release of the matter before this court, so as to enable the petitioner to mention the matter before the appropriate court. In view of the submission made by the counsel for the petitioner, petitioner given liberty to correct the group in the presentation form in course of the day
And the cost title, my lord.
and in the cost title. WPA number 18643 of 2025 is released from the list of this court with the liberty to mention before the appropriate court having
Grateful, lordship.
Yes.
May I please your lordship? Lordship, this matter puts into the writ petition under the heading of SURFACE. Hence, I am praying for release of this matter, lordship.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted the matter relates to the SURFACE Act and he prays for release of the matter. In view of the submission made by the counsel for the petitioner,
With the liberty to
WPA
mention it before the appropriate.
21155 of 2025 is released from the list of this court with the liberty to the parties to mention before the. Next.
Item number 3, my lord, I am appearing for the petitioner.
Yes.
This is for withdrawal, my lord.
It is dismissed already. Why it is mentioned?
My lord, there was a CAN application which we had filed, my lord, seeking for modification of the order. My lord, the proper recourse will be an appeal, my lord.
No, the matter is already dismissed. Why?
My lord, the CAN application I'm withdrawing.
It is fine from the record that by an order dated 29th of June 2026, the matter has already been dismissed. Accordingly, the department is directed to take appropriate step for mentioning, for correcting in the website as disposed of.
My lord, the CAN application may be withdrawn, allowed to be withdrawn.
My lord, in item number 4, I am for the petitioner. There are two inadvertent error. My lord, in the name of the petitioner, it is written in the affidavit and in the main cost title.
Where is the order?
Correction in the cost title, for cost title and in the affidavit.
Correction in the
Cost title and in the affidavit.
What is the name?
It should be Sadija. It is written at Sajida.
How you can say?
There are Aadhaar card in the annexure.
Where is the Aadhaar card?
Aadhaar card. On page 29.
Sadija.
Page 29.
Sadija.
It should be Sadija. Page 29, my lord.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for correction in the correction of the name of the petitioner in the cost title as well as in the affidavit portion. Counsel for the petitioner submitted the name of the petitioner is Sadija, Sadija.
Sadija.
Sadija Begum. Sadija Begum, but in the cost title and in the affidavit portion, the name of the petitioner is recorded as Sajida, Sajida, Sajida Begum instead of Sadija Begum. Sajida, Sajida Begum instead of Sadija, Sadija Begum. In view of the submission made by the counsel for the petitioner, peruse the record. The petitioner is given liberty to correct the name of the petitioner in the cause title as well as in the affidavit the portion in course of the day.
Sir, kindly give a direction to the department to correct the
I am giving the liberty to you. What the department will do?
May it please your lordship.
5, my lord, I appear on behalf of Kolkata Municipal Corporation.
Yes.
You only pray, my lord, Mr. Vishwajit Mukherjee is leading me.
Yes.
Mr. Vishwajit Mukherjee is leading me, my lord.
Ah.
My lord, if my lord may kindly take it up tomorrow, he has got some difficulty today, my lord.
Lord, I would be praying for a very innocuous order, Lord, subject to my Lord's pressure. A report be filed, Lord, because this cannot be disposed of in this manner. A report from two authorities, Lord. One is the registration authorities and the other one is KMC. Lordship will only direct that, Lord, because
My lord, I will only pray, my lord, let this direction be passed tomorrow.
Let come tomorrow.
For the
Not today. Let the same under the same heading, same position. Huh?
same position. I am grateful.
For the petitioner, my lord, on the last occasion, my lord, on 2nd of February, lordship has heard this matter and direction was given, my lord, to serve the copy of this, again intimate the bank, my lord. I have intimated, my lord, through email, through post, they have received it, my lord.
My lord, I am appearing on behalf of bank, my lord. I have not received the copy of the writ petition, my lord. I have instruction.
You are appearing for
Bank, Canara Bank.
respondent number.
I believe it's number 3, my lord. They are the main, because of 3, my lord. Senior manager, Canara Bank.
You are appearing for 3.
Lordship.
So
Well,
3
let-
and 2 are the same.
Let the, my
20.
lord, 2 and 3, my lord.
Ah.
Let the copy may be served, my lord.
Copy has been served quite a affidavit.
What your bank is doing with after receipt of the copy?
Well,
Yes,
kindly
sir.
see, I have instruction that we have received only letters, not
No, no, my
copy.
lord.
You-
I will give, my lord.
Counsel for the petition has filed affidavit of service. Let the same be kept with the record. So and so appearing for the respondent number 2 and 3 and submit that though they have received the information about the hearing of the matter, but have not received the copy of the writ
Copy has been
application along with the document. Counsel for the petition submitted the petition already served the writ application along with the document. In view of the above, the petition is directed to serve a fresh copy of the writ application and the documents to the learned advocate appearing for the respondent number 2 and 3 by tomorrow.
Yes, my lord.
By
I
tomorrow?
checked up if any document copy is there, but I will serve herein now.
By tomorrow, list the matter. List the matter.
My lord, may I hand up just now?
Okay, serve for the counsel for the petition already served the copy to the counsel appearing for the respondent number 3. The respondent number 2 and 3 is directed to take instruction and to file report on or before 28th of July 2026 after serving the copy to and counsel for the petitioner. List the matter on 29th July under the same heading
Give some preference, lordship, because
within 10 matters.
otherwise, on 2nd February, lordship heard this matter now. Grateful, lordship.
Take instruction, come with the report. Come with the report.
My lord,
If you will not come with the report, then it will be difficult.
my lord.
Yes.
My lord, in 7, 8, 9, 10, my lord, I have been led by Miss Afrin Begum, my lord. I am
Huh?
praying. I have been led by Mrs. Afrin Begum, my lord. I am praying for a short Passover, my lord.
Begum,
Your lordship, in these matters, these are referred.
Well, these are with regard to pushing back of the Rohingya, not refugees, infiltrators. Your Lordship, initially orders have been passed by my lord regarding a report, if I am not mistaken, because from the state, whether they have kept them, because my lord, erstwhile, my lord, I had
No,
done.
now the situation has changed. You have already, now the government has already directed the concerned district magistrate to identify the places where the foreign nationals is to be kept with
Lordship.
till their identification or pushed back to them.
Lordships.
Now these persons are in custody
Lordships.
and it is burden of the state to, because even after the conviction is
My
over.
lord, my lord,
Correct. So that's why now as per the judgment of the Supreme Court,
my lord.
if we are not making any alternative arrangement for keeping the persons, then we have to release on beyond. So earlier there was no provision for with regard to the keeping the Rohingyas or foreign nationals in any places. So this court has released the 1 or 2 persons, and before releasing, then what the details of the surety they are furnishing to the court, then it has been referred to the state as well as the authority, the FROs, to consider with regard to the genuinity of the sureties And if the reports come, then this court is releasing the persons on bail. But now the situation has come whether these persons can be accommodated in the district places which they have identified for keeping the persons till they have been repatriated by the Home Ministry's order. That is to be taken into account.
I suppose the state will be there with.
My lord, I directed the state to take a call, my lord, whether.
That's why I'm asking, where is the state?
My lord,
Sometimes states appear, sometimes state does not appear, I don't know. The June, Mr. Loknath Chatterjee was appeared.
well, it may be kept next week if Lordship
And
should.
whether you take also instruction,
My lord.
whether any civil authority, any officers has been appointed giving the civil authority, because he is the main person. If the person is released also, then the civil authority has to appoint one person giving the civil authority to him so that he can take care of this movement of the persons who have been released from the custody of the foreign nationals. Because till date, prior what I heard, no civil authority was appointed in terms of the act. Now the civil authority has to be appointed by the government.
Look, what I on instructions, my lord, what I understand is that the superintendent of police has been designated as the civil authority.
Correct. That's but here before the new government has come, when I taken the matter, it was informed to this court by the state authority, no civil authority. Even ESGI also informed this court, no civil authorities have been appointed.
Well, it's better, my lord, that I was not the incumbent in office prior to this. Lordship, let me be well aware, and Lordship, I will come up with proper instructions, my lord.
Mr. Loknath Chatterjee is appearing on.
Huh?
Mr. Loknath Chatterjee is appearing on the behalf of state. 7 to 10.
It's coming.
It's coming.
That's why, because in other states, other union territory, the concern some of the SPs have been given as a civil authority, and they're taking care of it, and they are managing with regard to the movement of the foreign nations who have been kept in the home. So
well, what has fallen from your lordship is two things, my lord. One, state should respond. I don't know, Mr. Loknath Chatterjee on his way, my lord. If he comes, my lord, that can be taken care of. Because, my lord, my understanding, they have created a safe house, but let it come from the state authority.
Correct, that's why.
One. And secondly, what I have been told that Superintendent of Police is already the designated authority, but be that as it may, lordship, let me come up with a written instruction.
Written instruction.
So
Otherwise,
that we can place it on record.
Any of the superintendent, they will come. I am not. Then it will be creating problem.
I bow down to. I'm on the same page.
If it has not been done by these two options, then they have to be released on bond as per the order of the Supreme Court.
My lord.
With the certain
Well, what I'm humbly submitting is, since Mr. Loknath.
When you will come?
My lord, he is.
Okay, pass it to.
Pass over home
Pass over?
Yes.
Okay,
My lord, because then if the state comes up with a particular report, then my lord can we can take the matter forward.
Pass over. 7 to 10, na? Yes. None appears on behalf of either of the parties. Trivedi तभी यहाँ था. There is Pandey. Yes,
I apologize, my lord. Lord, I am appealing for the petitioner. My lord, we have exchanged the affidavit. Lord, we have already exchanged the affidavit, but my lord, I suppose
nobody's. Mr. Kallol, yes. Yes, none appears on behalf of the respondents.
I will kindly keep it up because my lord, all the lordships.
Let the matter appear on 29th July under the same heading within 10 matters.
I'm grateful.
Your Lordship, I am for the petitioner in item number 12.
Yes.
And this is, I am aggrieved by a termination order of my contract on dated 16 December 2025 without any valid reason, which I would like to demonstrate before the Honorable Court, that a show cause notice was issued on 18th August 2025. I was awarded the work
Where
on
is the
14th.
affidavit of service? Have you served?
Sir,
Where?
yes, notices have been served. My colleague is there who will submit the service notice.
Notice has
All
been
the
served.
three it has been served, sir.
What about the 1 and 2? This is service of 3 only. Service Sakshi goes. What
Last
about the
day,
1 and 2?
Lordship, on last occasion, we have submitted the affidavit of service. It is
No, but you mentioned the matter. No, after mentioning the matter has come, where is the notice?
upon respondent 1 and respondent 2. Service has been done earlier. Kindly see the last affidavit of service filed before your Lordship. Service upon respondent 1 has been done through hand delivery.
Handling. Additional government advocate. Minister of Law and Justice. Yes.
Last time the counsel for the respondent was also present, but he said he did not have any instruction from the their client also. So the matter is that, sir, a tender was called by the respondent IIT Kharagpur.
No advocate from the other side. It is not possible because there is a resolution of the bar. In the absence of the advocate, it cannot be taken. Let it come tomorrow.
But sir, it is an urgent matter and a straightaway case is settled by me. I will just demonstrate that this show cause notice pertains to a certificate which was non-existent on the date of the call of tender, because tender was called in 22 and the impugned certificate which they are saying that it is forged was 24, means 2024. A 2024 certificate can never be submitted for a tender called in 2022. So basically, this show cause notice was a predetermined notice, and they were not dissatisfied with my service. The tender, the contract has not been determined or foreclosed because of my wrong services, but on allegation of a certificate which was non-existent, which was never submitted by me in 2022. This certificate, which has been mentioned in show cause notice on page number 59, your Lordship may kindly see. Page 59, Annexure P7. This is a notice 18th August 2025 and para 1 say that you have submitted one completion certificate dated 18th August 2024 issued by Odisha Bhavan, 18th March 2024 issued by Odisha Bhavan as a credential of the above mentioned tender. Now this tender is 2022's tender because it is mentioned published on 20 December 2022. Sir, in 2022, I did not have this certificate. How could it have been submitted? So basically, when the foundation of the show cause notice is wrong, the final action of determination is wrong. It is not required to be proved even.
Okay. Come tomorrow. Though the petition argued the matter at length, but none appears on behalf of the respondents. Police of petition has filed the affidavit of service. Let the same be kept with the record. Let the matter appear tomorrow under the same heading, same position. Next.
Publish.
My lord, Mr. Nilanjan Bhattacharya, learned senior standing counsel is for the state, my lord.
Who is for the petitioner? Has none appears on behalf of the petitioner? Let the matter appear on 10th August. Next.
I appear for the petitioner, Lordship. Time what possible, my lord.
If all the sort was what the court will do. Yes, what is the matter?
Lordship, the petitioners for the employees of Ramkrishnapur Cooperative Bank, my lord. The bank.
Yes.
The bank was given license as a to operate as a cooperative bank in the year 1983, my lord. The petitioner number 1 joined in 1994 and the petitioner number 2 in the year 1995, my lord. They were working at the post of accountant, my lord. I'll come to that. In 2010, the Reserve Bank of India rejected their license for renewal of the license.
Rejected the license of the bank.
Yes, my lord. Yes, my lord. Thereafter, several litigations were filed by the depositors, my lord. One of the litigation was carried into the appeal, my lord. There, the 61 employees of the bank, my lord, filed an application on their behalf. The union filed an application to be added as a party, my lord. There, the honorable division bench of this honorable court, my lord, allowed the petition, and that appeal was disposed of by directing the state government. Their state government also came forward to take steps for revival of the bank. The state also ensured to take steps to grant to pay off the dues of all the employees, my lord. However, that was not done. A contempt petition was filed. In that contempt petition, an order was passed, my lord, and thereafter the secretary of my lord, if my lord kindly comes to there, a reasoned order was passed by the respondent number 2, my lord. All the employees were called upon to submit their respective individual claims, my lord, to be taken into consideration. Both these petitioners filed their claim, my lord. I'll come to the documents, my lord. However, the petitioner number 2, there was some personal loan of both the petitioner, my lord. The petitioner number 2 was paid only a part of the amount of the gratuity, my lord. The rest amount of the gratuity was deducted. The petitioner number 1 was not paid any amount, my lord. However, their claim was not restricted only to the gratuity amount, my lord, because they were in service when the bank closed, my lord. And there was a hope of revival of the bank, my lord. They were not terminated. So they claimed their dues till the date of their retirement, the basic salary which they were drawing along with the the benefits out of that. However, this was not considered, my lord. No amount was paid on that, my lord. This is my grievances, my lord. The registrar was directed to file affidavit by my lord, which they have filed a report, to which I have also filed an exception to the same, my lord. May I now show the documents, my lord, the order sheet, which is kindly come to the order dated 24th April, my lord, which starts from page number 25, where the mat was disposed of and direction was given to consider the relevant portion is, my lord, 27 and 28, page 27 and 28.
Of the writ petition?
Yes, my lord.
27 and
28. This is the part of the order dated 24th April 2023, my lord. Page 27. Chairman, Chairman, Cooperative Society, answering this one in clear.
So where is the order? Impugn order?
My lord, this is the representation, this is the reason order at page 64, my lord, annexure P5, where the employees were called upon to submit their individual claim.
64.
Yes, my lord. That is reason order passed by Additional Chief Secretary of Cooperation Department, my lord.
Then
Lordship, pursuant to this order, the petitioner submitted their claim, which would appear at page 69, my lord. The claim of petitioner number 1 and yes. And page 75, claim of the petitioner number 2, my lord. The claim sheet, the annexure to that.
where is the impugned order on this?
My lord, this claim was submitted. No step was taken, my lord. After that, only a part of the gratuity amount was paid to the respondent number 2, my lord. And the balance amount around 1,47,000 was deducted towards personal loan, my lord. Whereas it is settled proposition, my lord, that from gratuity loan cannot be deducted, my lord. However, the rest.
69 to 76 is the representation in terms of the order passed
Yes,
by
my
the
lord.
Additional Chief
Thereafter,
Secretary
it
to
is-
submit their personal grievance.
Yes, my lord.
Correct. And you have submitted a 69 to 74, 74, 6. Then
It was
whether
not
that
considered, my
not
lord.
considered.
Then a representation was made through the learned advocate, my lord, which would appear at page 82, my lord, annexure P8. That representation also was not taken into consideration. No step was taken, my lord. Thereafter, my lord.
What is the report? What the report says?
My lord, report says that a committee was formed only to.
What the report says?
Yes, my lord. If my lord kindly comes to page 3 of the page 2 and page 3 of the report, my lord. As per the report, committee was formed only to take into consideration of the amount which was payable to the depositors, my lord, and it was not empowered to address any administrative matters of the closed bank, including the issues pertaining to its.
Where from you're reading? Where from you're
My
reading?
lord, their report, page 3.
Page 3, which
Yes,
paragraph?
Paragraph 4. This is all contrary to the order passed.
What has happened to the other employees?
Other employees, as per them, I don't have any document to that. But
So there are
what
the
they
union. After the union, the chief secretary has passed an order to file their separate claim.
individual
What has
claims.
happened to the individual claim of the others?
What they submitted on the last occasion, my lord, that the other employees taken off their gratuity and they are satisfied with that. That I am not aware of that, and I cannot make any comment on that, my lord, because I don't have any document or in support of that.
So you have not been allowed any of the benefit.
The petitioner number 1 was not paid any amount.
Ah.
The petitioner number 2 has been paid 47,000 only, my lord, after deducting the.
Where is that?
Would appear at page 7, page 8, my lord, of my writ petition. The petition number 2 was paid only 47,000 after deducting 1,04,431. This is out of this gratuity amount, 1,79,000. They did not consider my other claim, my lord, towards my salary, because I am not terminated, my lord. So I could not find any other job also. I was entitled to the basic salary which I was drawing till the date of the retirement. So they did not consider all that. Only out of 1,79,753, which is the gratuity amount accumulated as on that date, they deducted 1,04,431 and paid only this 47,000, which they cannot do because from gratuity personal loan cannot be deducted, my lord. And the petitioner number 1 did not receive any amount. My claim is, my lord.
No, the division bench, before the division bench, with regard to the revival of the cooperative bank.
No, dues also, my lord. If
Where is the dues? Where
yes,
is
my
the
lord.
order?
Kindly come to page 27, my lord, of my.
Yes, I am 27 only.
Kindly come to page 28 of the writ petition, my lord.
Revival and Recovery Committee that constituted
The state government shall also ensure that employee of the bank receives their dues, which they are entitled to in accordance with law.
Yes, yes.
My lord, page 28
It is expected the other concerned party, including Reserve Bank of
of my
India,
writ petition, my lord.
shall make endeavor to revive the business of the cooperative bank in question in accordance with the revival and the recovery committee that the court has constituted stand discharge. We record the gratitude. Then what? Where is that?
My lord, page 28, second paragraph, my lord, I am reading
Yeah.
of my writ petition.
Yes.
The state government shall ensure that the employees of the bank receives their dues which
Correct.
they are entitled to in accordance with law.
Correct.
My lord, this observation, my lord, this direction, my lord,
Yes. Where is the bank? Where is the senior?
cooperative.
Where is coming? America? Ah. Court number 4. He had no knowledge that the matter is fixed today. Yeah. What Passover? You have taken 10 minutes has been passed. What Passover further? I have given 10 minutes. I have heard the petitioner. If your senior is not having the time, why you are accepting the brief? Passover. Next. Hey.
Well, I am for the petitioner, my lord.
Yes.
Looking for the Reserve Bank of India.
Hey, that's 70.
I appear for the IndusInd Bank in this matter, my lord.
My lord, the petitioner took a loan from the respondent bank in the year 2021. And in course of the August 2025, the entire loan amount was repaid, including the all penal charges. Thereafter, I applied for NOC. Denied. Thereafter, the learned advocate of the petitioner made a representation, asked for NOC to the concerned bank, but subsequently the respondent number 5 issued a letter of denial for providing the NOC. My lord, kindly come to page 26. My loan account number is WAD0048E. Well, may I be permitted to read it out? The undersigned authorized officer of the IndusInd Bank Limited, Consumer Finance Division, herein after reference such and such, do hereby issue the notice to you in reply to your letter dated 30th January 2026, and understanding the purpose of thereof. Undersigned authorized bank gives this reply as hereunder. At the every outset, we would like to inform you that we are financial institution dealing with the public money and provide the financial assistance to the different borrowers. It is pertinent to mention you that your client had entered into another loan account being number such and such as a guarantor. This loan amount was provided in favor of one Imtiaz, son of Muhammad Akram, Bidhannagar, such and such. Responsibility as the borrower towards the timely repayment and closure of full satisfaction of the bank, the loan account being such and such as per the terms and conditions mentioned therein. Further, the loan agreements are all landmark as per the terms and conditions of the agreement. Hence, NOC will only be issued upon closure of other loan accounts. But my loan account closed. I have repaid, enter on all penal charge. But I have been denied by the authorized officer, respondent number 5 herein, that I am a guarantor in respect of the another account. For that reason, this loan account is being continued. The said Imtiaz is repaying his payment time to time, but bank has said until and unless the repayment of that loan is being closed, they will deny.
Yes.
But my submission is that, my lord, when my loan account has been closed, I have paid the entire amount. What is my fault?
Yes.
But then
so when you entered into a guarantor in terms of in fear of
this loan has
just I mean
closed. That is being continued without default.
if you have entered as a guarantor of
Yes.
Mr. Imtiaz,
Yes.
what document you have executed?
But being a guarantor,
What document you have executed, whether the document which you have submitted to the bank, that may be treated
but
like,
as a guarantor, I have put my signature.
then, yes, madam.
Your Lordship, first of all, my lord, the writ petition, since the IndusInd Bank is there, my lord, it's a private bank. So writ petition should not be entertained because, my lord, it's a private entity, my lord. Moreover, this arises out of a purely a contractual dispute, my lord. There is, if my contract provides that, it's that if there are several loan accounts in name of a person, my lord, and if one loan account is closed, it can withhold the no objection till the time, my lord.
Show me. Show the law.
My lord,
Show the law,
my
the
lord,
guarantor,
my lord, the-
guarantor property can be written if the his loan has been over.
The guarantor's liability
Clear.
is coextensive.
Show me the law. If you are making any submission before the court, come with the law. I will go to the technicalities subsequently. Show me the law. If the person who is the original borrower, he has paid the clear the loan amount, the document or the property which has kept in lien, it has to be released. Show me the loan. If he is the guarantor to any person, that property is to be kept in lien. Show me the law. I will dispose of. Show me. Your authority has given the letter.
Yes, my lord. The
So
agreement
show me
provides
the
so, my
law.
lord.
What is the law?
My lord, may I
You have
get
to
a
go by
copy?
the law. Where is the Contract Act provides? Show me the law. Whether the Financial Act provides this provision. Show me.
If the agreement provides so, my lord.
Show me.
My lord,
You could have been referred to this. You have executed this agreement. Where is the reference of the agreement in your letter? Show me the letter. He has executed any agreement with regard as a guarantor. He will kept the property in lien. Guarantor's property can be kept in lien.
then may I come back with those documents also in respect of the other loan account also, my lord, for which it has
I
been-
want only to the law if a person, borrower has cleared the loan amount and he is the guarantor of some other persons. Can that property or the document be kept in lien with regard to the guarantor?
Kindly keep
Show
it
me
to,
that.
kindly keep it tomorrow, my lord. I will come back with those
The-
supporting documents and that.
The only point, the counsel for the respondents prays for time, respondent bank
Yes.
prays for time to satisfy this court whether the property of the document which was kept in lien by the petitioner while borrowing the amount from the bank and the bank and the petitioner has paid the total loan amount, but the bank has not released the said property of the document to the petitioner on the ground that the petitioner is a guarantor with respect of some other persons. The counsel for the respondent prays for time to show the law whether the guarantor's property can be kept in lien, which was the property of the borrower, in which the borrower already cleared the loan. Let the matter appear.
My lord,
Let the
affidavit of
matter
service
appear
be
on
kept with
29
29.
July under the same heading.
29. Much of it.
My lord, affidavit of service be kept with the record. My lord.
Yes, yes. You are for the state.
My lord, I'm for the state, my lord.
No, state.
7 to 10.
Yeah, fine.
Yeah.
My lord, here, my lord, their terms have expired. My lord, they've served their sentences, my lord. So here the state government, my lord, has come up with, my lord, holding centers in various districts. So now, my lord, my lord will maybe pleased to, my lord, pass directions, my lord, upon the Home Department, my lord. They will shift them from the corrections.
No, they will shift. Then whether the civil authority was appointed, who will take the charge of the person?
My lord, the
There's
SP.
a notification, what I've been told of late, when I was deliberating on what has fallen from your lordship. Lordship will kindly allow us some time so that we can come up. SP is the civil authority.
Civil
I
authority.
have the
Under
notification,
FRRO, my
my
lord.
May I have a copy?
Yes.
One.
So,
Yes.
right.
My lord, it is with respect to, my lord, the immigrants who have not been arrested,
I'll
who
just
have been
indicate, my lord,
identified, and my lord.
third page, which is serial 70 at the top, my lord, point number 6. My lord, yes, point number 6. The foreigners regional registration officers and foreigners registration officers, who are generally the district SPs or DCPs, are the civil authorities under the Foreigners Order 1948, and they are also registering authorities under the Registration of Foreigners Rules 1992. My lord. As a civil authority, district SP or DCPs who are designated as FROs are responsible for implementing various provisions of the Foreigners Act 1946 and the Foreigners Order 1948. Where an FRO is not available, the FRO concerned may undertake these functions. Adequate powers are vested with the state governments, UT administrations, FROs.
No, but after the amendment of the
The new act.
New
My
act.
lord, now these people, my lord, had their incarcerations had happened under the earlier act. So, my lord, so this will follow, my lord.
Okay. So the procedure is that,
my lord,
if they have completed their tenure,
my lord,
then the jail authority has to inform to the civil authority.
my lord,
Correct.
my
Then
lord,
the civil authority will go to the jail,
my
and
lord,
they will take the custody
my lord,
of these foreign nations, and they will keep in the
holding centers.
holding house, and they will pass order restricting the movement of these persons for the time being till they have been deported to their own place.
Home countries, my lord. My lord,
So
because
civil authority, because this court cannot pass any order,
that is,
and
my
the jail authority cannot pass an order.
Yes.
Civil authority can pass an order for restricting their movement.
my lord, that is this is my lord, the central government, my lord, Ministry of Home Affairs came up with a manual, my lord, with respect to detention centers and all. But pursuant to that, my lord, these holding centers have come up in various districts.
That's why I told you.
Yes, my lord.
Because I came to know that.
Yes, my lord. The learned
With
is, yes,
regard to then the civil authority, you might have been holding house.
my lord.
So this person's, the jail authority has to release to whom it has to be released. Then the civil authority has to go to the correctional home, and
Identify
to take
them.
the custody,
Yes.
and to come to the holding house, and to make an order for their restriction movement. Because from 8 a.m. to 8 p.m.
My
there will be two roll call. There will be two roll call. In the morning hours, 8 a.m. there will be a roll call.
My
Then
lord.
they will allowed to go,
My lord.
and they will had to come by 8 p.m. Then there will be
These are more like open jails, my lord.
open jail.
More like open jails. My lord, in fact, we've
That
come
their
up.
movement, and the movement will be restricted to some village or whatever it is. So
My
they,
lord.
so they cannot go outside.
My lord, there'll be some radius orders of that kind. My lord, in fact, we've come a long way. Earlier, my lord, they used to be transported to Telangana, New Delhi.
That's one.
So that's,
yes.
my lord,
Actually,
thankfully,
her contention, they have to be deputed to the Delhi.
my
Because
lord.
there is no house
Yes,
there.
earlier there were orders passed by this, my lord. That was the situation. My lord, thankfully, my lord, we've crossed a long way. My lord, now with this,
It can be done. So you do one thing.
my lord.
I am keeping it after tomorrow or whatever it is. Tell the civil authority, then I'll pass an order. Then the jail authority will inform the civil authority, and civil authority has to take the custody. Next week.
If my lord kindly sees the guidelines of deportation, my lord, paragraph 7, my lord, that is with respect to, my lord, this guideline is with respect to, my lord, Rohingyas, Bangladeshis who are being apprehended, not who have already suffered their.
That's why I'm telling with regard to this. I am not telling the pushing back.
Yes.
They can be only deported. They cannot push back.
Yes,
They have to be deported with the consent of the ministry. Ministry will pass an order, and if it 20, 40, 30, whatever the persons will be there at a lot, then they will make necessary arrangement for deportation from India to Bangladesh or what.
Myanmar, my lord, Myanmar also has to accept that. That is the issue.
That's why the ministry is to involved.
Yes, your lord.
Ministry is to be involved. Like that. So this Indian government will consult with the Myanmar government, then they will agree, then they will be deported. This is the provision. What I don't know now, it has been changed or not, because I am not in criminal jurisdiction.
I've been informed that it is the same.
Yes, your lord. However, my lord, my instruction is that till date, my lord, there has been no
Okay, you do
deportation
one
to Myanmar.
Come, you
My lord,
see
union will be
civil
better
authority.
apprised.
Take instruction. I am keeping next week, next Tuesday. In the meantime, you may chalk out the program, how it has to be dealt with.
Because these are three districts primarily, North 24 Parganas, South 24 Parganas, and Howrah. These four matters pertain to these three districts. So, my lord, the concerned SPs, my lord, and within the commissionerate areas, it would be the DCPs, my lord. So,
you talk to them.
My lord, I spoke to the Home Department officials, my lord.
So
That's what they intimated.
So what they will fix, how it has to be.
The modality mechanism, my lord. My lord.
How they will.
Yes, because they cannot be kept in the holding center forever as well. Because if man
That's a second step.
That's why I clarified. They will keep in the holding center, but they can go, but movement will be restricted. To
Yes,
the,
No, it's not. My lord, it's not about their freedom, my lord. The question is them getting repatriated back to their countries. That is the ultimate objective. Because as illegal nationals, our country will not support them. Absolute, my lord. That is the stand of the government, my lord.
The Learned Council for the petitioner has submitted the guidelines dated 2nd May 2025, wherein it is that the foreigners regional registration officers within bracket FRROs and the foreigners registration officers within bracket FROs, who are generally the district SPs and DCPs, are the civil authorities under the Foreigners Orders 1948, and they are also the registering authorities under the Registration of Foreigners Rules 1992. In view of the above, the state is directed to take instructions from the civil authority and to frame the mechanism how these petitioners who are languishing in the correctional home in spite of completion of their imprisonment to be taken to the shelter and how they have to be repatriated to their own country. Let the instruction be taken within a week. This is the matter on 29th July.
7 to 10.
Under the same heading within 5 matters.
Great.
Come on that day, I will dispose of.
Yes,
on the basis of this, the guideline will be framed so that in future it can be.
Yes, in the future also it can be, my lord, because it's a tricky issue, my lord, because there are several jurisdictions.
Last 1 year, I am thinking that now it has come to conclusion.
Yes, my lord. My lord, now, my lord, I believe most matters we will, my lord, with the age also, my lord, we are also there. We'll try and, my lord.
Hope so.
My lord, we will try and, my lord,
Thank you,
that will be our endeavor, my lord.
Thank you.
I'm so grateful, my lord.
Yes, 15, 16, 15 हो जाते. None appears on behalf of the petitioners. No accommodation is sought for. Let the matter appear on 11th August. Next.
May it please, my lord. My lord, this is a writ petition against arbitrary termination of a tender. So I have filed, I think,
we have
an accommodation.
My lord will kindly appreciate, my lord, the affidavits have been exchanged from.
It's ready for hearing.
But my lord, I am in a difficulty.
But see the name also, and day also.
Yes, my lord will be kind enough to fix it on any day for hearing, whichever is suitable. Because pleadings are complete today, my lord. I'm slightly handicapped because I have reached, my lord, but my juniors are not there, and the affidavit of original which was to be submitted before your lordship is lying with my learned junior. So, my lord, on the next date, my lord, we will submit that affidavit. Otherwise, my lord may fix it up on any day which is suitable to your lordship.
Just a humble submission, my lord. What happened due to this illegal termination? I have been some way or the other, I had to pay the statutory cost. So being a startup, I have paid an enormous amount, but this account is not getting settled. So the last date was around 25th of October 2025. Ready for hearing any date this week, next week, my lord. I think subject to my learned senior friends' convenience.
It is submitted by the learned counsel for the parties that the pleadings have been completed and matter is ready for hearing.
My lord, just the affidavit on reply that has already been served, I would.
In reply filed by the petitioner,
That will be taken on record.
Full list of please the matter on. 4th August.
My lord, 4th August. I'm extremely sorry. 4th August, I am in Delhi. I'm sorry.
Then
4th
6th
August.
August.
Any date, any
6th
date.
August.
6th August is fine.
6th, no, wo the Lordship, 11th August will be suitable for your Lordship's diary.
11th August.
11th August,
Within
much
five,
obliged.
within 10 matters
Much obliged.
under the
I'm
same
grateful.
heading. Next.
Lordship, I am for the petitioner. I am unable to appear in the physical mode. I am praying for not this week.
Yes.
I am unable to appear in the physical mode. I am praying for not this week. Lordship.
For the petitioner case is adjourned, let the matter appear 7th August. Next.
Lord 19, my lord, I am appearing for the petitioner, my lord. My lord,
Not this week.
one more thing, my lord. My lord, the SDO's order is, my lord, illegible, my lord. So I'm praying, my lord, I want to file supplementary affidavit, my lord, in this regard, my lord.
Where is the order?
My lord, page 38, my lord. Annexure P6. The SDO's order, my lord.
No, it is readable, no problem. I can read.
But my lord, my copy is, my lord, illegible, my lord.
So you are the petitioner. You could have been keep the copy. You have filed this.
And my lord,
I know the tricky for taking adjournment. So
no, my lord,
I will give my brief to you. You read the order.
My lord, here, my lord, then your lordship, I can read the SDO.
Give the order, no problem. Or you want this a copy, then I will provide the copy.
My lord, then I can read.
You have a copy?
No, my lord, I have only.
You know, without briefing, you are appearing for the state.
I just got the police report, my lord.
What the police report? What the police will do? Challenge of the SDO order.
Yes.
Then what the police will do? Yes, what is the order? What is the grievance?
My lord, my grievance is, my lord, one SDO has passed an order.
Who are
my lord.
you?
My lord, I am the petitioner, my lord. I am the Rayat, my lord, of the property, my lord, along with my brother.
Property.
My lord.
Correct.
My lord, then, my lord, my.
Who was the complainant before the SDO?
My lord, my sister, my lord.
Your sister.
Yes.
What is the age of the sister?
My lord, sister, my lord, she is respondent number, my lord. My lord, you kindly takes, my lord. She is respondent number.
Under citizenship, the Senior Citizen Act.
My lord, Senior Citizen Act, section 23 of Senior Citizen, my lord, whereby, my lord, it says, my lord, that the SDO can, my lord, cancel the deed, my lord. So, your lordship, I am seeking that, my lord.
What?
If your lordship kindly comes to, my lord, the respondent number 5 is the, my lord, my sister, my lord.
He has made the complaint.
Yes, my lord. And
before the SDO.
Yes, my lord.
Then?
Your lordship will find, my lord, from, my lord, annexure P6, my lord.
Yes.
And my complaint is at page 31, my lord.
Your complaint?
Yes, my lord.
You have made a complaint?
Yes, my lord. Page 31 to the my lord SDO regarding my lord the grievance, my lord. If your lordship kindly.
Who has made the complaint before the SDO? Who has made the complaint before the SDO?
My lord, they have made the complaint before the SDO, my lord. The SDO has passed the order, my lord. And my lord, I have challenged the SDO's order, my lord.
You are telling that you made a complaint to the SDO.
My lord, I have made complaint to the police authority, my lord, along with SDO, my lord.
Who is the Dilip Kumar boss?
But Dilip Kumar Mitra is my brother, my lord.
And what is your name?
My lord, my name is my lord Shyamal Kumar Mitra.
So you and Dilip Kumar have purchased the property.
My lord, and my lord, the private respondent number 5 to 8 is torturing, my lord.
Just a minute. In Samuel petition executed the deed of settlement in favor of Namita Bose, Sandeep Sansuda. Who died?
My lord.
Who died?
My lord, died, my lord, my brother, my lord.
Brother,
Thereafter, my lord, I made an application, my lord. If your lordship kindly comes to, my lord, paragraph 14, my lord. My lord, the petitioner states that the said maintenance tribunal and SDO Sadar Hooghly failed to appreciate the specific case of the petitioner that he had been evicted from his own house, being a senior citizen by the private respondent, and the said order passed by the maintenance tribunal is required to be modified by directing the said maintenance tribunal to take all the necessary steps for restoration of the possession of the petitioner, and by allowing the petitioner to enter into his own property by police protection, my lord, and also directing the police authority to keep vigil over the matter so that the petitioner may live in his own peaceful possession, my lord. And after that, my lord, annexure, your lordship will find annexure P7, my lord, that is also illegible, my lord. It is a 144 order, my lord.
Respondent is directed to allow the petitioner, who is the elderly person, to live in the first of the property. And the aunt, who is also the elderly person, will continue to live on the ground floor of the same property. And both will jointly use the passage. The property let dispute, yes.
And my lord, if your lordship kindly comes to annexure P7, my lord, and paragraph 15, my lord, whereby they have filed one section 144, my lord, CRPC, my lord, and
where is the complaint? Who has made the complaint? Where is the complaint?
My lord, complaint, your lordship will find, my lord, annexure P5, my lord, page 31, my lord. My lord, it is in Bengali, my lord.
Then how this court can go through the complaint?
My lord, that's why, my lord, I was seeking, my lord, to file supplementary affidavit because,
What
my lord,
supplementary affidavit?
my lord, then translation could be done, my lord, and I will file that, my lord, and my lord, in that regard, my lord, in respect of
You are not able to submit before this court who is the complainant. So
my lord,
how
the
you translate
complainant,
the
my lord,
Bangla to the English?
complainant, my lord, is the Shamal Kumar Mitro, my lord.
Who is the Shamal Kumar Mitro?
My lord, the petitioner herein, my lord.
Ah.
My lord, he has filed, my lord, since, my lord, he was forcibly evicted from his property, my lord.
Who has evicted?
Being a senior, my lord, the sister, my lord.
To where you file the complaint?
My lord, complaint I filed before the police officer, my lord, officer in charge, my lord, and the, my lord, your lordship will find, my lord.
Sir, I am asking before the SDO, who was the complainant?
My lord, before the SDO, my lord, the private respondent has filed the, my lord, complaint, my lord.
That's what I'm asking.
My lord, that is, my lord.
Where is the reply to the complaint?
My lord, I have not replied to the complaint, my lord. The SDOs, I have challenged the SDO's order, my lord, whereby, my lord, SDO has passed the order, my lord, and my lord, Honorable Justice Tirthankar Ghosh has heard the matter, my lord. My lord, since, my lord, the determination was not there, my lord, as it was a police in action bench, my lord. So, your lordship, the matter was released, my lord, and the matter has been placed before your lordship, my lord.
That's why you satisfy this court.
Well,
you are agreeing with this?
I am only seeking one because, my lord, I am not having the physical, my lord, the copy, hard copy, my lord. So, your lordship, I am only praying for 1 week time. Your lordship may kindly grant, my lord, I file supplementary affidavit also, my lord, and I'll.
If you are not ready, why you mention the matter?
My lord,
why you mention the matter for urgent hearing?
My lord, since I
you mentioned the matter on 14th of June.
My lord, I have mentioned the matter, my lord.
Yes, you mentioned the matter.
But, my lord, my lord, I am not having the hard copy today, my lord. Your
The
lordship
matter is listed as urgent motion on the prayer made by the counsel for the petitioner by mentioning the matter. And as per the mentioning, this court has fixed the matter as item number 19. In the today's list. When the matter is called, the counsel for the petitioner prays for time. Let the matter go out of the list.
My lord, your lordship may kindly grant me, my lord, 1 week time, my lord. I will suffice your lordship, my lord.
Yes, who is for the 20?
May it please Lordship, Lord, I appear on behalf of the petitioner.
Yes.
Lord, complaints have been made regarding, my lord, premises not being fire compliant, my lord. And there are unauthorized constructions also in the said premises. And regarding unauthorized constructions, no fire clearance can even be granted.
Who are you?
I am, my lord, the lessee of the premises, the registered lessee. I hold a lease. And I have annexed it, my lord, at annexed P1 to the writ petition, 15th October 2020. There are certain other occupants who are there, my lord, in the premises. They are carrying on, my lord, activity without any fire clearance. Please come to page 91. Apropos certain complaints, my lord, the authorities of the fire did make a paper compliance, but after that, my lord, for reasons best known to them, they have not taken further action.
Lord,
91, in response to the memo under reference 1, written by the Director General to the Divisional Fire Officer, The undersigned has been directed to occur an inspection and submit report. Accordingly, OC Kamarati has inspected the site. Outcome of the inspection is depicted hereunder. Said premises is abutting from 30-meter BT road. In the said area, there are 8 numbers of buildings, so and so found, which are made of brick walling and RCC roofing, and also brick walling and tin roofing. The said building is used and running by different kinds of small-scale business entities by storing hazardous materials like garments, wooden blocks, plyboards, cartons, etc., without proper and valid fire safety certificate oblique FSR oblique FSL. Accordingly, the owner of the said business entities have been served notice under Section 35 for violating Section 11C and 12 of the West Bengal Fire Services Act 1950.
Lord, prior
with
to
up-to-date
going
amendments.
into the merits of the case, Lord, kindly allow me a few seconds to argue, Lord. Lord, the occupants in these writ petitions are the tenant under me, because Lord, I was the original lessee, and Lord, I constructed the building over the property. I had not been imputed as party here.
As far as my cause of action is concerned, my cause of action.
And Lord,
My cause of,
I made application for fire license. My license is pending, and Lord, kindly ask my learned friend to impute me as party, because I am the original lessee under the lessor, and all the occupants are under my tenant.
my learned friend wants my lord get impeded, Lord, I will not have to tell him what to do. So far as my cause of action is concerned, he does not appear in the scheme of case. I have taken a registered lease of the property in question as annexed. That gives me prima facie interest over the
From whom
property.
you have taken?
From the owner. From the
And
owner.
who are you?
Lord, I am the original lessee. I got the lease, Lord, in the year 1961.
Who's the owner? Hire someone, then tell me, Lord, I will also take a registered lease from you. As of now,
yes.
He is a suspicious maneuver to get rid of I don't know the occupier. Mr. Vishwarup Bhattacharya comes up today, does not say who is appearing for, and both of them are making submissions, Lord, on the basis of there's no application.
Who he has arrayed in
Yes.
his array of parties.
So whatever my humble submission was, that there is a finding of the fire safety authorities that 8 buildings are carrying on activities dehorse Section 35, and steps have been taken under 35. Those steps would include stoppage. The biggest thing is, my lord, in our fire safety problems, whenever a problem comes up regarding someone not having taken fire safety clearance under Section 11C, occupiers are bound. Under Section 12, they will serve as NOCs for various other acts, my lord knows. Now, whenever something is not done, the only thing that the fire authorities will do is initiate criminal proceedings and tell them to show cause. The biggest thing side by side which they should be doing, which is complained of in the writ petition, is to stop the activity. Today, my lord, if a fire breaks out, then my lord, can the fire authorities come in their fire engines and show them a show cause notice, and the fire will subside? That's the whole and the soul, my lord, of my problem. Now, I've written to the authorities. The authorities have said they have had an inspection. Not a single fire license has come till now. Page 92, my lord, if your lordship kindly has a look, the very next page.
Okay. Just to cut short the entire.
No, he's
Pages 72, 85, 91, 92 are documents regarding fire license. I am not taking this preliminary objection, all these documents are not served on Mr. Banerjee's client. They have also not been served on me.
Are these relevant today?
It has also not been served on me. But the entire writ petition has been affirmed as true to knowledge. Whatever. Let us take it, that he is, blessed with the blessings of the fire authority. Be that as it may, we have been served with this document, 18th May 2016. Okay,
2016.
I'm just giving you.
The appearing on behalf of whom?
Won't respondent.
Mr. Bhattacharya is appearing on behalf of one of the private respondents.
No, I am appearing for all the private.
All the private respondents?
I am appearing
Then
for.
fantastic. Great. No difficulty.
You are appealing for whom? 12 to?
12 to 19.
12 to 19.
Who are the sublessees under the lessee. First submission to your lordship is
To whom you are the tenant?
He,
Mr. Dalal.
my learned friends,
Yes.
whoever his client.
Whoever my client. Unfortunately, I have a registered deed of lease.
No, he's not you.
No, he's not. When he walked in, they walked in as a team. He allowed him to take first strike, and then he took a single and gave.
Mr. Banerjee's team, he never takes me.
Now the difficulty is not I am too small to afford the order. Mr. Bhattacharya.
So you do.
So
cut the matter short. You do one thing, go and enter the agreement, all the matter will be solved.
That is the whole, that is the whole reason. That is the whole reason. That is the whole reason. That is the whole reason Mr. Bhattacharya has come up. He wants to say that he owes his privity to a non-existent lessee. I am a registered leaseholder. He doesn't owe his privity. Forum is different. Today, rightly or wrongly, 12 to 17 or 19, they are carrying on activities. There is not a single fire license.
Okay, you do one thing, give the details, meet them as a party, serve the notice.
They know. I'll tell you, Lordship. And again, I will say, no.
Or you do one thing,
Let
you
him
file an
explain.
application,
Let
what
him
are the
explain.
documents you are relying upon, if the court.
Yes, we'll come back. Lord, this is slightly urgent. Could it remain slightly? He will file his application tomorrow. I'm sure he'll file his application tomorrow. Mr. Bhattacharya will help him. He has already drafted it. It's being settled.
No,
Namula, therefore,
don't put words in my mouth.
no, I am not putting words in your mouth.
How can I be everyone's lawyer like?
Mr. Bhattacharya is prolific. I'm
Do
sure
one
he'll
thing,
help.
all three sit together and prepare the application.
Ballot, I've got one ready. I've got one ready.
He's one of the Milan, dearest to me, Milan, by heart.
But by lungs, Ballot, I'm not dearest. Because Ballot, sometimes my lung power matches his.
Okay.
That is not.
Mr. Dulapati, London.
আমি মানুষ হয়েছি আমি মানুষ হইনি
Client is also one of.
সঙ্গে আবার একে দলপতি কে দিয়েছি
You are the lessee. Mr. Dulapati, you are of the lessee.
No, he alleged lessee.
His client is a lessee of the premises in question, and as such, he is the necessary party in the present writ application, but the petition has not made him the party in the present application. Accordingly, prays for time for taking steps for addition of parties. In view of the submission made by Dulapati, the case is that the intervener is granted liberty to file appropriate application within a week after serving the copy to the learned counsel for the petitioner. Let the matter appear on 30th July.
30th.
Under
Within
the
first
same
five.
heading.
Within first five ballot time. Within first five ballot time. I want to first five. Ballot, do not hear Mr. Bhattacharya.
At the top before the cost item.
Malad, I beg to appear for the municipality.
Within first 10 minutes. Obliged.
Malad, beg to appear for the municipality.
Grateful. Malad, I am extremely sorry. I made an oral mentioning today, my lord, for a matter. My lord appeared to have been annoyed. I'm extremely sorry.
Which one?
I don't know. There was an item number 101 where interim order is expiring today.
But I given that. It will listed as in the supplementary list.
No, that is another one. That is Mr. Lahiri's matter. I have given the slip yesterday. Yes, 101 is in the list.
So mention at the time rising, you mention it. I will do that.
I'll give the other side a notice. At the time of rising,
appearance.
Inform other side and come at the time rising. I will do
at the time of rising at 1:15 or
Three.
at
Three.
At 3. Obliged.
একটা মামলা তিনটা
I'm so sorry.
Yes, next.
My lord, kindly impose
Yes.
decibel limit on Mr. Bhattacharya.
Come with all application. We'll see.
Yes. My lord has understood the crux.
You are the crux. That's the whole problem.
You are my.
Yes, next.
I am for the petitioner.
Lordship, I am for the respondents.
This is a matter where the petitioners, my lord, both the petitioners, my lord, lost their child in the year 2025. The male child committed suicide. He was a doctor. Subsequently, they applied for the surrogacy treatment, IVF treatment. Now, what has happened? Practically, the age regarding the surrogacy regulation act 2021.
Both age over.
Age for
Both.
2 to 3 months.
Both.
Marginal. Now they applied and now kindly see the rejection. Kindly see the rejection which is at page 38 once. It is issued by the Ministry of Health, Deputy Secretary of the Ministry of Health, by saying kindly see paragraph number 3 once. Bottom.
Yes.
It may be noted that the eligibility criteria of availing surrogacy services was recommended by the Parliamentary Standing Committee on Health and Family Welfare after careful consideration. These restrictions are in place of prioritize the welfare of the child, ensuring that in fulfilling the couple desire to become parents and well-being of the unborn child is not compromised and also to ensure that the facility of surrogacy service is availed by only needy couple as a last resort.
Correct.
Now, my lord,
That is the object of the act
yes,
itself.
absolutely. Under exceptional situation, my lord, my client, the petitioner before your
No,
lordship.
whether you obtain report that in the
Yes, correct. I
fit-
filed
fit
the
to
supplementary.
go,
No, I filed the supplementary affidavit.
fit to go for the RT procedure at this stage.
Yes,
Have you obtained report?
yes.
Where is that?
Kindly see my supplementary affidavit, which is affirmed by the Dilip Kumar Ghosh, the petitioner number 1. And kindly see page 5 once. I attach all the reports. And the doctor specified that they can opt for IVF. Right side bottom.
Page 7.
Page 5, my lord. This portion, man. Page 5.
Bottom. Right.
Yes, right bottom.
Patient has got almost
no eggs in her overseas, but considering the blood and USG can opt
for IVF.
Yes.
When it is when it was? What is the date?
Date is
what is the date of the report?
20th October. This is the 20th October 2025.
Where you got?
Middle
Left side.
left side.
Middle.
29th October.
Yes.
When on that day, what was the age of this lady?
On the date of application, because we made the application, which is at page 34 of the 34
No,
of
on 29th October. What is the date of birth?
date of birth is Aadhaar card আছে। This is the date of birth of the petitioner number 1, 3rd March 1969.
No, this is why what of petition number
Why
2?
date of birth is 21st February 1975.
What is the name of the petition number 2?
Petition number 2 name. Reboti.
Yes, the report is of her only. The report is of her only.
Yes.
What was the age?
Age
50 years plus.
51.
What is the exact age?
At the time of filing the application, 50 years, 8 months, 17 days.
And as
wife. And the husband is 76 years, 8 months, 3 days.
76.
56.
What is your heavy act? What is the age under the 23?
Yes. Kindly see.
Sorry. 23 to 50 for the female, and male is 26 to 55.
23
to 55.
Where you are getting? Section.
According to Section 4, Roman 3, subsection C, Surrogacy Regulation Act of 2021.
The intending couple are married between itna.
Only consider the mercy.
Yes, yes.
The woman, the age of 26 years, not below the 55 years, 50 years.
50 years.
Yes, ma'am.
And at the time of application, 50 years, 8 months, 17 days.
50 years. And the man above the age of 21 and 55 years.
Yeah.
So he was 56.
56, admitted.
And of ladies,
Lady 50 years, 8 months, 17 days.
17. And husband,
Husband, 56 years, 8 months, 3 days. At the time of application for surrogacy, seeking permission.
and when this report, on the 29th October, what was her age?
29th October 25.
25. So what was her age on that day?
51.
Already over.
51. 51.
Lady. Yes.
Lordship, as per the rules, we have nothing to say regarding already. They have age barred now. Only Lordship can give a direction for the fresh medical report. They will file because they are coming on.
That's why. How soon you can get the fresh report?
They will give.
Week?
Yes. Within a week.
Come within a week.
Yes. Lordship.
Fresh report.
Yes.
If still they are able, then
If they are capable for that, there's no problem.
Grateful, mother. Grateful.
The petitioner has filed the presented application praying for a direction
I have gone through. He died, na? So that's very fortunate.
You have not made a prayer, only setting aside. Where is the prayer to allow to go for the IVF procedure?
We made an application
For the surrogacy.
that was rejected by the order.
You have to amend the prayer for setting
No,
aside.
B, prayer B.
Prayer for made a prayer with the direction. क्या बोला? Praying for allowing the petitioner to go for surrogacy after relaxation of the age of the petitioners in exceptional circumstances. Counsel for the petitioner submit that the petitioner number 1 is aged about 56 years, 8 months, 3 days, and petitioner number 2 is aged about 5 years, 50 years, 8 months, and 7 days. He has relied upon the report, a clinical report dated 29th of October 2025, wherein it was opined that the petition number 2 is fit to opt for IVF procedure. The report is of 29th of October 2025. Now we are on 21st of July 2026. Accordingly, the petitioner is directed to submit, to go for a further test and to ascertain whether still the petitioner number 2 is fit to go for the IVF procedure. Let the report be filed by way of supplementary affidavit within a week. List the matter on 31st of July under the same heading.
31st, I have some difficulty.
Under the matter on 5th of August 2020.
Same under same heading, within
the same heading within 15 matters.
Obliged, grateful.
Lots of good.
Next.
Lord, I appear on behalf of the petitioner in this matter. This is my affidavit of service. Well, a petitioner is engaged in construction business under the sole proprietorship, having long-standing association with CPWD for at least 25 to 30 years. Now, presently, he is a class 3 constructor. My lord, kindly come to page number 21 for once.
21?
Page number 21.
Yes.
he made an application for enlistment in all categories and classes. Kindly see class 2. From class 3, he wanted to become class 2 constructor. So he made an application online, class 2.
21 is the
Page 20.
application.
This is the application for enlistment in all categories and classes. Just below that, my lord, you would find class 2. Just below at the first row, at the top first row, class 2 at the middle, top.
Applicant name.
No, just class 2, my lord, page 21. Buildings and roads, just next to building and roads.
Yes, class 2.
Class 2, my lord, your lordship has. My lord, kindly come to page 22.
So you have made an application for upgradation of your.
Absolutely, my lord.
Great.
Kindly come to page 22, where there was absolutely technical reason I have come before your lordship. But kindly see at the bottom, his name is Mukul Majumdar, MAJUMDER, but due to inadvertence, his name has been typed as MAZUMDAR.
What is your actual correct name?
Actually,
Z or J?
J.
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 Yes, here is the J.
J just beneath the photo, but left hand side, kindly see the name
Z.
Z. This was due to inadvertence, my lord, this has happened. Now, my lord, kindly see page 25 also. The same. Page 25 also, your lordship will find the same inadvertence, my lord, that the name
Z.
Z has been done.
So actually your J.
J, my lord. Now what happened, my lord? JE. Yes, coming. Now, my lord, it will also appear from page 31. My GST registration also, it bears the actual J. JDER, Majumdar, page 31.
Yes.
Yes. Now, my lord, what happened? I received a letter at page 36. And my lord, that inadvertence was because of my previous PAN card. My previous PAN card, I have annexed also page 34. That was my previous PAN card. So the person who was applying for it, he had page 34. Your lordship will find that ZA. And the next page is my current PAN card. Then it has been rectified, but due to next.
What is the number of the PAN card?
My lord, next page 35, ADSPM
0839Q. ADS. Okay.
That your lordship will find. My lord, for that reason, this technical reason, my lord, kindly see page 36, the impugned order. Page 36. Kindly see the subject, application for enlistment in class 2 buildings and roads category. Your online application dated 3rd May 2024. Please refer to above mentioned application dated 3rd May 2024 for enlistment in class 2 buildings and roads category. The enlisting authority considered your application and noted that in response to this office letter dated 2nd July 2024, you have submitted sole proprietorship affidavit executed before notary public instead of first class magistrate, and name of the proprietor in annexure 1 is Mukul Majumdar, but in the other documents it is Mukul Majumdar. Even after editing online by the applicant, we did their letter dated 26th of July 2024, sufficient opportunity have already been given to applicant for rectification. Therefore, your enlistment application in class 5, that would be class 2. They have corrected it subsequently. That is the only reason, my lord, I was not allowed to.
Your application in class 5?
No, that is wrongly. Next page, they have corrected it. Corrigendum, kindly see the next page, corrigendum. They have given the corrigendum, my lord. That is the only reason, my lord, due to this name disturbance, my lord, it has happened. My lord, I made a representation that kindly allow me to make the.
No, they are telling that the sufficient opportunity was given to you or not. Rectify then.
I could not, because through the online I could not. I made an application before them. Then they again reconsidered. That is page 40. Page 40, my lord, kindly see.
Yes.
Subject, reconsideration of appeal for enlistment in class 2. Please refer to your letter dated 24th of March 2025 regarding above mentioned subject matter. It is requested to submit acknowledgement for reconsideration of enlistment application through CEMS portal as per para 7.8 of relevant CPWD enlistment rules. This issues with the approval of the chief engineer. I was, according to the letter, I was given, but my lord, I could not access the portal. Then and there, I wrote to them that the next page that I am not being able to access your CEMS portal, for which I could either next page, my lord, 22nd of April 2025. I informed them within 15 days that I could not access the portal. The second paragraph in this regard, I also kindly request to good office to consider providing me a chance by reopening the online portal or restriction to enable submission of any additional replies to the queries raised through the enlistment management system. Because I was not able to access the portal. It was not being able to, I was not able to correct the name. My lord, after that, my lord, I again made a representation. That's a copy I'm giving. This a representation. I made another representation. My humble prayer before your lordship is that, my lord, this is a very technical issue, my lord. I have presently also I'm working with CPWD at present also as class 3. But only this minor, my lord, this spelling mistake, my lord, I could not access. That is my humble prayer.
So why you're not submitting the fresh application?
No, I have to make the application. I cannot access it now. That is the difficulty. CEMS portal is not accessible for me.
Why?
I cannot. I tried. I cannot access.
Why?
Portal is not allowing me. That is the portal algorithm. It doesn't allow me to do it.
Why, Mr. Lai?
I'm ready to
correct. It is not a new application. He wants to correct the old one.
How it can be corrected? It is online.
No,
Once
no.
it's been uploaded.
So he
when you
has
have
to
taken
file
it-
a fresh application. That is
Cannot
what is written.
access.
That's why he's telling that there is no access.
Cannot
He has
access.
made a representation.
So we will dispose of this presentation
Can
and
you
allow
allow
him
me?
access.
Yes, that much.
If he makes a fresh application, we will allow him access. He wants to revive the old application. That cannot be done.
Yes.
That cannot be.
Yes,
That's
fresh
what I'm
application he can make.
telling. That's why you ask. So he's telling the fresh application is not getting the website access to the website.
Yes, we have said file a fresh application. They want to revive the old application.
Why it can't be once you decided?
Because and they have said what we are now changed to proprietorship to partnership. New things they have said.
What I took the instruction, but he's saying that if today he wants to go, it would be a fresh application regarding the new criteria. I have to get the application based on the previous criteria. Previous criteria are certain, enlisted criteria are there. This amount has to be done. This construction work is to be done. There are details, my lord. So if I want to do it now afresh, my lord, I may not.
Criteria is changed.
Criteria, I may not match that.
So what can be done?
My lord, the difficulty is, my lord, they had allowed for reopening, but I could not access it because portal did not allow me. That is why I have come before your lordship. But presently, I will not be able to reach.
That's why they will allow the portal, but the portal will be allowed with the new fresh, with the
fresh. I may not.
application. How once the application is rejected, once the application admittedly there is a discrepancies in the name.
Spelling mistake.
Correct.
Yes.
So discrepancies in the name and the authority have considered and dismissed, rejected your request.
And reconsidered and allowed me to make fresh.
Yes, fresh. So
No, not fresh, to access the application, not fresh. The authority.
how you can access online? How you can access?
Because they have allowed. Kindly see their page, my lord, page 40.
Yes.
No, they have said reconsideration of my appeal.
Regarding mentioned subject, it is requested to submit an acknowledgement for reconsideration of the enlistment
Yes.
application through the yes.
This is the reconsideration. Not fresh.
Means what? If he files the application, then only reconsideration, not a review.
No, they said regarding my first application, they allowed me for reconsideration. It is not
referred to
fresh.
Letter dated regarding the mentioned subject, it is requested to submit acknowledgement for reconsideration. Acknowledgement for reconsideration of what?
Of my first application.
How? That has been disposed of. How?
No.
See, once you file the application, that has been whatever rightly or wrongly disposed of. Then you find that yes, there is a dispute of either so then you have to file a fresh application. How the hold up, because that they have already taken a decision.
They had taken a decision. I made a representation. They considered it. Then said for reconsideration, they allowed me.
Correct.
After rejection, it has happened. So that for the reconsideration, it is not considered reconsideration regard with first application. That is why they're using the word reconsideration.
But where is the para 7.8?
Para 7.8, your lordship, kindly take this. No, kindly excuse me, there is a marking in this. Slight marking. Take a picture. Okay.
Yes. So what 7.8 the same. If the enlisting authority finds the applicant eligible for the enlistment, it shall be issued the enlistment through CMS portal only. That they are all.
Kindly read the next proviso.
The general application received so and so shall be processed as per the enlistment rule. Application received itna shall be processed as per the enlistment rule. Application received so and so shall be processed.
That 60 days. ব্যবহার করো না, সিভিটা ব্যবহার করো। এটি আসবে তো।
So
That is why, my lord,
application received on or after 23rd of July 2024 shall be processed enlistment rule 2024.
that is why 60 days time limit has been.
When you filed an application?
Application, my lord, I received this letter on 7th of
No,
April.
when you original filed the application?
Original filing, my lord, it is on originalটা কবে হয়েছিল, ডেটা তো থাকবে নিশ্চয়ই। 20 না না, ওটা তো আলাদা জিনিস, annexure. That is on
page 31. What is
2024
Huh?
10th of March.
Where you got the order date?
This date, yes, my lord, I'm giving. Just kindly give me a moment.
What is the date of the page 31?
3rd May 2024.
30th July.
30th July 2024.
Where from you got?
My lord, kindly come to page 21. 21. Top right hand corner. Initially submitted on 3rd May 2024. Application date 30th of July 2024. So, my lord, 60 days time limit has been given for reconsideration
Page
period.
21.
Page 21, right hand side top.
30th July 2024.
30th of July, my lord, that 60 days in 7.8 has been
No,
given
just
for.
30th July 2024.
Yes.
And the enlistment rule, if the application received on or after 23rd of July 2024, the process shall be enlisted 2024 rule. So you are 30th July 2024.
No, initially submitted on 3rd of May 2024. There are two initials, left hand side. Kindly see, initially submitted on 3rd May 2024.
Then application date?
Then 30th July. It initiated on 3rd May. Then application is 30th July. My lord, what I respectfully submit to your lordship, that 60 days time was given for reconsideration. I could not apply because the portal did not allow me. I tried to. Within 15 days, I lodged a complaint with them.
Sir,
yes.
Your application dated 30th. You initially submitted on what is the meaning of initially submitted on application? Why? What is the difference in this? You don't know. What is the difference in this? Initially submitted on an application date. How it can be? Before initiation, how before application, how the initiation date will come?
Possibly, my lord, certain documents are to be uploaded and finally the click is to be made on application.
Yes.
Possibly
So
that.
on that day when the application is complete in all respect, then it will be treated as an application. So that you completed the all documents on 30th of July.
Yes, after that they had taken the decision.
Correct. So
After-
30th July.
Yes,
So
my lord.
30th July, if it is taken into consideration, the 2024 rule will come into effect. Whether now the new rule has changed.
Not the rule has changed, the criteria. Criteria
Correct.
changes.
Any criteria has changed. Might be the rule,
Yes,
the
yes.
criteria might be changed in the rule itself.
No,
So now which rule is applicable now?
criteria is separately given. That he has to complete 3 crores of work in one.
Where is that?
Criteria, my lord, that is.
And what was the criteria in 2024? Show me.
May I just take instruction and come back on that? Because I need some technical instruction, my lord. I need to come back. Please take.
Ask your client is there.
Right. He says that there are certain criteria. আলাদা memo করে দিয়েছে তো? ওদের নাকি? ওটা বলছি না, নতুন যে ক্রাইটেরিয়া এটা এখানে নতুন কোনো রুলে এসছে। May I just come back, my lord, because
Not
technical.
counsel for the petition has filed the affidavit of service. It has been kept with the record. Counsel for the petition prays for time to take instruction. According cases adjourned. Let the matter appear on 6th August.
6th August, my lord, under the same heading, my lord.
Under the same heading.
Grateful, my lord.
Next.
Well, I'll satisfy your lordship on the requirement of this.
Next.
Great.
Wait, please.
My lord, I am appearing for the respondent note. I am appearing for the respondent note. My lord, before your lordship proceed with this matter further, my lord, this matter relates to foreign exchange. These are all 3 writ petitions. FERA, under FERA. They are basically they are challenging an adjudication under FERA. Now, my lord, this should identically go under group 4. revenue, because the appellate rule says that revenue determination includes foreign exchange. If your lordship kindly see this, একটু দেখান। The revenue, it is marked with the highlighter, my lord.
Revenue, income tax, sale tax, foreign exchange.
Foreign exchange is specifically mentioned under group revenue.
Oh, this thing. Group A.
No, group, that is my lord, the classification.
Revenue, it will go to revenue.
Yes. My lord, this is, my learned friend is referring to, my lord, the listing rules.
Yes.
My lord,
Where is that appellate? Yes, if it is coming under the revenue, how it will be for this court?
Not, if my lord just pleased to have the 226 rules of our court.
Yes.
But kindly have that.
ওই বইটাতে আছে, but after that.
Which one you want? This is the writ rules. Yeah. What do you want?
But this is the rules of 226.
Yes, I have gone through.
আমি আপনার বইটাতেই রেফার করি, কারণ আমার কাছে আর বই নেই।
If my lord is pleased to have rule 8B. Rule 8B, man.
Yes.
So lord, this is the under our writ rules, lord, the all petitions for the issuance of high court, high prerogative writs under Article 226 shall also contain particulars as detailed in the pro forma, being Schedule A to these rules, mentioning the group and head according to the classification list of different types of writ proceedings as specified in Schedule B to these rules. And we kindly have Schedule B. There, not group 4.
Matter relating to revenue, tax laws.
Lordship, now, my lord, as far as FERA of FEMA is concerned, lord, it does not concern revenue at all. Because lord, it's not a statute for taxation. Lord, it regulates dealings in foreign exchange as far as lord, the residents and non-residents are concerned. So lord, the previous writ petitions were also not filed, dealt with by the court taking up the residuary matters. In fact, lord, my learned friend had provided to me, lord, and I reminded him, lord, when this 2023 writ petition was moved, lord, he had sought for a clarification, lord, and the clarification was issued, lord, to the effect that where police is involved, then it goes to the residuary bench taking police matters, but other matters involving the enforcement directorate, they come before the residuary bench. So that is how the matters before, my lord. So this listing rules, lord, I do not know how far they will override the 226 rules. They have put their foreign exchange, but not foreign exchange is never revenue.
Group 4, what is relating to revenue and taxes, excluding the accessory assessments and so.
Assessment, reopening of assessment, stay of recovery, refund, declaration form, appeal revision, liability to pay tax, exemptions, deductions, classification of tariff items and entries, search and seizure, adjudication proceedings, levy and short levy of duties, miscellaneous. So this is the revenue law. Revenue and taxation law, not foreign exchange does not fall under this. And
yes.
Therefore, maybe clarification.
জজ সাহেব লাস্ট দিন একটা অর্ডারে ডিল করে দিয়েছেন। আফটার দ্যাট আমি এখানে যেটা রিলাই করেছি না, দিস ইজ এ জুডিশিয়াস অর্ডার, his lordship has held. So this will be held. So
my friend had provided me this, but I would not have access to this, but he provided me these documents from 2023.
But this is those administrative orders which your lordship has held. Already dealt with. In fact, my letter, this was my letter in 2023 I have referred to that judicial order also, the Manka Gambhir judgment. Your Lordship will find. And even after that, the clarification came from the then Honorable Chief Justice that this particular matter shall be dealt with by this bank. The others will follow the 2022 circular. Kindly see.
No, the distinction was between police and not
That
non-police.
is police and Indian.
That is, no, that was the, therefore not the
It was the first one, Your Lordship, looking into 2022. Your Lordship had the occasion to deal with that in our last matter, where Your Lordship has restored the matter. Clearly. Thereafter, again confusion came, then I gave this letter, including indicating the judgment passed in Menka Gambhir case. Thereafter, Your Lordship will find another clarification came. Sir,
Which one?
Well, a single page will be there. 15 June.
Reply to yes, 15 June.
15 June.
23.
Yes.
Total addresses so.
Last line.
WPS shall be heard by the honorable Sanction.
No, it's not specific to that matter. It's the principle behind this is that police and non-police. So enforcement directorate where police is involved will go before the other bench.
That is different.
That is the only question. Not,
Now here also
no
in
revenue.
2020.
Now he is raising the question with regard to the revenue.
But there's no. It's not a revenue.
What is the challenge here?
Well, they had
But I will-
earlier 5 writ petitions. Well, I'm sorry to interject. 5 writ petitions they have preferred on 5 different show cause notices. All were in Group 4 revenue matter.
No.
And yes, Group 4 revenue matters.
All Group 9. My
No,
language
no.
is not properly.
Appeal went before the mat was pending before the honorable bench taking Group 4. My lord. From classification I can show.
Appeal is there.
Is Group 4, my lord, kindly see. There are 5 matters actually. I'm just showing, my lord, one. The first one. There, 780.
This is the appeal that you have filed. What about the rate?
Sir, Group 4 এ যদি রিট না হয় Group 4 এ appeal হবে না. That it will continue.
My instructions are that writs were in Group 9.
And they have filed this return.
Yes, see, subcategory revenue, foreign exchange. May we kindly come to the second page?
Yes, got it.
Sir.
Group A, writ 1 matter, revenue, foreign exchange 5.
But the records of the writ petition, not what has been shown to me, Lord, it says Group 9.
It was heard under Group 9.
It was heard under Group 9.
Which one?
No, the 2016 matters which
Those writs.
my friend has appealed against those decisions. So
They filed the appeal before the Group 4.
it looks like that. No?
But the order passed.
The appeal was
Okay, you might be filed the 9, but whether the matter was taken by the Group 4 matter or Group 9 matter.
My lord, Group appeal will never go under Group 4 if it is an order coming from Group
Correct,
9.
9. That's why.
So these are the appeals I am showing you, Lord.
When this order, this writ petition was disposed of.
My lord, these writ petitions were disposed of in 2019.
2018.
18.
2018.
18.
Yes.
dated 14 July. Was appearing under Group 9.
And what those appeals were dismissed by the Honorable Division Bench taking
Group 9
residuary
matter.
appeals, Group 9 appeals.
We have the list.
We'll put it on.
But the case status shows Group 4.
But here this
Status shows revenue, my lord.
status shows revenue.
No,
Now then we have to see the order. Which court has passed the order? Fine in the writ petition.
Type it.
Which court has passed an order?
Page 354. 340 or 354.
The court orders, I believe, passed by Justice Arindam Sinha.
Justice Basak.
Justice Sinha.
Justice Sinha. Justice Sinha, then the Group 9 might
Group
be.
9.
And then
But Justice Sinha was taking Group 4 also at a brief period of time.
And well, there are
The date is to be seen.
November 2018.
with the two judgments, the
One is a 340.
Yes.
Is that?
yeah, so
340 is a 14th November 2018.
yeah, that's so therefore started in 2017 and in 2018, and the second writ petition, the judgment is at page 355. But that part we'll need to consult the list and then, because you're not able to answer it right away.
Yes.
Because the second order was judgment was of Justice, the Honorable Justice Shahidullah Munshi. His lordship never took
Group 4.
Never took
Never took.
Group 9 also not.
Because Group 4, in Group 4, Millard, my learned senior opposite is the stalwart there.
I have not moved anything to do with FERA in the revenue bench. I have not. So therefore, I'm surprised by this point being taken.
No,
of course, my learned friend had warned me 2-3 days in advance. That's why I have some preparation to be able to answer.
But I have moved a number of foreign exchange matters before Group 4. On different occasions. But in fact, in these matters also, initially I was under the impression that Group 9 will go. But when the maths were come to the question of restoration, we found that this was under Group Revenue. Then it struck my mind, and the department also saying that this was under Group 4, why this is under Group 9. Then I found from this classification list that the heading revenue includes foreign exchange.
I'll check up.
Can
we find a supply?
The counsel for the respondents raise the issue whether the writ petition filed by the petitioner will come under Group 9 or Group 4. According to counsel for the petitioner, prays for time to take to ascertain whether the matter will remain in the
A
Group 9
report
or
may be
Group
called. Well, just a suggestion. A report may be called from the registered appellate side. Maybe he will be at the better position to clarify. If your lordship so deem fit, I have no personality. If your lordship so deem fit, because on certain occasions we have found that because there was a initial APML,
the
original side or appellate
registrar listing is also directed to furnish report whether the writ petitions being WPA 19248 of 2023 with 17065 with 90024 of 2026 are the matter of Group 9 or Group 6. Please let the report be Group 4. Let the report be filed on 11th August.
Group 4.
No, my lord was pleased to ask them not to proceed with the hearing till tomorrow.
But I am not proceeding. I have given the words. I have communicated.
No, they have fixed the hearing on 29 July. His officer is not.
Not proceed.
I am not passing any order. Shall I record that?
Yes,
Can I direct the adjudicating authority not to proceed with the hearing on 29th.
Counsel for the petition submitted the adjudicating authority has issued the notice of hearing on 29th of July 2026. Accordingly, the adjudicating authority directed not to proceed with the matter till the next date of hearing.
My lord, so we'll have it on the 11th.
11th August.
I'm grateful.
Under the same heading within 10 matters. No, within 10 matters it will come. Let first ascertain, then I'll fix the date.
My lord, I'm grateful.
First ascertain it will be there, then I'll fix a date.
My lord has called for report from registered listing
Register and also
application
taken.
with respect to these particular 3 matters. Deeply obliged.
Candid, that my advocate has not yet reached, in course of this day, I will file the affidavit of service. It is ready, my lord.
Who is appearing?
Well, I have served, my lord, but the short point is involved, my lord. Kindly comes to page 51, my lord. This is a partnership deed. Reconstitution of the partnership deed has not been registered by the authority, in spite of the fact that I have filed the reconstitution deed, the requisite fees, everything. Page 50, my lord, this is the representation that I have made to them after filing of all these documents, my lord. a farm of 1967, my lord. Prior thereto reconstitution was done. Now, my lord, one partner has, my lord, Vidyapati Chatterjee retired from by way of so and so. Subsequently, on 19 remaining partners met and decided to accept that. A reconstitution deed of partnership was accordingly executed on so and so by and between the parties, and the requisite fees for such purpose was also deposited on so and so, along with a notice of intimation in provisions of the Partnership Act. Now, in spite of receiving of all this, my lord, now, my lord, kindly comes to page 49 once. This is the, my lord, intimation for the recording the changes in the constitution. And the page 48, my lord, is that deposit that we have made through challans, my lord. And prior document is, my lord, the reconstitution deed, which starts from page 37. So all the requisite formalities that has been complied by my client, my lord. But
Where is the reconstitution deed?
My lord, page 37, it starts with page 37, my lord.
2019.
19, my lord. Since then, my lord, they have not done. They have only said, my lord, we will do it, we will do it. But nothing has been done in 25.
You are there and they have not done.
No, they have not done, my lord. This is the reason, my lord.
Not imaginable.
This is the things, my lord. And not only that, now the problem is, my lord, he is doing business, my lord, last 50 years, my lord, of petroleum products. Now, my lord, this reconstitution deed is very necessary for the purpose of business. Now his business will be standstill unless and until it has been done, my lord. So, my lord, I am beseeched to his lordship, my lord, let them at least file a short report before his lordship, my lord.
But nobody.
But only thing what I is praying, my lord, this has been served not in course of the I will file the video service. Lordship only direct them, my lord. If required, I will serve again, my lord, to them, my lord.
That's correct. But if running by
GP, I will serve to the GP, my lord.
no purpose will be so.
Only thing, my lord, I will serve to the GP office. Let them file a report
Yes,
on
come,
the next
yes.
day. Okay?
You are appearing.
State to party ache.
You are appearing. Yes, give.
I will. No, state is party, my lord. One day register of farms is the number one, my lord. And 2 is state of West Bengal service to industry and commerce.
123 all are the states.
Yes, my lord.
Record an order. The so-and-so appearing for the state. Police shop. The petition is directed to serve the copy of the writ application along with the document to the London advocate appearing for the state. Police shop. The police shop. The state is directed to file report. Why the deed of reconstitution deed of partnership submitted by the petitioner on 29th of September 2019 has not been executed till date. Let the report be filed by 12th August 2026. Let the matter appear on 12th August 2026 under the same heading.
Some preference may be given because lordship understood the urgency matters.
Yes, next.
Hmm.
24, my lord, I appear for the petitioner, my lord. May I have my lord's leave to appear online? My lord, here, my lord had passed an interim order on 11 June 2026, restraining the respondent railways from taking steps to evict me forcibly from my premises, my lord. Thereafter, my lord had directed them to file an affidavit in opposition. No affidavit in opposition has been filed. Apart from that, my lord, while extending the interim order that was passed on 8 July 2026, I'm sorry. On 8 July 2026, my lord had passed an order directing the respondent railways to carry out a survey, my lord, at my plot, and my lord also to my lord directed the railways to file a report. My lord, no report, no copy of any report has been received by us.
That the demarcation was carried out at 3 p.m.
Yes, my lord. That day an inspection was carried out. A joint letter was signed, though, my lord, there were some discrepancies. We've objected to it. If they file the report, my lord, I don't know what they'll file, but they're trying to say that a portion of the railway land is being encroached upon, which is not the fact, my lord. I'm sorry.
What is the can one?
Well, can one has been disposed of, I believe. That's for extension. I'm being led by Mr. Shah, my lord. Shah.
Yesterday. What has happened?
Yes, my lord. Yesterday we mentioned the matter. Lordship has been pleased to extend the interim order till the 27th of the month. Now, my lord, pursuant to your lordship's direction, the demarcation exercise has been carried out. But, my lord, the respondent is yet to file a report pursuant to your lordship's direction. My lord, we were also praying that, my lord, along with the report, they be directed to, my lord, furnish their title deeds. Because, my lord, I have purchased the property by two deeds of 2006 and 2013.
So you have to produce the deed. How they will produce the
My
deed?
deeds are on record. I have annexed it to the writ petition. So, my lord, they are saying I'm trespasser. If they say that, they have to show what is the basis of their claim to the land.
None appears on behalf of the respondent authorities. No report is submitted. Full stop. By an order dated 20th July 2026, the interim order is already extended till
27th July, my lord.
27th July
Or 27th August, I beg your pardon, my lord.
27th?
27th August, lordship has been pleased to extend till, my lord, by yesterday's order.
Till 27th August 2026 or until further. Let the matter appear on 27th August under the same heading.
My lord, we also kindly consider directing them to furnish the title deeds because otherwise, my lord, the
Nobody is there. If they will come, then I will do that. Next.
Item 25, my lord, I am for the petitioner. My lord was kind enough to pass an interim order on the last occasion. Look, I will be seeking, my lord, extension of the interim order since no affidavit has yet been filed.
Yes. Can be done.
But kindly come. No, let them file an affidavit. Your lordship had considered pass an interim order, which is too hard on affidavit.
He's coming. He's coming.
Coming, man.
Look at General is coming. You will argue them.
Let me open then. So kindly come to. I'm led by Mr. Bhattacharya with his leave.
Very well. Let Mr. Basu argue, but I have a bigger aspect now than I shall argue. Let them first finish it.
Kindly come to the order impugned. First of all, kindly come to the original lease, page 34. This is the lease. Kindly come to clause 7, page 36.
Yes.
Clause 7. The lessee shall not subdivide or sublet the premised land.
Just a minute. Not kindly, Shaptangshu, for a second, that kindly keep in mind that this is a newspaper and a newspaper running depends on the revenue, which cannot be curtailed. That is the basic principle set by the Supreme Court. Now the factual aspect, Mr. Basu takes it.
That is the clause, my lord, clause 7. It says that you cannot transfer, subdivide without permission. So transfer is altogether not prohibited. Only on the basis of, my lord, the permission. Then, my lord, kindly come to clause clause at page 39, 4 subclause. The resumption clause. Provided, nevertheless, the lessor shall not exercise the right without serving the lessee a notice in writing, giving 6 months' time to remedy the breach. Take your breath. Boso, Baba, boso. Remedy the breach. My lord, we have applied, is going on. Now, my lord, now the last order which has been challenged before my lord is page 184. Second volume.
Yes.
Can you allow me to read with my request for submission of documents in connection with the proposal for renting out by the lessee Bartaman Magazine Private Limited in respect of units 1 on the 5th floor of the building in favor of Aditya Birla Sun Life Insurance, 2 on the 4th floor of the building in favor of Concord Diagnostic Center, and on 7th floor of the building in favor of Luminia Health Center constructed at DK such and such. The proposal was going on. Then, with reference to subject noted above,
I am directed to request you to kindly take necessary action as detailed below for consideration of your proposal. To cancel the lease agreement executed on 16th day of November 2023 between the Bardhaman Magazine Private Limited and Aditya Birla Sun Life, and to submit a copy of the tenancy agreement. Can you mark that? Tenancy agreement between Bardhaman Magazine Private Limited and Aditya Birla Sun Life Insurance Company Limited to this department. This is the only ground. My lord, kindly recall, my lord, what should I say? Kindly recall section 7. A document. Possible.
Nowadays, book is not required.
So my lord has memory, I don't have. So 5.
আছে কি book আছে?
Probably my lord don't have this copy of this book because it's not a civil court. Must not be there. Lord, kindly test 105, 106 and 107. A lease agreement.
Yes.
If it is not registered, admittedly it is not registered. If it is not registered, which is compulsory registrable, can be termed as a tenancy agreement.
Tenancy, month by month.
What is the, my lord, the ground here? That you converted lease agreement to a tenancy agreement, admittedly what is not a registered agreement. Can this be a ground for well, recalling the so permission and resumption? And that too, under the lease agreement, 6 months time is to be given for remedy the breach. And kindly see what is the date of this order.
Yes.
Can you see the order or date of the order? 9th April.
9th April 25.
This is the order. And my lord, the last one is the order which is now challenged before my lord is at page 208. That is on 7th July 2026. On the same line.
Notice to vacate.
Notice to vacate. Kindly come to page 209.
Under the purported lease is charged.
First, second, third, fourth, fifth line.
It was also
6 lakh, but kindly read this. 6,39,200 per month. Kindly mark that. So it is a monthly tenancy. Whatever may be the nomenclature written there cannot be a lease agreement. It is also found that the registration process was not completed after execution of the lease agreement. So, my lord, it's a tenancy agreement. They are not objecting to the tenancy agreement. They are saying you cannot grant lease. I am not granting lease.
Yes.
Then, my lord, they said by their letter number such and such, Bardhaman, this was again not accepted in the department and they were again asked to submit tenancy agreement in cancellation of the lease agreement. However, no response regarding the said unit has been received from the lessee till date. Subsequently, fresh field inquiry was done, and on 5th floor there is an entity of Aditya Birla Group without approval from the department, which suggests that the lease did not pay any heed to the said objection from the department. Objection is lease or tenancy. This tantamounts to violation of lease clause, as in the principal original lease deed, wherein it is clearly mentioned that the lessee shall not subdivide or sublet demise the land without consent of the department, and in case of any breach of such terms and conditions, the lessor shall have the right to re-enter into possession. The remedy of such breach of terms and conditions also does not seem possible, as the lessee has already charged and collected lease rent monthly since the occupancy from the occupant, and hence accordingly 6 months time to cause any remedy does not seem viable. On that ground, they will even not give the 6 months benefit to resume the property. So, my lord, my submission is what Mr. Bhattacharya will add anything on. So far as legal submission is concerned, they are objecting that you cannot execute a lease deed. You make a tenancy agreement. That is the I repeat.
No.
Now he is too busy, so he may not have time to read it. Let me read it in his presence. This was again not accepted in the department, and they were again asked to submit tenancy agreement at page 209.
Yes.
So, according to me, this is the tenancy agreement, a document, month by month rent stipulated and non-registered.
Yes.
So in my humble submission, this is this tenancy agreement which you required. You are asked for that. This is tenancy agreement. We accept it and grant the permission.
Yes.
Because আর কিছু বলার থাকলে বলো।
Well, kindly come to me that the show cause notice at page 195. This is in addition to Mr. Basu's submission.
Yes.
I kindly come to the third paragraph. Recent field inquiry was held on 20th of June by the Salt Lake so-and-so. It transpired that activity of printing press is going on. It's admitted that this was given for the purpose of facilitating the running of a press. I will come to the bigger aspect later. Also, it is seen that despite getting working capital loan by mortgaging the leasehold interest of the government plot, the lessee has been found to use the property for other purpose and in the name of other entities. Utilization of rupees 17 crore and so by mortgaging the leasehold property. This was long back. Then kindly come to Milord, next paragraph. Also, Bartaman magazine made a proposal. This is important. For renting out SBUA of so square feet and SBUA, the float of the building of the said plot in favor of Concord Diagnostic Center and Lumina Health. A demand notice with an amount of rupees was issued, and it was mentioned that lessee has to deposit the demanded amount within 30 days from the date of issue of the said letter. The lessee failed to deposit the amount within stipulated period even after receiving a reminder from the department, and after a long gap, they informed the department that the tenants would have vacated the units as the rent agreement had been terminated. From this, it is clear that the said units were for some time occupied unauthorizedly without approval from the department. According to clause 2.7, then, lessee has made another proposal. Therefore, this is not that we are doing it behind their back. For renting out of the unit of 5th floor in favor of Aditya Birla, it is found from the document that one lease agreement was executed on 16 December 2023 between Bartaman and the Aditya Birla without consent of this department. This act was done in 2023. The lessee was asked to cancel the said lease agreement and to submit a tenancy agreement. Therefore, their proposal was you better give a tenancy agreement. If any, as no lease or sublease was at all possible by the lessee himself as claimed by him. It is seen that the lessee had failed to furnish any satisfactory reply so. It is found from the departmental inquiry conducted on 20th June that one entity, Aditya Birla, is running their activity on the 5th floor building unauthorizedly in terms of so. Now, therefore, you are directed to remedy the breach within 3 days. Therefore, they also know that this can be remedied. Next page 197, within 3 days. Now, why this was triggered off? That is very important. Now, immediately I reply to the show cause at next page. This is important.
Yes.
We have received your aforesaid notice through email at about 19:46 p.m. when our general office is closed. We have gone through your aforesaid notice and noted the contents therein. It is to be noted that you did not attach the property of field inspection held and so. By the said notice, we have asked ourselves to reply within 3 days from the date of 23rd June. It is not possible as to comply. Then I am writing this letter to you without prejudice to our right in our leasehold property. The next is important, my lord. I again, my lord, reply to them. The several letters on the very same date is issued. And kindly come to my lord, page 203. Has my got it?
Yes.
In continuation of our letter dated 24th June, we state that your purported letter of show cause is based on misconception of facts, the details of which has been placed by Mr. Basu. We have every reason to believe that this was triggered because of a news report published in the Bartaman newspaper on 19th of June 2026 pertaining to Yoga Divas. On the same day at around 9 p.m., a telephone call was received from your office claiming to be from an official of the UD. Immediately thereafter, on the following day, at approximately 11 a.m., a purported inspection was carried out and the person refused to disclose their names. Since the entire thing is based on malafidis, I would request you to withdraw this. Now, this is the action of a government. I'm definitely alleging this is the outcome of a news report which was not palatable to them. Otherwise, at 9 o'clock in the evening, the government office is not functioning. And then next day, 11 morning at the 11 o'clock, the inspection was carried out. And this ultimately the threat letter comes at page 208. And they say within 5 days you have to remedy the defect. What is the defect? Fundamentally, my lord, there is only technical aberration, nothing else. Mr. Basu has explained under the Transport of Property Act. This is virtually a, my lord, tenancy agreement. Maybe in the term as lease, but lease agreement was not registered, and unregistered agreement, lord, is no agreement in the eye of law. Therefore, this should be treated as tenancy. And if this resource is, my lord, curtailed, that would really affect, my lord, the running of the newspaper, which has been repeatedly deprecated by the Supreme Court.
Yes.
Even in our High Court, not in case of Ganashakti, when the advertisement by the government was stopped, the court was pleased to strike it down, that you cannot any action which will ultimately affect the running of the newspapers. Well, the prima facie, you have a case. Lordship was kind enough to pass an interim order. Well, I would request before the Lordship an appeal to you, my lord, extend the interim order. And if they want to use an affidavit, let them file an affidavit. Then the matter be thrashed out on merit.
Yes.
Before he starts, my lord, kindly, it is 2016 9 Supreme Court cases 268. On the proposition I have argued, my lord, Supreme Court has, you have a habit of showing judgment instead of tattoo. Paragraph 17 and last paragraph of 19.
Page?
268. Just above 20. Just above 20, paragraph 20. Thus, in the absence of registration of a document, what is deemed to be created as month-to-month tenancy.
Yes.
Lord, may I have minus candy?
Yes.
The civil court should be closed down. Civil courts. This is a contractual dispute. What are they, my lord? If I may ask myself the question, what are they trying to enforce? They are trying to enforce their right under the contract. Nothing further. For a moment, I do not say, my lord, that even in contractual matters, a writ does not lie. But under, my lord, very few circumstances, my lord, a writ lies, my lord, in a contractual dispute. And it is not one of them. It is not, my lord, that, my lord, the lessor has acted arbitrarily or whimsically.
Yes.
So, my lord, the writ in my respectful submission, the remedy lies in the civil court.
Yes.
Now, coming to the merits, my lord, kindly, may I show, my lord, some paragraphs, my lord, kindly come to, my lord, paragraph 6, page 4 onwards, my lord. My lord, it speaks of the lease deed, registered lease deed granted by the government in favor of the petitioner before your lordship on 25th November 1991. Paragraph 6, my lord.
Yes. Yes.
Now, my lord, kindly come to that document, my lord, which is, my lord, at page 34. "25th November, my lord, 1991. Kindly come to the second paragraph. The first recital. Whereas the lessee has applied to the government of West Bengal for a lease of the land sanctioned and described in the schedule hereunder written. Kindly take note of the next part. To enable the lessee to erect a house and building thereon for use for setting up a modern place, and the governor has agreed to grant a lease in favor of the lessee for the period and on the terms and conditions hereinafter appearing. So building would be constructed for setting up a press, nothing else. That was the object of the lease. Then, my lord, kindly come to page 36. Clause 7.
Yes.
The lessee shall not subdivide or sublet the demised land or the building to be constructed without the consent in writing of the government first had and obtained. And the government shall have the right and be entitled to refuse its consent at its absolute discretion.
Yes.
Then kindly come to the next clause. The lessee shall not assign or transfer the demised land or any part of the demised land and of the structure erected thereon without the previous permission of the government in writing. In case of transfer or assignment of the lease, the lessor shall have the right of preemption, and upon the exercise of this right, the building constructed by the lessee on the land shall be taken over by the lessor at a valuation of the building made by the lessor on the basis of the cost of construction, etc. Then, my lord, kindly come to next page. Clause 9. Not to use, Lordship got it?
Yes.
Not to use, clause 9, my lord. Not to use or allow to be used the land and of the structure thereon or any part thereof for any purpose other than for the purpose stated above without the prior permission in writing of the government or other authorities prescribed in that behalf. Very specific, registered document, clauses are binding on parties. Then, my lord, kindly come to directly, my lord, page 9.
Page 9 of the writ petition.
Yes, my lord, of the petition. Paragraph 23.
Yes. Yes.
Your petitioners state that your petitioners, একটাই তো petitioner নাকি? Your petitioners wrote a letter dated 18th August 2022 to the Additional Secretary to the Government of West Bengal, Urban so-and-so, for, kindly take note, for seeking permission for renting out third floor of the G+10-storied building to Max Light Insurance Company Limited. Now, my lord, if I read this paragraph, my lord, I got the impression that, my lord, they wrote a letter seeking permission that allow me to let out in terms of the lease deed.
Yes.
The lease deed provides that to sublet or to let out, you have to obtain prior permission.
In writing.
Now, yes, in writing. Kindly come to page 88.
Yes.
This is the letter they have referred to, P16. Dear sir, etc., please refer to your email dated such and such. Attaching a checklist for renting out a portion of our premises situated in this connection. Please note that Max Life Insurance has approached her for renting out a portion
Court
of...
is not audible. Yes, now. Now, my lord was pleased to pass an order when the government pleader was present on his assurance, thereafter they have left
Yes, sir.
kindly restrain
please-
them from doing anything further. That was ordered by the court.
Nobody is there. Better
এটা
than
কি এ
junior
করুন
is not
দেন
there.
বিকাশ
Yes.
তাকে মিউট করা যায় তো হচ্ছে না হ্যাঁ মিউট করে দিন
Yes,
তাহলেই হবে sorry now in this connection we are attaching the following documents for your kind perusal.
Yes.
Lease deed entered into between Bortoman and Max Life, not to be entered into. Certificate of incorporation of the tenant company,
Yes.
etc. Now kindly turn the page. Kindly come to my lord, page 90.
Yes.
Lease deed. The indenture of lease is signed on this 8th March 2022. 8th March 2022. Kindly come back to page 16. Later is 18th August 2022.
Yes.
So by that time, the document
Already
was
entered.
executed, the property was let out. My lord, there is no difficulty between a lease and a tenancy. Tenancy, my lord, if it is covered by the Premises Tenancy Act, it becomes a monthly tenancy under Premises Tenancy Act. There can also be a lease under the Transfer of Property Act. That is also a monthly tenancy if it is not covered by the
Register.
Premises Tenancy Act. That is, again, my lord, for both the cases, it is a tenancy. Then, my lord, kindly come back to, so this was the letter they wrote after letting out. They let it out, then they inform that we have let out, give us permission. Then kindly come to, my lord, paragraph 24, page 9.
Yes.
Your petitioner states that the additional secretary, Government of West Bengal Urban Development such and such department with a letter dated 6 January 2025 raised a bill for a sum of rupees such and such for permission for renting out in favor of Max Life, should be Life, whatever it is.
Max Life. Max Life.
Yes, Insurance Company Limited. So, my lord, they still allowed. Then, my lord, kindly come to paragraph 27 on the next page.
Yes.
Paragraph 27. Your petitioner states that your petitioner with the email letter dated 13 January 2025 addressed to the additional secretary to the Government of West Bengal so-and-so department seeking no objection for renting out 5th floor of the building in favor of Aditya Birla Sun Life Insurance and submitted a copy of a lease deed dated 16th November 2023. My lord, contracts are entered into to be, my lord, complied with. My lord, government gave the land. Lordship is aware, my lord, that these lands are not allowed at the market rate. You carry on business in your entire property for, my lord, running a press, permission was granted. It also said that you obtain a prior permission if it has to be let out. Now, that was not being done consistently. Not, my lord, one single instance. First, I have shown 2022, then, my lord, 2025, later, after 3 years.
Correct.
Or 2 years. 2023, they write in 2025, give us permission. Now, kindly, my lord, kindly come to page 124, the document. Sorry, the mail, my lord. Towards the middle, lordship will find to the additional secretary, etc. Subject document for renting out 5th floor of the building in favor of Birla Sun Life Insurance Company. Then kindly come to, my lord, serial number 6, lease deed.
Yes.
And my lord, the deed is, my lord, at page 126. November 2023. Kindly turn the page. Page 127. First recital. What is the representation made?
Page.
Page 127. Second page of that document.
Yes.
What is the representation? First recital at the bottom. Whereas A.
Absolute owner.
Absolute owner. Kindly turn the page. Kindly turn the page. Now this agreement witnesseth, and it is hereby agreed by and between the parties hereto as follows. Grant of lease and period. In consideration of the lease rent hereinafter defined, the lessor hereby grants the and leases the said leased premises in favor of the lessee. Specific bar.
Yes.
Then, my lord, kindly come to paragraph 28. Page 11, I'm sorry, my lord. Petition, my lord.
Yes.
Your petitioner state, paragraph 28, my lord, page 11. Your petitioner states that the Additional Secretary Government of West Bengal Urban Development and Municipal Affairs Department, with a letter dated 25th February 2025, sought for clarification regarding proposal for renting out of 5th floor of the building. And your petitioner, with a letter dated 10th March 25, clarified the questionnaire. Then 29. Your petitioner states that the Additional Secretary Government of West Bengal Urban Development Municipal Affairs Department, with a letter dated 9th April 25, asked your petitioner to submit the tenancy agreement in place of lease agreement for consideration of the proposal. Because, my lord, they said it's, my lord, they are the owner. Then, my lord, kindly once come to page 154, my lord, this document. No,
Yes.
sorry. 22. It's not required. I have
Request for submission of document.
yes, submission of documents. Then, my lord, kindly come to next pair, paragraph 30, page 11. Your petition, sorry, my lord.
Yes.
Your petitioner state that your petitioner, with the email dated 13 January 2025, addressed to the Additional Secretary Government of West Bengal Urban Development Department, seeking no objection in connection with renting out 4th floor, and submitted a leave and license agreement dated 10th January 2025 between Bortoman Magazine Limited and Concord.
Yes.
Again, subsequent. 13th January, they write.
The third one.
Third one. This is, my lord, at page 155.
Yes.
The letter, document for renting out 4th floor of the building situated at such and such to Concord Diagnostic Center.
Yes.
Then, my lord, documents are annexed, leave and license agreement. Kindly turn the page, page 156, document dated 10th January. Property has been parted with.
Yes.
Without the prior permission. Now, my lord, kindly once come to paragraph 32. May I read out, my lord? May I read out?
No problem. Please let me. No problem.
Page 12, paragraph 32.
I thought not this is prima facie satisfaction for passing into one, and advocate has taken the trouble, my lord, as if the matter is being argued on at length on merit. No, I have the difficulty. Then my lord, I would have to be given chance, my lord, to go through the detail of the petitions, reading paragraph wise, then citing authorities. This is only for the purpose of, with due respect to my lord, client advocate general.
AG is trying to establish a prima facie case.
Yes, my lord, so much of time by lord advocate general, prima facie case proves it's a prima facie case.
অন্য কোর্টে মামলা করার সময় এটার কে মিউট করবেন, আমরা সব শুনে ফেলেছি অন্য কোর্টে কি বলছিলেন। Sorry.
Yes. Page 31.
32. Paragraph 12. Your petitioner states that the Additional Secretary, Government of West Bengal Urban Development and Municipal Department, video its letter dated 9th April 25, asked your petitioner to submit an undertaking in the form of affidavit. Yes. Now kindly come to page 184. Page 184, my lord, first part possibly was placed before your lordship, that tenancy agreement, lease agreement, etc. Then part 2. Second verse, Roman 2. To submit an undertaking in the form of an affidavit in respect of Concord Diagnostic Center and Lumina Health Center, declaring that all the requisite formalities under so and so Act, etc., has obtained license from the competent authority to start such business, as well as following all rules, etc. Now, this was the letter. Then, my lord, kindly come to my lord next page. Sorry, page 13. Page 13, my lord, paragraph 34.
Yes. Yes, 34.
Your petitioner states that thereafter your petitioner received a demand notice dated 23rd July 2025 from the Office of the Urban Development Department for a sum of rupees such and such for renting out of the office premises in favor of Concord Diagnostic and Lumina Healthcare Services, which they had already done without prior permission. Well, this is at page 190. I am not placing it. Then paragraph 35. Your petitioner states that thereafter your petitioner received reminder letter dated 16 September 2025 from the Urban Development Department, and your petitioner replied to the said reminder with a letter dated 14th March 2026, after 6 months, informing that the aforesaid two tenants, namely Concord Diagnostic and Lumina, vacated the tenancy on 15th March. Money not paid. And my lord, they seek indulgence from the court. They would merrily go on, my lord, earning from the property which they were not entitled to under the lease deed. When money is demanded, that is not done. Then, my lord, kindly come to paragraph 36. Thereafter, your petitioner received a show cause notice dated 23rd June 2026 bearing memo number such and such from the UDIMA department. And by the said letter, your petitioner was asked to remedy the breach caused by violation of the terms and conditions of the lease deed dated within 3 days from the date of issuance of this notice. And if the lessee fails and neglects to remedy the breach within the stipulated period, the aforesaid lease granted by the government in respect of plot number such and such shall stand determined and government will re-enter. Now, my lord, lordship is aware, my lord, that a notice, my lord, giving a shorter time, but not taking any step, my lord, in the meantime, my lord, is a valid notice.
Why 3 days notice was given?
They say, my lord, 3 days notice was given.
Why? Why 3 days notice was given?
But no step was taken within that time. Nothing was done.
Okay.
Now, my lord, as I have, my lord, when I started making my submission, my lord, my submission was, my lord, they are trying to enforce their contractual right.
Yes.
And, my lord, for that a civil suit lies. There, my lord, they can obtain an order of injunction. And today, my lord, the order which has been passed, my lord, I cannot file a suit even.
Correct.
Now, my lord, I would humbly submit, my lord, that in these facts, my lord, the writ petition is not maintainable, is liable to be, my lord, dismissed summarily. In any event, my lord, if your lordship still thinks, my lord, that an affidavit is, my lord, required or called for, my lord, in this facts, now, my lord, in that event, my lord, kindly, my lord, modify the interim order to the extent that I shall be entitled to, my lord, take steps
In accordance with.
in accordance with law. And, my lord, they shall go on depositing, my lord, the money, my lord, which, my lord, they are realizing from the property, which they were not entitled to. Let it be deposited in court till, my lord, an order is passed by this court. My lord, those are my respectful submissions.
Yes, Mr. Bhattacharya.
Again, I say with deepest of respect, my lord, learned advocate general has proved this, lengthy submission that there is a prima facie case on which court should enter into. And my basic allegation is, my lord, this is a malafide attempt. I have specifically pleaded to ensure that this newspaper cannot, my lord, go on reporting freely. And on this aspect, my lord, the favorable Supreme Court judgments are there. I am not citing it now. My lord, this action, my lord, would be bad, expressing. There, my lord, the question of, my lord, jurisdiction lies. The latest judgment which was delivered by our court, my lord, in respect of Ganashakti, where the government, my lord, refused to give them advertisement. And the plea was, this is my prerogative. The court has said no. Following the Supreme Court judgment starting from Indian Express matter, Beckett and Coleman, that anything which ultimately affects the running of the newspaper would interfere with the freedom of press. And these earnings are, my lord, not for private gain. These earnings are, my lord, for the purpose of running the press. My lord, there is no allegation that you are making unlawful gain from this. Let that allegation come, we shall show with documents. That's why, my lord, depart from time to time says, remedy the defect, remedy the defect. Now suddenly, my lord, because of a reporting 3 days time, my lord, it calls for my lord's intervention and my lord, hearing at length. I am prepared with the authorities. If your lordship wants me to place it now, I can place it now.
What is the authority? Give the citation.
Let's starting from Shokal Press, starting from AN 1962 Supreme Court, followed in Bellet Coleman and Hindustan Times. Reference go to pore di dichi. And the latest one, my lord, is of Ganashakti, which had considered all these, my lord, reportings of the Honorable Supreme Court and came to a finding that is reported in 2015, Volume 4, Calcutta High Court Notes, page 497. My lord, which had really considered all the authorities.
Calcutta High Court Notes, page?
Page 497.
Yes.
Well, since we are at the interim stage, my lord, I don't really trouble my lord with the detailed argument.
But Mr. Bhattacharya, once as per the agreement, you have to take the consent in writing, and you before that you have entered into an agreement, and subsequently you have asked for the permission in writing.
My lord, these were the breaches which were, my lord, really condoned. The government, my lord, did not take any action on that point at that point of time. Therefore, the actions were condoned, and they said remedy the breaches. My lord, the breaches has to be remedied. We are willing to remedy the breaches. And with the latest one, I had applied before them, my lord, for permission, which land advocate general very truthfully placed. The application was pending before them. Not that I am doing, my lord, behind their back. My lord will find, my lord, my application for letting out to Aditya Birla is at page 124.
Yes.
It's not that case that we are doing it behind their back with any ill motive. And this application was kept pending since January 13, 2025. And repeatedly we are urging them, kindly grant it. They say, don't go for lease agreement, go for monthly tenancy. And not what we have entered into, really a monthly tenancy, which your lordship had looked into as per the Transfer of Property Act. The mentioning of the lease word is not very relevant. Relevant is the nature of, my lord, the occupation and nature of, my lord, the right of the landlord to evict them. That is the basic thing. And which they admit that this was a monthly tenancy. Again, they say remedy the breach. Therefore, this was not prohibitory. These are all regulatory. And the regulatory action, my lord, can be, my lord, followed by way of regulation. Transfer was not prohibited, subject to permission, of course. Their permission was sought for. It's not the case that no permission was taken. Therefore, these are the aspects which have gone into. I am praying, Milord, let them file a short affidavit, let the matter, because my allegation, Milord, of malafide is serious allegation which is on record. I have said that this was triggered because of the news item which I had published on the day of, before the day of yoga, and immediately at the late evening.
So why not all the things in the civil suit? Why before the
That the civil court cannot go into the question of the freedom of press, and this is much. There is law is well settled when government action, even in case of tenancy, we should lie. That this is not a new proposition. Mr. Mitra has also not acceded to that. Here the all actions are government. Government has given me a document as per the Government Land Tenancy Act. This is not purely of the the civil dispute in nature. Here the authorities will not exercise the power out of statutory provision.
Yes. Okay. That's all.
My lord.
My lord, only thing, Ganashakti matter, the CHN matter, my lord, has no application in the facts of this case. That was relating.
No, yeah, I agree. Facts are different. I say principle.
That was not, my lord, a contractual, my lord. The government's obligation, my lord, to supply newsprints, my lord. That cannot be curtailed, my lord. That has got nothing to.
Anyway, my lord, when I shall face the judgment, I shall show, my lord, how this has application.
Remember it correctly, my lord. Possibly Mr. Bhattacharya will also not disagree to that. The other decisions, I really do not know. Nothing has been cited formally. Contract, my lord, the contract said that you obtain prior permission. They don't do that. I have accepted the first one, yes. Then, my lord, the next one, no. The third, fourth, two simultaneously.
That are pending.
Diagnostic centers, when I demand money, they say, no, they have left.
No, the other are, you have not taken any decision with regard to any of the matter.
No.
Taken any decision of any of the three water.
No, I have said that you change the document. I did not try to stand in the way, but when, my lord, I say that you pay this money for these two diagnostic centers, they immediately say that no, they have left. They are leaving, my lord. They could not have let it out without my prior permission. They had let it out. When I demanded the money, they, my lord, don't pay the money. My lord, they cannot, my lord, run, my lord.
But therefore, ultimately, money is the consideration. If that is so, definitely we can sort it out. No difficulty. If the money was payable to them, they will get the money, nothing else.
Well, those are my responsibilities.
Deeply obliged, Lord.
The petitioner has prayed for extension.
My lord, may I have your lordship?
Yes.
I will.
Petitioner has prayed for extension of the interim order passed by this court dated 10th of July 2026. Not counsel for the petitioner. Not counsel for the petitioner. Submit that on 25th of November 2021, an agreement, a lease deed was entered between the petitioner and the government with respect to the property in question. The petitioner has drawn the attention of this court to clause 7 of the agreement and of the lease deed, wherein it is mentioned that the lessee shall not subdivide or sublet the demised land or building to be constructed without the consent in writing of the government. First had to obtain and the government shall have the right and to be entitled to refuse its consent and its absolute discretion. He submits that the said clause does not reveals that the petitioner cannot sublet the premises in question. Only a written consent in writing is required. He further submits that the petitioner has drawn the attention of this court to the communication dated 9th of April 2025, wherein the additional secretary to the government of West Bengal informed the petitioner, requested the petitioner for submission of the document in connection with the proposal of renting out by the lessee with respect to the 5th floor of the building in favor of Aditya Birla Sun Life Insurance and on 4th floor of the building in favor of the Concord Diagnostic Center and 7th floor of the building in favor of Lumina Health Center constructed at DK-03 Sector 3 Salt Lake. Full stop. Non-counsel for the petitioner, by referring the said communication dated 9th April 2025, has further submitted that in the said communication, it is informed and it was directed to the petition to cancel the lease agreement dated 6th of November 2023, entered between the petitioner and the Aditya Birla, and directed to submit the copy of the tenancy agreement between the petitioner and the Aditya Birla. I submit that the respondents have admitted with regard to the lease agreement and the tenancy agreement. The petitioner has further relied upon the communication dated 23rd of June 2026, wherein the notice was issued to the petitioner with regard to the breach of the contract, but in the said notice, only 3 days time was provided to the petitioner. 3 days time was provided to the petitioner. Police, on receipt of the said notice, the petitioner has given reply to the said notice and requesting the authorities to withdraw the said notice, But in spite of the same, the respondent authorities have issued the impugn order dated 7/7/2026 by directing the petitioner to vacate the premises within 7 days. It is the contentions of the petitioner that if the respondents authorities are treating the said lease deed as a monthly tenant and as monthly tenancy, and thus the respondent authorities have to follow the provisions of Section 106 of the Transfer of Property Act, but instead of following the procedure, they have issued the impugn notice by fixing and by giving a 5 days time for vacating the premises. The counsel for the petitioner further submitted that the request made by the petitioner with regard to permission for entering into the tenancy agreement with the tenants is still pending, and the respondents have not taken any decision. Pending decision of the request made by the petitioner, the authorities have issued the notice of vacating within 5 days. The counsel for the petitioner has relied upon the judgment in the case of Park Street Properties versus Deepak Kumar Singh and another, wherein and submit that in the absence of the registration of the document, what is deemed to be created is a month-to-month tenancy, the termination of which is governed by Section 106 of the Act. But in the present case, the respondent authorities have not followed the provisions of Section 106 of the said Act. Per contra, Learned Advocate General raised the point of materiality of the writ application. He submitted that the writ application and the dispute raised by the petitioner is a contractual dispute between the petitioner and the respondent. And as such, the petitioner, instead of approaching the civil court, has filed the present writ application, which is not maintainable. Though he submitted the writ, he has drawn the attention of this court to various paragraphs of the petition and the document, wherein it reveals that the petitioner has entered into the tenancy agreement with Aditya Birla with several firms with respect of the premises is question and after with respect of the premises in question and after entering into the rent agreement with the concerned firms, the petitioner has subsequently made an application for permission in writing for subletting the premises to the third party. He further submit that with regard to one of the tenant, that is one of the tenant was in occupation of the premises, and when the respondents have asked for the rent from the petitioner, the petitioner has informed that the tenant has already vacated the premises. Though the tenant has vacated the premises, but the petitioner has not paid the rent of the said tenant to the respondent authorities. Full stop. The full stop. Then counsel for the learned advocate general further submits that without the permit and further submits that as per the lease agreement, which is a registered document, has categorically provided that the land was provided to the petitioner for the purpose of erecting a house and a building for the use of setting of the modern press and with the liberty that the petitioner can sublease or sublet the premises, but with the written consent of the petitioner, with the written consent of the respondent, but without the written consent of the respondent, the petitioner has sublet the premises in question to different firms and subsequently has made an application for consent for subletting the premises. Full stop. Heard the learned counsel for the respective parties peruse the materials on report and the judgment relied by the petitioner. This court find that the lease agreement was entered between the petitioner and the respondent. As per the clause 7, the petitioner shall not sublet the premises in question without the written consent. But in the present case, the petitioner has sublet the premises in question to different firms. But after subletting the same, the petitioner has made a request to the respondent authorities for granting for giving consent. The request made by the petitioner to the respondent authorities are still pending before the authorities. The petitioner's case is that without considering the request made by the petitioner for consideration of giving consent, the respondent authorities in arbitrary and whimsical manner has issued the impugn notices of 3 days and final notice of 5 days without following the procedure of 106 of the transfer of property. Full stop. Admittedly, the petitioner, after entering into the tenancy agreement with the other firms, have made a request to the authorities. The authorities have not rejected the said request of the petitioner. The request made by the petitioner is still pending before the authorities. If the authorities would have rejected the request of the petitioner and taking appropriate action against the petitioner for eviction of the petitioner for violating the terms and conditions, the case would have been otherwise. But in the case of this court, prima facie find that pending the request of the petitioner for subletting the premises, the respondent authorities have issued the impugn notice. The another aspect is that it is the specific case of the respondent that the respondents have inspected the premises, but there is no report was submitted to the petitioner, so that the petitioners can file any objection and to deal with the said report, if any. Full stop. Considering the above, this court find that though this is a contractual dispute between the parties, but the respondent is the state of West Bengal, coming under Article 12 of the Constitution of India, and this court find that the act of the respondent is an arbitrary by issuing the only 3 days notice and 5 days notice instead of without considering the request of the petitioner for consent of subletting the premises. Accordingly, a writ petition is maintained. Full stop. In view of the above, the respondents are restrained from evicting the petitioner from the premises in question. This court find that the writ petition is to be disposed of only after exchange of affidavits. Let affidavit in opposition be filed by
4 weeks, my lord.
4 weeks. Reply, if any, there to be filed by
4 weeks. 4 weeks, my lord. State.
Reply 4 weeks. You are telling.
Reply, my lord.
Yes, Mr. Bhattacharya, reply.
Reply 2 weeks, 2 weeks. Affidavit in opposition 4 weeks, will be 2 weeks.
2 weeks. Full stop. List the matter after 6 weeks. List the matter 6 weeks. No? आज कितना तारीख है? 1, 2, 3. List the matter on 10th of September 2026. In the meantime, the respondents are directed.
Well, the interim order granted will continue. That would do.
The respondents are directed not to interfere with the possession of the petitioner till 10th of September 2020.
Lordship fixing on 10th of September, interim order maybe little more, otherwise marginal situation might arise.
Till 15th September or until further order, whichever is
Deeply obliged.
My lord, may I be allowed to mention, my lord, I apologize. Today morning, item number 13 was fixed. I couldn't reach, my lord. If it can be fixed tomorrow, my lord, it is fixed on 10th of August. I apologize for not being able to reach, my lord.
Yes.
Today morning, I could not reach.
Which
my
one?
item number 13, my lord. There is some urgency. It is fixed on 10th of August. I have come to know. If
you lost your chance, sorry.
My lord, it's my fault, my lord.
This court is facing very hard
Yes, my
for
lord.
fixing the matter in the adjunct
Yes, my lord.
motion. If it is fixed, if you are
I admit, my lord.
My lord.
say day after tomorrow, or I'm ready.
The petition.
I
He's the, she has already been heard at length. So I'm only respondent number 6. I'm not even the state respondent. I'm just representing a committee. That committee's chairman, who was made party in person, he has already retired. Now a new chairman has come.
Who is for the other?
Lordship, the state has been served, my lord. On one occasion, they appeared also, but today they are not present.
What can be done? Not today. Come tomorrow.
My lord, Mr.
Come tomorrow. Come tomorrow. Yes.
May I give the name of the new this one? I've already handed over the notification.
Not here. Come tomorrow with the notice. Yes. Call the list.
My lord, on the last occasion, the responded, handed over, my lord, one judgment of the partner division bench.
Which matter?
This matter, this fixed matter.
112.
Yes.
I have handed over this reflection in the order sheet also. The partner high court division bench order. The pat on the point.
Yes.
Yes, my lord.
Patna bench order.
Yes. Kept to the record, my lord. Partner bench judgment. Yes, yes, my lord. The pat on the point. Division bench decided the matter at this point. Has already been decided.
What is the matter? What is the point? What is the point?
Point is that, my lord, if the reasonable requirement is reasonable qualification is not possessed by the applicant, is not entitled to get the benefit.
Okay, let me
My lord.
hear. Yes.
My lord, the judgment is not related to this matter. Because the petitioners has complied all the tender conditions. The judgment referred to here is non-compliance of the mandatory conditions of the NEET. But in the instant matters, the petitioners had fully complied all the criterion of the NEET, but illogically, they have taken the arbitrary decision by the technical evaluation committee to cancel the technical bid with the logic of that the certificate of neighbor country as per GFR 144/11 has not been submitted.
What is the case? Please made out what is the case? Tell me what is the
Case is regarding the floating of tenders
Correct.
and open the technical bids. My technical bids has been
Where is the tender?
values
Where
of
is the tender document?
there are 4 tenders, values about with the extension period about 2 crores each.
Where is the tender?
Tender document may kindly be seen, my lord. That is from page number 24 of the.
What is the work?
What is the work regarding OFC maintenance cable? OFC maintenance.
Maintenance.
OFC maintenance.
Cluster of maintenance of landline and the broadband work. OFC network. Yes. Then.
My lord. My main point is that I have complied with all the instructions.
So where is the impugned order? What you have agreed? Which order you have agreed for?
Yes, that is my technical work bid has been rejected.
Where is that?
My lord, page 110.
110.
110 to 111.
Not meeting the eligibility criteria, disqualified in the bid.
Yes, this is the main logic and argument point.
Yes.
What they have.
Certificate undertaking 44/11 general finance rule not submitted.
Yes, my lord. This is my lord. Before that, I request kindly have a look to my reply affidavit to the opposition of the respondent. My lord, kindly have a look at page 25.
Page 25 of?
25 of my affidavit in reply.
In the reply you have made out a case, not in the writ application.
Yeah, that is also there, but I am giving the certificate of the MSME. My farm is MSME farm, registered, Uddam certificate. And there are so many relaxation as given to the MSME farm.
Yes, tell me,
Even
show me, show me.
Show me, my lord.
So the only condition is that you are not
Only
submitted the
condition is that,
document.
my lord, kindly page 25 of the reply, last line, sir. ISE status. ISE details under the heading ISE status inactive. ISE means import-export code status. That is, my farm is
import-export
code status. That is, my farm is not eligible to function beyond the jurisdiction of the India. That is inactive. If an MSME farm, and I am entitled to get all the benefits, even relaxation in the eligible criteria like this. But my tender was arbitrarily cancelled on the ground that I have not certificate that I have not working in the border country. That certificate they have asked. My lord, come to my writ petition, page 7, my lord. Page 7, para 9, my lord. This is the main point of this writ petition. Your petitioner state that in view of the immediate above para, all above mentioned bid documents through GEM portal under reference incorporate clause compliance regarding beneficial ownership and transfer technology as per rule 144.11 of GFR 2017 with two fields. That is in the GEM portal, online portal, there are two fields. Two fields, yes or no. The field yes means for procurement of supply and finished goods, procurement raw materials, etc. from a country which shares a land border with India. If I give no, that is I am not land sharing. I am only working in India as per my MSME, which I have submitted with my tender net. Now, accordingly, when the option came, the two field yes or no. In my case, the appropriate field is no. So I tick in the appropriate field no. Whenever I tick in the appropriate field no, then the next screen come up. Come to the point, no. That is mean the procurement of service only. In case of yes, is marked by the tender, then the system will automatically, that is the GEM portal, ask to submit the upload the requisite certificate of the competent authority as required under para 144.11 of GFR 2017. The field no is applicable for service level agreement like OFC maintenance. The appropriate field no is to be marked, and in that case, question of producing the above certificate of the competent authority does not arise. But my tender has been cancelled. The documents earlier referred that I have not submitted the certificate. But in the need document, there is a pro forma like this. I have submitted all that with signature, filling up the all NIT. Only that certificate from the appropriate authority that I have not submitted because I have not required.
Where is the required document, eligibility criteria? Where is the eligibility criteria in the tender document?
Eligible checklist, my lord. Checklist, my lord, please kind have a look to the page number. Checklist. Checklist, my lord, 41. Checklist, page 41, my lord.
Yes.
There are checklist.
Yes.
Based on this checklist, a technical bid is to be evaluated by the technical evaluation committee set up by the competent authority.
Yes.
That is the CGM, Chief General Manager of the CNTX Circle of BSNL. In this checklist, there is no mention that the certificate is required. But unethically, with vindictive attitude, My lord, there is a history behind it. Off the record, I am telling. I was asked to give the 5 lakhs. Off the record.
But it is not used
Then-
in the pleading.
Why
Why he is not make FIR against the public?
that
Public.
My
Some
lord,
type of
my
aberration
lord,
before the
my lord,
honorable court
this is not the case. I have give you the documents with this. All are here. All are here. That automatically establishes the intention, the malified intention in case of public procurement, and they are restricting the bidders. How?
Kindly come to the page 40. Page 40.
Page 40, my lord.
Last Roman 7.
The bidder is required to certificate. I have read the clause regarding the restriction, procurement from the bidder country which share land border. Land border. I am not sharing land border.
Page 40, last 7, 8.
8. Bidder should have registration pursuant 144, 117 at the time of submission of the bids and acceptance of the bid. If the bidder was validated registration at that time, accepted registration shall not be relevant considered during the content of the execution. It is not applicable to me. My business is limited within the jurisdiction of the India.
Very sad that if you are in India, the certificate is not required. Show me.
That I have shown, my lord.
Where you have shown?
Yes. My lord, my reply. I am MSME registered.
You are MSME registered.
I as a MSME registered, I have filed the tender document,
Correct.
and before for that reasons I have exempted from the EMD.
Show me which document you are telling you have been exempted. Show me which document.
That is in the need condition. Need condition, there is exemption clause. And my bid was not cancelled on that issue. Cancelled only on the single issue that I am not giving the certificate that I am not working in the border sharing country as per GFR 14411. My lord, my registration is only the status. IACS status, import export code. That has been blocked, inactive. I cannot act beyond the country. MSME registered Uddam portal, everything submitted. My limit
So
is that.
suppose you are a MSME.
Yes, my lord.
And you are not conducting the business in the intercity in border countries. Correct.
Correct.
And if there is a condition in the tender document, that certificate is required.
That is I am telling, my lord.
The certificate is required. So the court can say now the certificate is not required for the
My
MSME.
lord, the system is itself required. I am given the explanation, yes, no. That is the gem bed of the department. So there.
You tell me what are the eligibility criteria in the tender document. Show me the eligibility criteria. Kindly come to the page 39. Read all these things. These are the criteria. You are not having the certificate. The authority have rejected that. You are telling that you are the MSME. MSME cannot have the certificate. So MSME cannot register.
Because this is the need. There is a part also the gem bid, 2 part. First need, based on the need, the tender is submitted. Then online tender procedure is there. I have to submit the online tender. That is through gem bid. But in gem bid, I am not, when I am giving the option no, then there is no required of the certificate. The department itself contradict. What can I do? That I am showing, sir.
Show me.
That I am showing. Page, my lord, kindly have a look at page 108 and then 109, my lord. My lord.
What is that?
There is a, if I feel no, nothing and come. But next page, my lord, if I
Sir, you tell me one thing. Whether the terms and conditions of the contract require the certificate or not, yes or no, you answer it as
not
yes or
required.
no. Not required.
As
Throughout
I
the
am.
condition, yes, record an order.
Yes, my lord.
The petitioner has filed the present date application being agreed and dissatisfied with the impugned communication
My lord, one
wherein
thing-
the petitioner.
my lord, my argument has not yet
technical
completed.
bid was cancelled on the ground that the petitioner is not meeting with the eligibility criteria, comma, disqualified is specified in the bid clause as per the details indicated in the comments. The comment shows that certificate undertaking under rule 144 within bracket Roman 11, small Roman 11 of the GFR rule GFR 270 not submitted. Then counsel for the petitioner submit that the petitioner is an MSME.
With the code of
full stop. He submit that he has relied upon the document wherein the IEC status of the IEC status, that is import export code status, has been indicated as inactive. Petitioner submit that if the petitioner is not having the business terms with the border country, and as such the import export code status has been given inactive. He further submit that if the petitioner is not sharing the business with the border country and his IEC registration, IEC status is inactive, thus the petitioner is not required to file the certificate undertaking under rule 144 within bracket 11 of the GFR. Full stop. He submit that the respondent authority, without considering the said aspect, has rejected the technical bid of the petitioner. Yes, what is the submission?
My lord, another submission is there.
What is your submission?
My lord, another point is there. My read
that's all. Yes.
My lord, there is a forged document. The form has been allowed, my lord.
The petitioner is not allowing the respondent to make submission.
Yes, not my lord, sorry, my lord, sorry.
Submission according to petition is dismissed.
My lord, please, my lord. Please, my lord. Please, my lord.
Next, call the list.
My lord. My lord, kindly allow, my lord. My lord.
Call the list.
My lord, kindly, my lord. My lord, excuse me, my lord, pardon me, my lord. My lord, pardon me, my lord. My lord, actually, my argument was not completed. As per the WP. My lord, please. My lord, kindly, my lord.
Yes, who is on item number 26? I am for the
My lord, please, kindly, my lord, kindly, my lord, pardon me, my lord. My lord, kindly give me a chance, my lord. My lord.
Half an hour, this court is asking you what is the eligibility criteria. You are stand on your own way. What the court will hear you for the hours together.
My lord, another in the read also.
That's all.
There is a forged document. My lord, dismissal is not.
Yes, what is the
my lord, give me a chance, my lord. Please pardon me, my lord, give me a chance. My lord.
Sorry, dictated.
My lord,
dictated, yes.
If your lordship will kindly see the last annex of the impugn order, my lord. My lord,
my lord, this was a forged document that I have not got chance, my lord.
My lord, kindly, my lord, the order of the honorable court, my lord, page my lord 42, and as a P11, my lord, kindly, my lord. Stay. My lord, page my lord 45, pursuant to the order of the honorable court, my lord, the impugn order has been passed. That is, my lord.
Where is the order?
That is on page my lord 45, impugn order, my lord. And as a
45.
45, yes, my lord.
Who has passed the order?
The district magistrate bureau, my lord.
What order is passed?
Actually, the fact is this, my lord.
Calculation of rent.
My lord, the fact is this, my lord. My property total, my lord, 5,319 square feet. It is admitted, my lord. Since 2003, my lord, the property.
Who are you?
Well, I am the owner of the land, my lord.
Owner of the land.
Owner of the property, my lord.
Yes.
My lord, since 2003, my lord, the lease agreement is going on. Time after every expiry of 5 years, it has been renewed and it is continued till today. My My lord,
You are the lessee.
I am the lessor, my lord. The government is the lessee, my lord.
Okay.
My property, I have given the on lease basis, my lord, to the my lord,
To whom you have given the land?
to the my lord, Consumer Affairs Departments,
Huh?
Consumer Affairs Department.
Consumer Affairs Department.
Yes, my lord.
Yes.
My lord, fact is very clear, my lord. As per circular, that is 2013, my lord, I am entitled to get the rent, my lord. Now I am getting the last order, my lord. The district master passed the order on page 47, my lord, para 12, my lord. That is, my lord, assessed by the district master after hearing both the parties, my lord, 33,211
Per month.
per month.
Hmm.
But my lord, till today, my lord, I am getting, if you lord see the back page, my lord, page 46, 90 rupees, paragraph 7, my lord, rupees 19,469. Actually, it was paid in the year 2018, my lord. But 2026, my lord, as I, my lord, filed this petition against the impugn order, till today, this payment is going on. Now only 90,469. Even my lord, order passed by the district magistrate, there is 33,211. No, I am not getting. As per their government circular, my lord, per square foot 8.66 per square foot is the rate, actual fair rent, my lord. If it is calculated, my rent will be, my lord, more or less 42,000 per month. And the present circular, now the present circular has come, my lord. After filing the petition, my lord, I got the document, my lord. In each and every year, also, my lord, 5% will increase each and every year, my lord.
So what you are challenged?
My lord, 30,
What you are challenged?
the rent will be, my lord, 42,000, my lord.
Kindly read the paragraph 12 of the order 47. Kindly read the paragraph 12 of the page 47. Read.
Yes, ma'am. I find that the calculation of rent as above is in accordance with the aforesaid guidelines dated 29 for 2013 of the Land and Land Resource Department. The above calculated monthly rent for the premises in issue shall be effective from 1st February 2023.
Correct.
Retrospectively.
Correct.
Keeping in view that the last assessment of the rent was made on 1st February 2018.
Correct.
Which was to expire on 1st of February 2023.
Correct.
As per the aforesaid guidelines dated 29th for 2013, annual enhancement of the sale rent of rupees 33,211 shall be made at the rate 5% on 1st February to each year, and the assessment shall be valid for the next 5 years, that is on 1st of February 2028,
Yes.
or until further guidelines.
Correct.
If so, issued by the government, whichever is earlier.
Correct.
But the fact remains, my lord, after 2018, if it is properly calculated, my present rent will be 42,000 per month.
So you mean to say the calculation is wrong?
Yes, my lord.
So what was your original rent?
Or a previous 2003, that was my only, my lord.
That is to be calculated because the
No, time to time it has been extended, my lord.
correct, that has to be taken into consideration when the agreement was entered.
My lord, last extended, my lord, on my lord.
When the agreement was entered.
Again, my lord, 1st February 2003, my lord.
2003.
Yes, my lord.
2003, which guidelines was prevailing?
But that is not in dispute, my lord. Dispute arises when the circular came in 2013, my lord. I am praying, my lord. Yes, my lord.
2013.
Yes.
So 2013 circular was there.
Yes, my
So
lord.
you are agreed with the 2013 circular.
Yes, my
on
lord.
2013 on 1st February 2018.
Yes, my lord.
Correct.
Yes, my
So
lord.
your new rent was started.
Yes, my lord.
1st February 2018. 1st February 2018, what was the rent?
That day, my lord,
1st February 2018.
is, my lord, 19,469.
Where from you got?
That is, my lord, page 46, my lord.
Page 46.
Para 7, yes, my lord.
Para
Still
7.
that is continuing, my lord.
Author including understand we are agitated at 8.66 and so.
My lord, here it is stated, my
Just
lord.
a minute. The assessment rent of the tune of 19 are determined by the special land acquisition officer, does not disclose the mode of such assessment. In the aforesaid premise, the owner calls upon the authority to reassess the rent, and you heard the party. Then has been no dispute with regard to that. So you are admitted. Kindly come to the page number 9, paragraph 9. Undisputed fact is that there has been no dispute with regard to the rate of rent to the tune of rupees 16,224 with effect from 1st February 2013.
2013, my lord.
Correct.
Thereafter, in 2018,
First minute, 2013 to 16,200, which is to continue up to the next 5 years.
Yes,
So,
ma'am.
5 years means 2018.
2018.
To 2018,
Right.
16,224.
And 2018,
So, 1st
2018.
February 2018, it is to be increased 5%.
Yes, my
So,
lord.
what is the 5%?
Not 5%, my lord, 20%. My kindly see the my lord, circular, my lord, present circular, my lord.
Where is
My lord.
2018 circular, not recent
No,
circular.
2018, there is no circular, my lord.
It is
2018, 2013 circular is to be guided, my lord.
2013 circular. What is the 2013 circular?
That is, my lord, page, my lord. That is page 31, my lord.
Page 31.
Yes, my lord. I mean, it is an admitted fact, my lord. The past purple is to be 8.6.
Page 31, what says how it is to be increased?
My lord, page 35, if you lordship kindly see, my lord, page 32, second paragraph, the considering the rapid hike of rate in the market, the rent shall be enhanced up to 20% of the present rent after expiry of 3 years, instead of expiring existing 20% after 5 years. Here say, my lord, instead of, my lord,
Just a minute. Considering the rapid hike in the rate of rent of market rent is enhanced 20% in the present rent after every 3 years instead of 20% after 5 years. Enhancement of the salary made automatically after a period of every 3 years from the date of possession. The application from the house owner of the enhancement rate is not mandatory. Maximum permissible limit in rent 3 years shall be 20%. The enhanced rent may be paid 3 times consecutively, then the rent shall be assessed after 9 years.
Only clear, my lord.
Just a minute. If the time is hiring department, continue occupy. Where the covered, uncovered spaces. What is this covered space or uncovered space?
The total, my lord, 5,319 square feet.
Open space.
Covered place, my lord, covered place, my lord.
What?
That, my lord, premises, that is, my lord, it is a covered place, my lord.
What is for covered place means cow shed.
No, my lord, it is a
Workshop.
No, my lord.
Office.
Office.
Where you mention, where is the lease deed?
Only my prayer, my lord, as per present circular, government circular,
Correct.
my
See,
rent may be
your case is up till 2013, there is no dispute.
No dispute, my lord.
2013 circular, there is no dispute. 2013 circular up till 2018.
Yes.
So 2000 circular says the 20% every 3 years.
Yes, my lord.
Correct.
Yes.
So if it after 3 years, that has not been considered. So 2013, if it taken into consideration 1st April 2013.
Yes, my lord.
So then every 3 years means 2016 it is to be.
Yes,
then
my lord.
how these 5 years will come?
Assess by the DM, my lord, 5 years. That is the problem, my lord.
That's
after,
why I'm
after 18
asking.
years, after 2018, my lord, I am entitled to get the 20% every expiry of 3 years.
Who has made the you have made an application? Where is your application before the DM for consideration of the rent?
That is, my lord, page.
Where is the schedule in the agreement?
My lord,
there is no schedule.
Kindly see page 36, my lord, my application before the, my lord.
No. In the agreement, there is no schedule.
No, there is no dispute. The agreement is there.
Agreement is there. It is open place or this office place? What is that?
Office place.
Where is that?
It is run by the, my lord, Consumer Affairs Department, my lord. Office is run by the Consumer Affairs Department. That is not a dispute, my lord, at all. That is not dispute at all, my lord.
That's why I want to say, because
the order itself is clear.
See, this court is not getting any support from the state authority. She will say, I will take instruction. She will come with the police report. She will not come with the Consumer Affairs report. I know that is.
Only prayer, my lord, DM may be directed
Because
to,
here nowadays the state is totally paralyzed.
yes, my lord. My simple prayer, my lord, DM may be directed to
I don't know what they are doing.
Man, if your lordship kindly see the phrase, phrase you have
That's why the state work has to be done by this court only.
If you also kindly see the present circular also, my lord, 2024 circular.
If I ask a report, they will bring this report from the police authority. State means the police. They have some definition of the state is police only. The other authority is not the state of West Bengal.
My lord, may I request your lordship?
That's why I'm asking you. You justify this because I didn't find any support from the state.
May I request your lordship? Kindly see the document circular, present circular, my lord, 2024 circular. Already I have handed over, my lord.
Which one?
24 circular, my lord.
This is the agreement you have given.
Oh, that's it. Even my lord, again circular has been passed in my favor. I am playing only as per government circular, my lord. I am not claiming any further, my lord. After filing the disputation, I got this circular, my lord. I am handing over the petition as well as the circular also to my learned senior, learned friend, my lord.
Yes, so then you clause 4. If the pair one determined under the order so and so date 29th April 20 can the case be reopened for determination. Premises for which the parent is assessed on itna will come under the purview of order. Where is that order?
Actually, here para, para 5 also, here is also mentioned the 2013 circular. Even my lord, after the assessment by the DM, my lord, as per assessment of the DM, I am entitled to get 33,000 something, my lord, 33,211. Now they are giving me previous date 19,000.
That's why if you go by the 13 circular, kindly come to the page 32, then it will be 9 years. So where is your complaint before the district magistrate?
That is, my lord.
Where is your complaint before the magistrate for fixing your rent?
And already I made the complaint, my lord, before the district magistrate, my lord. Pursuant to that order has been passed by the honorable court.
Where is your application? That's why you have to see what you have prayed for.
Yes, yes. Just a second, my lord. My lord, page 36, my lord. 36 the details we presented, 36, my lord.
Where is the government order 29th April?
That is, my lord. That means just I have shown your lordship's
29th April, yes.
Yes, my lord.
Page 31.
Page 31, my lord.
So as per kindly come to the page 38, paragraph 6. So you are asking for this benefit.
Yes, my lord.
Kindly come to the paragraph 6, page 38.
Yes, my lord.
Correct?
Yes, my lord.
So now if we go by that, then paragraph 2, kindly come to paragraph 2. Page 32, paragraph 2. Considering the rapid act sensation automatically expires. The maximum permissible limit of expiry of the period is 3 years shall be 20%, and the enhancement of the rent may be made 3 times consequently. Then the rent shall be assessed afresh after 9 years. So if it 2013, 2013 your rent is taken into consideration.
Yes,
so 9 years means it will go to 2022.
Yes, my lord.
Correct. 2022. And as per this order, when it was, they have considered from 2018.
2018, my lord.
That is wrong. You want that?
Yes.
Yes, madam.
I think, my lord, today,
No instruction.
My lord, just now I have received the brief from my
Just now, your PP office is only for the exhibition. GP office is exhibition.
My lord, all are suffering. My
What
lord.
what all are suffering? See, receipt of the GP office. What is this? So, you haven't tender with any pawn shop?
My lord, one thing may be noted, my lord, at present, my lord, previous date, that is 1944, I am getting still wrong.
What?
Right now, I am getting, my lord, 19,469.
19,000?
469, page
Where?
46, page 46, page 7, my lord.
19,449 you are getting now.
Getting now, yes, my lord. Even the order passed for the DM, page 46.
You are getting 33,000.
Yes, my lord. I should
You are entitled to get that.
Yes, my lord.
But still you are getting 19,000.
Yes, my lord.
Yes.
My lord, fix a date for report, my lord.
What report? You are not having the repetition. You are not mentioning when the matter is called. You are silently standing there at the corner. The petitioner has filed the present writ application challenging the order passed by the district magistrate and collector Birbhum dated 2nd June 2025, wherein the district magistrate has calculated the rent of the premises of the petitioner, which was let out by the petitioner to the Director of Consumers Affairs and Fair Business Practices. Full stop. The respondent number three, while calculating the rent, has relied upon the guidelines dated 29th of April 2013. And has calculated the monthly rent of the premises with effect from 1st of February 2023, keeping in view of the last assessment of the rent was made on 1st of February 2018, which was expired on 1st of February 2023. The respondent number 3, by considering the guidelines of 29th of September, 29th of April 2023, has enhanced the rent of rupees 33,211 from 1st of February each year, and assessment was valid for the next 5 years, that is 1st of February 2028 until further guidelines, if any, issued by the government. The Land Council for the petitioner has raised the first issue that the respondent number 3 has fixed the rate at the rate of rupees 33,211 with effect from 1st of February 2013 for 5 years, but the department is still paying an amount of rupees 19,469 instead of 33,211. The petitioner is further agreed with the calculation made by the respondent number 3 and brought to the notice of this court and submit that as per the guidelines dated 29th of April 2013, every 3 years and 13, the existing rent is to be enhanced at the rate of 20% of every 3 years, and the enhanced rent will continue for 9 years. But the respondent number 3 has considered the enhanced rent at the rate of 5%. 5%. He submit that the calculation made by the respondent number 3 is erroneous and is required to be rectified. At the learned counsel for the petitioner, this court find the petitioner. The respondent number 3 has passed the following order by fixing the rent of the petitioner premises, which reads as follows. Paragraph 12 for it. No? Page 47, paragraph 12. Clause 2 of the scheme dated 29th April 2013 reads as follows. It of page 32, paragraph 2. Full stop. As per the said paragraph 2 of the scheme of 2013, every 3 years the existing rent is to be increased 20% instead of 5 years. Instead of 5, and the enhanced rent may be made 3 times consecutively afresh after the period of 9 years. In the present case, the respondent number 3 has considered the enhanced rent at the rate of 5% instead of 20%. The respondent number 3 has considered the period of 5 years instead of 3 years. Accordingly, from the face of record, this court find that the calculation made by the respondent number 3 is erroneous. Accordingly, the impugned order dated 2nd June 2026 is set aside and quashed. The matter remanded to the respondent number 3 with the direction to consider the request of the petitioner afresh by taking into consideration of the scheme of 29th of April 2013 as mentioned in paragraph 2 and to pass appropriate order after giving an opportunity of hearing to the petitioner within a period of 6 weeks from the date of receipt. WPS disclosure.
May I clear one thing, Milord? Till such disposal, may I get the amount, Milord, per month, 33 to 11 with
Yes.
area. Till such disposal.
As the respondent number 2 is not paying the monthly rent as assessed by the that are your cost, so I am not passing another case. Next.
27 also, I am for the petitioner, Milord.
27, I am for the private respondent number 5, my lord.
Yes.
This morning, my lord, I have been briefed, my lord. I am seeking only the day's accommodation.
Yes. What is the
Please.
matter?
I have challenged, Milord.
MMR.
Yes, I have challenged.
Cancel the impugned divorce. Notice dated so and so.
I have challenged the impugned notice. The MMR, actually, system is as per Mohammedan Marriage and Registration Act. The MMR and Kaji should be in the local area. My lord, petitioner is in the district Bankura and his wife is in the district Bardwan. And MMR is in the district Milord Asansol and Kosim Bardhaman. And actually, originally he belongs to Birbhum. Totally fraud notice, Milord. That's why I have challenged this notice, Milord.
You are appealing for whom?
For the private, no, my lord, for the wife.
Why? So you are
Total fraud notice.
You are agree for the notice issued by the MMR.
Just this morning I have received, my lord.
Long back I have
days
long back.
Yes, my lord.
Who is for the authority? You know,
But again, my lord.
very difficult. You persons are the cause list is already uploaded at 6:30. What you persons are doing in the night?
My lord, uploaded after 8 p.m. my lord.
No.
Yes, my lord.
I am getting the at 7:30.
No problem. Uploaded after 8 p.m. and all office works hour is gone, my lord.
Learned counsel for the private respondent and the state respondents prays for time according cases adjourned. Let the matter appear on 6th August under the same heading. Next.
Milord, possession may be same, Milord, time.
Same heading. Yes.
6,000.
28 who is appearing.
And I for the response.
Yes.
Passport authority.
Who is for the petitioner? That is the problem. As none appears on behalf of the petition, let the matter appear in the combined monthly list of September 2026. Next.
Your Lordship, I am appearing on behalf of the petitioner, and this is a matter for restoration of the petition.
My lord, I am appearing for the respondent bank, my lord.
What?
Your Lordship, I am appearing on behalf of the petitioner.
Which matter?
And this is a matter where the PNB is the opposite party.
Which serial number you are appearing?
Your Lordship, item number 29.
Yes.
My lord, this matter pertains to surface, my lord.
Surface?
No, this is not actually not surfacey matter, Your Lordship, because this matter, they may have the permission to submit, Your Lordship. This matter is not surfacey. The bank authorities, they have taken money and ensured my client that you have owned the bid. And thereafter, they have taken 48 lakh rupees on account, in the account of the authorized signatory. Your Lordship, thereafter, when my client went to the bank and they said that give me their possession, the bank authorities verbally said that the person who was defaulted previously under Surface Act, they have returned the possession of the that particular property to that person. And accordingly, the bank authorities is now saying, because you have not paid the matter, you have paid not paid the amount on time, your total amount is forfeited. So there are two different set of questions arising here, Your Lordship. One is the Surface Act, the person from whom the bank has taken possession. And after taking the possession and assuring my client, they went to bidding, auction. My client owned the bidding and my client paid the money. And after that, the bank is denying to give the possession and saying that, that we cannot give you the possession. We cannot give you the possession because
IT कहाँ है? Why it's not on screen?
Your Lordship, I am not visible on screen. I don't know. Your Lordship, kindly come to page number 23. Your
Yes.
Lordship, this is a paper when my client, the petitioner, has paid 7,25,000 to enter into the bidding.
Where is the auction notice?
Your Lordship, kindly come to page number 24.
Yes.
It is saying by the PNB that you have quoted an amount of 7,25,000 for property ID such and such during online auction held on sub portal on date 10/9/21. Status of the lot is subject to approval based on the decision according to authorized officer of the property. A system generated mail will be forwarded confirming the update status of the property. Thereafter, Your Lordship, come to page number 25, where the PNB is writing to the petitioner confirmation of sale e-auction dated 10/9/2021.
Yes.
Page number 25, Your Lordship.
Yes.
We are pleased to inform you that successfully bidder for the e-auction sale held on 10/9/2021 pertaining to the scheduled property described herein under. The said e-auction sale was conducted in pursuance of our sale notice dated 7/8/2021. The undersigned acknowledge the receipt of 5,25,000 paid by you, which amount to 25% of the total sale price.
No, Sarfasi. You have issued the sale notice. They have appeared in the sale notice. The amount quoted has been accepted. You received the amount. Why the land has not been given to the petitioner?
My lord, because the DM order was yet to be, my lord, we did not obtain the DM order as yet, my lord. On symbolic possession, we have taken the property. My lord, we are taking steps before the DM, your lordship. We are taking steps before the DM.
When it is 2021, you have received the amount. I am passing an order with the 20% you return the amount.
Lordship, kindly do not do so, your lordship. Lordship, let me come now.
Is spraying the fraud upon the petitioner.
No, your lordship. Lordship is well aware, my lord. If we do
What
not get,
unless and until you have not taken the possession, how you gone for the auction?
lordship, on symbolic possession, my lord, we can sell.
Possession, you gone for the auction.
Your lordship, they have already
to correct
returned the matter to the
we
original
can sell out the
property holder.
As is various basis the property was sold, your lordship. On as is various basis the property was sold, my lord, as I am instructed that the petitioner has been informed regarding the updates of the section 14 proceedings, your lordship. Lordship, I'll come back with the report if your lordship is
No,
taking
your
up.
lordship, this is a
My lord,
dilatory
I'll
practice.
come
This
up
is
with the
not
report.
possible. Your lordship, kindly come to page number 46.
Well, I'll come up with a report. What is the present situation? Well, then whatever order your lordship passes, my lord, I'll bow
Your
down to
lordship,
that.
my client is 70-year-old. He is a heart patient. He is suffering and he paid this money. And now PNB is offering only 5 lakh rupees.
Just a minute. Why this person go to the surface?
Well, lord, because he has purchased in an auction sale.
An auction sale.
He has purchased in.
He is not
Under section 13(4), my lord, the auction was done. My lord, he has participated in that auction, and my lord, thereupon he has been the highest bidder, and after that the property has been sold to him. My lord, the sale certificate has also been given to him. My lord, only predicament is that we cannot hand over the possession because we were yet to receive the DM order. My lord, we were following up with the DM. My lord, the matter got dismissed. My lord, thereafter I did not obtain the instructions. My lord, kindly restore it back. My lord, allow me to come back. My lord, then your lordship is taking the matter.
The bank submit that the bank has already applied before the home.
My lord, before the district magistrate, my lord.
District magistrate for taking possession of the property in question, and as such, he prays for time to file report.
Lordship.
In view of the above, the case is adjourned. Let the matter appear on 11th of August 2026 within 10 matters.
Lordship. Grateful, my lord.
Your lordship, under the same heading? Under the same heading, your lordship?
Mr. नहीं कहाँ यहाँ तो नहीं है अरे मेरा इंटेलिजेंट लोग मालूम नहीं कहाँ है कैन कहाँ है
Your lordship, the respondent should come up with the application that they are saying that they have applied before the DM. But we made an RTA application which is on page number 42. They said they did not reply on the RTA application.
Just a minute, your suit is already applied. It is dismissed.
Yes,
how
my
the
lord.
matter can be taken up?
My lord, they came for restoration, my
How
lord.
the matter can be taken
We were coming up for the restoration of the petition, your lordship.
That's to be listed, but this court finds that there is no can application is on record. Accordingly, no order can be passed. कितने दिन बाकी सर?
Grateful.
तुम लोग को दिखाई नहीं देता कैन है तो कैन नहीं आएगा Yes, call the other matter.
Grateful.
My lord, I am appearing for the petitioner.
My lord, this related to my.
Why you are doing all these things? And sitting silent over the matter. I am hearing the matter. And you are not telling the can is there. Yes.
My lord, on the last occasion, my lord has been pleased to direct us, my lord, to come up with a report. My lord, this relates, my lord, to the Asansol District Hospital.
Yes.
My lord, tender with respect to canteen services of that district hospital.
Yes.
My lord, now, if I may trouble, my lord, there, my lord, initially a tender was issued, my lord, pursuant to the tender.
Copy of the report, my lord.
My lord, I copy there. My lord, pursuant to the tender, my lord, which was, my lord, floated, then, my lord, they had submitted their bids. My lord, the tender evaluation committee did the, my lord, did a scrutiny on technical documents. Then, my lord, financial bids were opened. My lord, then they received, my lord, we had received a formal representation from one, my lord, entity where, my lord, specific objections were raised, my lord, and then the entire tender process was re-evaluated. My lord, after evaluation, my lord, paragraph 4, if my lord will be pleased to take, fresh detailed re-verification of the technical documents were undertaken. During the re-verification, my lord, discrepancies and inconsistencies were discovered in the papers of multiple bidders. My lord, tender committee meeting was held, and my lord, a resolution dated 20th May 2025 was passed, declaring that the documents of 2 bidders did not fulfill the mandatory technical requirements and were liable to be rejected as technically non-compliant. My lord, due to technical discrepancies, since my lord, paragraph 5, Since the tender process had already advanced to the stage of financial evaluation, it became procedurally necessary to revert to the technical evaluation stage to ensure that only technically eligible bidders were considered for further process. The following bidders were excluded from technical eligibility. My lord, one Rajiv Roy and you, my lord, the petitioner here. My lord, the next, my lord, after that, my lord, paragraph 6, if my lord has been pleased to take, my lord, minimum 3 bidders are required. If it's below 3, then it has to revert back. My lord, next page, if my lord will be pleased to take, these, my lord, paragraph 7, my lord, 3 sub-paragraphs, my lord, these are the primary issues against the petitioner here, my lord. Discrepancy in the authority and authorized signatory. Trade license was issued by the petitioner certificate number such and such, dated 9 December 2024, listing Mr. Nihar Ranjan Pal as the secretary of the United Order and Supply Cooperative Society Limited. However, the notarized document submitted represents contradictory information. This raises serious doubts about the authenticity of the authorized signatory. Next paragraph, mismatch in trade license category. As per tender specifications, the trade license submitted by a bidder must categorically reflect business activities related to canteen services, catering, or food supply. The petitioner submitted a trade license describing the business activity as printing and office stationery, which is entirely unrelated to canteen or food services. This amounted to a fundamental failure to satisfy the basic technical criteria. Inconsistency in FSSAI license details, my lord. The FSSAI license relied upon by the petitioner stands in the name of one Bondona Rai, whereas the trade license stands in the name of Mr. Nihar Ranjan Pal. The petitioner did not produce any document demonstrating the linkage between the two persons or authorization permitting the use of such FSSAI license. The mismatch rendered the bid non-compliant with the essential food safety requirements prescribed in the tender. My lord, the petitioner has also referred to a tender bearing memo number such and such, which does not correspond to any tender floated by the tender inviting authority.
Yes.
So, my lord, primarily, my lord, these are the three.
So what has happened? What is now the tender is cancelled?
Tender is cancelled, and I'm
Yes,
challenging the cancellation of the tender.
Yes. What ground? What is the ground for challenging the tender?
First of all, the rejection of my technical bid is erroneous.
Why?
Why? I'm saying so. This is the tender license. I have already filed the supplement.
But 3 o'clock now.
Look, tomorrow, my lord.
The counsel for the respondents argued the matter at length and filed the report. Let the same be kept with the record. Due to paucity of time, hearing could not be completed. Let the matter appear tomorrow. Yes. 29 this found that the petition filed an application for restoration, but no application is on record. No application is let the matter go out of the Yes. No.
was there, still.
I appeal for the respondent. Well, could it be extended without prejudice to the rights in the appeal? We have already preferred an
disposal.
Yes, yes.
Right in contention till the disposal.
Yes. That makes it a limited. He will, as it is, have to find another.
Disposal I am fixing.
Not limited beyond disposal. No, but your lordship had given it a limited order, but kindly. The appeal bench is not sitting. That is the difficulty. The appeal bench is not there. My lord, for 2 weeks.
Preferred an appeal?
Yes, my lord, we have preferred an appeal.
No affidavits have been filed.
No affidavits have been filed.
Which they would have had to file.
Though the matter is listed as item number 101.
101.
Due to procedural matter could not be taken up by hearing, counsel for the petitioner mentioned the matter in presence of the land counsel appearing for the respondent for extension of interim order. And counsel for the respondent is objection for regarding the extension of interim order. At the land counsel for the parties, this court find that this petitioner already enjoying the interim order. There is direction or affidavit? No.
Yes.
There was a direction for affidavit.
Not filed.
Not filed.
No,
appeal was so.
Within 2 weeks.
Enjoying the interim order, full stop, despite direction, no affidavit in opposition filed by the respondents. Accordingly, for time to file affidavit in opposition is extended for a further period of 2 weeks. Reply, if any, that will file within a week thereafter. Release the matter on 20th August 2026. Under the same heading. No, within 2 weeks. Interim order is extended till 20th August 2026 or until further order, whichever is earlier, let the matter remain in the list.
Acha, it's remaining in the list. 20th August of the extension. 20th August of the extension.
20th August.
Very good.
Yes.
I'm sorry, my lord, extension till 20th and the matter will remain in the list. Okay.
But the interim order was till today, my lord. State was supposed to file a report.
You are for the petitioner?
I'm for the petitioner.
Who is for the state?
State.
What you think?
The matter is listed as item number 104 in the day's list, but the due to 105. But due to paucity of the matter could not be taken up for hearing, and counsel for the petition mentioned the matter for extension of interim order. And counsel for the petition respondent pressed for a week time to file report. Accordingly, interim order is extended till 21st of August 2026 or until further order, whichever is earlier. Let the matter remain in the list. In the meantime, the respondent directed to file report within 1 week. Reply exception if any within a week thereafter. Next. एक तो वो था ना, क्या वो सप्लीमेंट्री नहीं निकला, यही वाला था।
हाँ, 21st August.
Yes. No mention. Call the list.
Well, in this matter, my lord, I'm seeking a direction upon the respondent numbers 5 and 6, my lord, to issue me rent reasonable certificate, my lord. My lord, if your lordship will kindly take, my lord, may I find my affidavit of service, my lord? Very short point, if your lordship will kindly take page number 19. My lord, post
have you had petition given liberty to add the parties?
Yes, I have added, I have served.
Yes.
Well, post office is my lessee, my lord. They have agreed to increase the rent, my lord. However, my lord, they want the, my lord, now in terms of the CPWD guidelines, a rent reasonable certificate has to be issued, my lord. If your lordship will kindly take page 20 of the manual, my lord. Page 20, my lord, paragraph 1, assessment, reassessment of fair rent relating to private buildings taken on lease by the central government departments. So, my lord, for this, the respondent number 5 and 6 are the appropriate authorities of Central Public Work Department, my lord. But I was humbly praying, my lord. Respondent number 5 and 6.
Yes.
My lord, I was humbly praying, my lord, a direction upon respondent number 5 and 6, my lord, in terms of the manual to issue me a rent reasonable certificate, my lord, so that the respondent numbers 1 to 3, which is the post office, if your lordship will kindly take the letter at page 19 by the post office, they are asking me for this certificate.
19.
Page 19, my lord. The undersigned is very pleased to receive your documents regarding enhancement of rent. We are also very eager to enhance the house rent through FRAC of this department. But for this purpose, you have to supply the land cost certificate from the competent authority. That is First Land Collector, Kolkata, such and such, which is prerequisite condition for doing FRAC. But now, my lord, because of the Central Public Works Department and all departments of central government are governed by this, my lord, the rent reasonable certificate has to be issued by respondent number 5 and 6, my lord. I was humbly praying, my lord, for a direction upon this.
The tenant under you?
Yes. Post office is a tenant under
1, 2 and 3 are the tenant?
Yes. Post office is the tenant, my lord.
1, 2 and 3?
My lord.
Post office?
Post office.
Yes.
Yes, madam. I'm the postal department, madam. They issued the certificate, all the documents, then I can follow. My last location I've submitted, madam. I will report, madam. Kindly please the paragraph 7 and 8, madam. I have nothing to say, madam. The documents have paragraph 7 and 8. I agree.
Yes. Have you served the notice?
Yes, my lord. On 5 and 6, we have affected services.
Service. Record and on. The petitioner has filed the present writ application. Writ petition, praying for
Page 12, my lord, prayer C.
praying for a direction upon the respondent number 4 to provide land cost certificate to the respondent number 1, 2, 3, so as to enable the respondent number 1, 2, and 3 to enhance the rent of the premises in question. And counsel for the petitioner submitted the respondent number, the postal authorities are the tenant under the petitioner. The petitioner has made request to the postal department for enhancement of the rent of the premises in question. The postal authority, by a letter dated
Page 19 is the letter. my lord.
by a letter dated, what is the date?
My lord, date is not mentioned. However, my
By a
lord,
letter informed the petitioner that the postal authorities are eager to enhance the house rent through FRAC of their department, but for the enhancement of the rent, the petitioner has to supply the land cost certificate from the competent authority. That is the first LA collector, Kolkata. Full stop. The petitioner has made request for grant of land cost certificate by the LA collector, Kolkata, but the same has not been provided. But counsel for the petitioner submitted. In the meantime, an SOP has been notified. SOP number 8/5 has been notified, wherein assessment oblique reassessment of fair rent relating to private building taken on lease by the central government department has been notified. As per the said guidelines, a committee has to assess the reasonable, has to assess the present market rate.
Yes, my lord.
Present market rate, so that the rent can be enhanced.
And issue a rent reasonable certificate.
Chabala has to assess the market present market.
Then market rate or my lord, the agreement between the parties.
Present market rate or as per the agreement entered between the parties. No, but the
It has to be the present market
present
rate, my lord,
market
because that
rate.
is the dispute.
Present market rate and the land assessment committee, the assessment of the reassessment committee has to issue the certificate. What is it?
Rent reasonable certificate.
Rent reasonable certificate, on the basis of which the rent can be enhanced. By an order that the petitioner has made the
My lord, respondent numbers 5 and 6.
made the respondent number 5 and 6
Order dated 10th July.
as by an order dated 10th
10th
July
July.
2026, the petitioner has added the Special Director General, Central Public Works Department, as well as the Executive Engineer. What LE? Executive Engineer, Central Public Works Department as party respondent, who are the members of the assessment of the reassessment of fair rent of the fair rent committee. And the notice has been served, but in spite of service of notice, none appears on behalf of the added respondent. Accordingly, this writ petition is disposed of by directing the respondent number 5 and 6 to consider. Now, you have not made the request to the this committee.
No, my lord. My
You
lord,
have to
we,
make a first request to
I will, my lord, we shall, my lord.
Yeah, go on.
After giving us an opportunity of hearing if that
This one disposed of by giving liberty to the petitioner to make appropriate request to the respondent number 5 and 6 in terms of the SOP number 8/5 for enhancement, for fixing the monthly rent and for issuance of by fixing the enhanced monthly rent and for for issuance of
rent reasonable certificate.
issuance of
Rent reasonable certificate.
rent reasonable certificate to the petitioner so as to enable the petitioner to enhance the rent of the respondent number 1, 2, and 3. Full stop. If the petitioner made any request to the respondent number 5 and 6, the respondent number 5 and 6 shall consider the request of the petitioner and to provide the unreasonable certificate to the petitioner within a period of 6 weeks from the date of receipt of the petition. The petition is disposed of.
Item number 2. For the petitioner. The matter was fixed on last Wednesday at 3:45. I have served notice on the state.
It's not clear, my lord. I am appearing on behalf of the corporation 2 and 3, my lord, respond. Our letter dated, my lord, reply of this, our letter dated.
তোমাকে report file করবে?
Yes. my lord,
Lordship's
required because evidence is required.
That is required. That is why Lordship passed an order on the very first day for the state and the corporation to file a report. That report has not come. It's been 3 months. Kindly see 23rd June 2026 order. 3 months now, 1 month.
Yes. You are appearing for 2 and 3.
2 and 3, my lord. File, my lord.
Which for that one?
One is the state. We had served the state. Your Lordship has recorded. We had served the writ petition on the persons who appeared.
But on that day he was present.
Yes.
He has taken the report. Now today nobody is present.
Then there was a
Ah,
change.
state.
Yes, then there was a
That
change
is
in
the
the advocate on
problem.
record. We have served the petition on the registered advocate on record on the original side. That
I
they have
will call
received.
all secretaries before this court. If this type of the state activities will go. Since morning, none of the state advocates is representing properly.
At least a report should come from 2 and 3.
It is very unfortunate affair on behalf of the state authorities. Since morning, none of the advocates appearing for the state authorities are coming with the proper instruction. Accordingly, Principal Secretary of Judicial is directed to appear before this court and to explain why the state is not taking steps for bringing the report on record with regard to the cases filed against the state. Let the Special Secretary appear before this court on 28th of July 2023 at 3 p.m.
Grateful. Item number 3, special case.
Yes.
Your Lordship had kept 3 days for me to finish, but I'll try and finish it in a day and a half.
18 minutes, 18
Well,
minutes short.
But if I get a chance today and tomorrow, I should finish it.
Yes.
Because I think the last time I made any submission in this was in January. Hopefully my luck will now be a little better.
Yes.
So what I have decided, I'll just shorten my submission to keep it within a very short scope. Now, just to bring it back to your Lordship's memory, dispute relates to a school. School is run by a society. There are trustees running it. Now it's suddenly discovered that the secretary and the trust, who's also a trustee, was found guilty of defalcation, or rather, police investigated, found that he's been defalcating sums. After full inquiry, they start taking proceedings against him, arrest him. But he challenges the arrest, fails all the way to the Supreme Court, ultimately gets bail after more than 100 days with very strict conditions. Now, in the meantime, the reports are now available and all of that. They show a money trail, which is running into, which shows a money trail, going basically to his wife and daughters. So, 30 crores odd, it seems close to 30 crores has been defalcated. Now, the question is whether such a person can remain in charge of the school, being the secretary and a trustee. So, the trustees held a meeting. They appointed another honorary secretary. They appointed an administrator, and this was the situation.
Now, in defense, there are two or three things. But before I just show your lordship, I'll just remind your lordship of the kind of allegations against him. But I'll show that from the documents, but not just to keep it short. Now, my lord, in defense, your lordship will find two kinds of stands are there. But the principal stand taken, not the defense. I had made my submissions a long time ago, so not Mr. Mukherjee had not opposed, and then thereafter not followed by Mr. Anil Bandre. So there were two sets of objection. Now the defense really, the principal defense which seems to have been run is that look, this whole thing is a fallout of the Birla Lodha dispute. But South Point is part of the impression given is that it's part of that dispute, it is governed by that dispute, it is part of Priyamvada Devi Birla's estate, and Lord, in those proceedings arising out of probate, an order is passed by Justice Munshi, which had the effect of putting the APL in charge of not everything, including societies, trusts, and other things. That seems to have been the principal defense. And that's the defense taken in many other proceedings. Now, fortunately, in the meantime, there have been similar societies, not in which something like this had happened, wherever this gentleman was involved, not steps were taken, they have not challenged it, and not got any interim orders, and there are findings against them. I'll show your lordship that. So, the first submission which I make is this reference to probate proceedings is a bogey. But this is pure and simple, not a case of a trustee defalcating and playing around with the funds of a school, and an attempt by one wing of people using the excuse of not Justice Munshi's order to say he should remain. Now, please remember this. This is a well-known school with a large number of students. Highest in Asia. But apparently, it's the largest number of students in any school in Asia. 12,000 students. I didn't know this. Now, the question is whether this person could have been trusted to remain after these charges. Now, there is not just a question of defalcation of funds, it's also a question of a trustee doing it. And I place the judgment saying that the trustee must explain. Now, your lordship will remember this, that through the arguments made by both my learned friends on the other side, no attempt was made to try and explain away why and how this money has gone out. None. They have not gone on technical defenses saying, look, this is governed by Justice Munshi's order. This meeting at which action is taken against this defalcating member, the secretary, could not have been validly held. That is really the basis of the challenge. So, technical defenses have been taken, but no attempt made to explain this removing of funds. Now, it's in this background that I'm just dealing with not everything. I'm now not going to keep it in a very short compass because I realize your lordship has determination and we will not obtain a closing in this matter if I keep it longer. So, having summarized it this way, what I'm saying is it's simply a dispute which has now been sought to be created, which is non-existent. It's a bogey. There is not the simple facts are, there is a man, he's been found defalcating, the police investigation shows that. Thereafter, the ED has also started investigations. That your lordship was pleased to say, hold your hands for the time being, because Supreme Court is in session over that similar issue. But forgetting the ED part, the fact is the police investigation is complete and they say there has been defalcation of funds. So it is a simple case of defalcation from a society. The question is whether he can continue to remain in charge. Therefore, there was a duty on the remaining trustees to ensure that he disassociates himself. A new honorary secretary has been appointed and administrator has been appointed. So this is really, now what they did was, now the reason that this dispute comes in is, they've also filed a suit challenging the meeting where this gentleman is removed. And the basis of the challenge is, like I told your lordship, it is to do with the probate proceedings with which the school is not involved in any way.
What is the tenure of this?
Well, there is no fixed tenure of these people. There is no fixed tenure under the rules. There is a right to remove, he has been removed.
Okay.
But,
so whatever the
well,
committee
let me
that
put it-
continue.
My lord,
The committee will continue.
Yes, there is.
Without any, no time limit.
Not that I can remember, but it's not a committee, it's trustees. my lord,
Trustee, that's right,
Trustees.
trustees.
But look at it from a different point of view, a different perspective. But can this gentleman, once it is found that there are serious allegations in which the police has actually found to be much evidence also, should he be permitted to carry on?
How the trustee can be removed?
Under the rules provide for it. He has been removed. Their case is also that Harshvardhan Lodha was removed. So they can't say that the rules don't permit removal. Their case is also he was removed, but removed pursuant to the so-called order of the High Court, which is not there. So removal, my lord, is not question. My learned friends have made many submissions. They have said that that meeting was attended by a person who could not have attended. This really is the case in the other one. Now, again, look at it from another perspective, just a practical common sense view of the matter. Can a person who is now accused in a criminal proceeding against whom there are substantial allegations, there is a money trail showing removal of a large sum of money, apart from other benefits which he could not have obtained. But once that is found, can he remain? And will someone else be justified in keeping him on the ground that, look, there are internal differences? Let's look at it from that perspective. Let us say he claims that, look, it is part of the Birla estate. Let's say he says so.
Okay.
Even then, Lord, he should not be there.
Yes.
That detail I'll just give your lordship, I'll show your lordship the details. Now, now, please remember that the countersuit is trying to justify these acts. I'll show your lordship those paras also. The countersuit tries to justify these actions, and these can't be condoned. So, now the smaller details, if I can just get into, our meeting was held on 10th of February 2024. With notice of that meeting, that meeting is held upon notice, due notice, admitted. Their grievance on that, please remember, is that one of them was arrested, therefore he could not attend. This is the defense on that. It is not a case of lack of notice. The second part is thereafter, with notice that we have held a meeting where he has been, and first trustees and managing committee members have been appointed, he goes on and holds a valid meeting.
Yeah, that you submitted already.
Yes. Just remind me, your lordship. So, this is what happened. This is that chronology. Now, as far as he is concerned, the details I'll give your lordship. If your lordship sees, but in the petition, my lord, all those annexes are there. Those were showed to your lordship at the very beginning. But if your lordship wants to make a note, my lord, page 474 to 486 of CS Kotor, CS 21, GA1. Not those are the remand reports.
Yes.
Now, there was another society, to do with Bellevue. Same gentleman was involved. And there also, similar action was taken. They filed a proceeding challenging that. And in that, they failed to obtain an interim order. And the court's findings in it, but we had handed up Justice Sarkar's order. If your lordship would please have a look at. In that case, just make a note. I won't trouble your lordship with it. I'm trying to keep it short, but if your lordship wants to have a look at it. But what Justice Sarkar has held is that after the division bench judgment, the position has completely changed. But it's an order of 22nd May 2024. consider that. Lord, I'll give another copy.
Yes, got it.
Lord, if your lordship would come to page 9, I'll keep it short. Now, Lord, please go to the top of the page. First sentence on the top of the page. PDB was the owner of certain specific shares in the company in such capacity as shareholder. She had incidental rights such as voting right, decision-making powers, ownership of shares and rights directly incidental thereto were heritable rights which devolved on her estate. So, Lord, shares can devolve. Trusteeships can't. But a personal charisma, authority, and influence over shareholders and management of other companies were not heritable. They are not properties which could be treated as subject of PDB's estate. The division bench now made a clear distinction between rights of PDB flowing from ownership of shares and those which had been remotely derived from ownership of such shares, being the nature of control over the promoters, groups, or voters. APL could exercise powers only on the strength of shares which were owned by PDB, but not on those shares over which PDB had either remote or derivative control. Thus, in my prima facie view, the APL could not interfere with the internal affairs of the MP Birla Group and the societies. Upon disposal of the appeal of 14 December 2023 and the division bench coming to a specific finding that APL did not have any jurisdiction or right to interfere with the internal affairs of the management of companies under the MP Birla Group, the resolution of 4th March 2021 became inoperative. But this is the one which he supposedly seized. The cessation became not inoperative. The agenda notices were issued on February 22nd and 22nd and 27th, 2024. Petitioners received notices, raised objection, but did not take any steps to prevent the meetings from being held. Accordingly, resolutions were passed and adopted. There was a need for recomposition of the trustee and managing committee had been prima facie answered by Mr. Mitro. But here also it was the same gentleman and the answer given was, next line, but such a need arose as one of the trustee and members of the managing committee, Mr. Damani, was charge sheeted. So same allegation, but different society. We were unable to function on account of arrest. Mr. Daga, petitioner number 2, is also facing criminal investigation. The charge sheet filed upon completion of investigation was placed before the court. Investigating agency indicated the complicity of Mr. Daga was prima facie available and further investigation was necessary. It was further contended that application for anticipatory bail had been withdrawn. Learned senior counsel submits that a person who is an FIR named accused cannot continue to manage the affairs of the society and the other person has been arrested. Investigation is going on in respect of the involvement of Mr. Daga in the allegation of defalcation of funds of South Point School. Thus, Mr. Pradeep Tandon was made honorary secretary. I find further that the regulations, prima facie, do not prohibit a trustee from calling any meeting, but same facts. Mr. Tandon was appointed honorary secretary in one of the meetings held on the basis of so-and-so. Notice and resolution has been adopted. It is the petitioner's own case that they have also constituted trustee and managing committee in the past. Regulations do not provide that non-conformation of regulation render them void ab initio. Rather, regulations provide that resolutions taken by circulation would be valid. Prima facie, it appears from the records that the meetings were held also, etc., etc. So, Lord, in this situation, Lord, interim orders that they had sought were refused.
Yes.
There was an appeal from this. I'll just give it for your lordship to not record. There was an appeal from this which failed. Not a copy had been made of. I'll give one more copy. But division bench of presided over by Justice Sabyasachi Bhattacharya, Lord, 28th of February 2025. Not interfered.
Yes.
Lord, in addition, Lord, the fallout or the consequence of the order of the division bench has also been accepted by your lordship in a Lord, your lordship has relied on this inoperative, Lord, in your lordship's order of 21st June in Punjab Produce versus Harsh Lodha. That it became inoperative. Lord, I'll just hand up a copy. Oh, it's you have shown it earlier. Please turn to page 14. I'm sorry, that should be page 17. In CS 153, at para 28 at page 17.
Yes.
In CS 153 of 2024, an application being J1 of 2024 was filed by Eastern India Education Institution, another for grant of an interim order with regard to a notice when emergency meeting of the managing committee was called for on 29 February. The coordinate bench refused to grant an interim order, and your lordship has quoted Justice Sarkar's order. Not that inoperative portion. And then, my lord, at the time of the order, on the previous occasion, plaintiff have paid for an interim order with regard to an AGM of 22nd September. At the relevant point of time, there was no order of the Honorable Division Bench, dated 14th February. After the order of the Division Bench, circumstances have changed. As the Honorable Division Bench held that the testamentary court can't pass orders directly in respect of the management and affairs of corporate contractual rights of other entities, including companies, trusts, etc. Now, your lordship has got that para 29.
Yes.
And Lord, that same division bench order which is referred to, Lord, I've already showed to your lordship and your lordship has marked it. I'm not placing it again. Your lordship will find it refers to the division bench judgment of 14 December 2023 in para 29.
Yes.
Lord, for your lordship's note, if your lordship wants, Lord, the order is annexed and the relevant paras would be not many paras, but 179 if your lordship would mark. 178, 170, but 172, I'm sorry, 172. 172 and 178, Lord, which is at page 496.
GA4
Of GA4
in CS 16.
in CS 16.
Volume 4.
That's at volume 4.
Yes.
Don't show it now. Lord, I've already showed this Lord order a few times. I'm not showing it if required. Lord, at the very end, I'll place that.
Yes.
So, Lord, several Lord, attempts have been made to challenge this kind of Lord removal
Yes.
in different proceedings, and Lord, my learned friends have not succeeded. Now, in addition, Lord, one important thing has happened in the meantime. Lord, your lordship will remember their stand, and that's what I was arguing on, Lord, when I last argued on January. They have said that he has ceased to be a trustee pursuant to
Order.
Pursuant to an order as not intimated by the APL. There is no independent resolution of removal.
Correct.
Now, after all these submissions have been made by me, a series of suits is filed by them. In Alipur court, Sialda court, all of them trying for orders, and they have not succeeded in any of them. But it says two things. Number one, they recognize, therefore, that as far as the trusts and societies are concerned, they did not form part of the estate. Because if they formed part of the estate, then you would have had to go to the probate court. So now they accept our contention that, look, this was not the subject matter of Justice Munshi's order. Number two, Lord, In these new proceedings, now, my lord, once I made the submission that there is no independent resolution of removal, now they've changed the language from cessation.
Yes, they are.
Stands now, changing stance.
They have taken the consideration of the two orders and the opinion.
Yes, but at that stage they were saying cessation. But once I made my submission before a lordship, not in January, that look, there is actually no cessation. The only stand was cessation. I pointed out there is no independent resolution of removal.
Yes.
Mr. Mukherjee tried to justify it, saying, well, even this is to be taken as an independent resolution because there is of the words use of confirmation. It has been confirmed. Now they take the stand that he has been removed. They've given up the old stand, which means that their defense in this suit also is not considerably watered down. But in that whole bunch of new suits, what I will do is tomorrow I'll give your lordship a list of the proceedings filed since then, which in all of which this similar issue is cropped up, and where they really haven't succeeded anywhere. Now, in addition, there is a number of orders also, including one where, well, these people, they took charge of the bank accounts of this hospital known as Bellevue. And again, went and Mr. Daga files against Mr. Damani, and they go and get an ex parte order against operation of bank accounts. It's as collusive as it gets. Now, so this kind of thing has been happening. They don't succeed in Alipur. They go to Sialda. They don't succeed there. Then a third suit on the same issues filed in this court. But I'm going to give your lordship a list of these proceedings to show that there is an abuse of process. Here we are concerned with a school, the running of the affairs of a school, not those fights between trustees and whether we are part of the estate or not, can continue. But here, these orders are absolutely necessary. Now, three or four, do we show the documents or not? To do it. Put up for it one. First, let's take care of his crookery. Just. No, this is at stay. What's the point? Now, when I earlier made my submissions, I've given your lordship all the pages to show the complicity. But the basic story, to do with this, stealing is this. What this gentleman did was, there's a chain of companies formed by him, where his wife and his daughters are shareholders and directors, and his mother. All family members, there's also one where his brother is there. So what he does is, funds of the school are sent to those companies, and from there on to him. The total amount is roughly anywhere in the region of 20 to 28 crores. That's what the investigation reports of the police seem to show. There are several orders of the criminal courts recording this fact. Now, in addition, he has been paying his personal bills through school accounts, number of bills of famous clubs in Calcutta. Those bills have been taken care of through school accounts. Personal driver's salary is being paid out of school accounts. There are these other charges also. Now, anything you want to show from it? Your lordship could not just make a note of the page number. I've already showed it earlier.
Page 626.
Page 626.
To 600.
Page of what proceeding?
Of GA?
Of affidavit in opposition to
Filed by Krishna Damani
filed by Krishna Damani
in
CS 21 GA1. So he
has disclosed one of the police reports.
This is okay.
Now he
way of GA.
My lord.
Way of GA.
Yes.
One.
AO. So it is by them where he's disclosed. He has disclosed the police report.
Yes.
If your lordship would have a short look at this, since we are on it, volume 5, page 627. Lordship has got page volume 5,
Yes.
page 627.
Yes.
Not the second para. It is a fact that SPES, not that's South Point Education Society, had engaged a company styled as Global Staffing Services, which is a division of Pastille Mercantile. As per the declaration of the company, Pastille in its letter addressed to the Income Tax Department outsourced manpower consultancy work. It is also evident that Pastille is owned and governed by two directors, namely Mrs. Manju Damani and Mrs. Jaya Damani, who are the mother and wife respectively of the accused. Krishna Damani being a trustee of SPES. Now, a trustee cannot have dealings not like this. I've showed your lordship the provisions and the judgment. Not that judgment was not dealt with. Besides this, Mrs. Manju Damani, Jaya Damani, and Basant Damani, now deceased, are the family members of the accused. Krishna Damani, herein the accused person of this case. In fact, Mr. Krishna Damani himself is an authorized signatory in the bank account of Pastille and associated as director to one of the three companies, Ms. Jaya Damani, wife of the accused, Krishna Damani, and accused number 1 is the director of the two companies. Scrutiny of the bank accounts of Global Staffing and Pastille has clearly showed that funds have been paid from South Point School, South Point High School, managed by SPES, and transferred to the bank accounts of Global Staffing, a division of Pastille, which is elaborately mentioned in the case diary. And so on. So, in the course of investigation, several vouchers had been collected on seizure from the office of South Point related to the payments of Global Staffing, and the computer containing the tally database of the school were meticulously examined. It is astonishing that those vouchers and the subsequent entries in the accounting software is clearly mismatching. In fact, it became evident to the investigating agency that multiple vouchers have been entered into the accounting software for the same entry, which was done intentionally to hide the actual amount transferred to Global Staffing Solutions, and it integrates the siphoning of funds in the name of ghost recipient of the funds. Since the available vouchers are not matching with tally data, it's evident that the vouchers are manufactured or the tally data has been grossly tampered with. Also to mention that forged vouchers containing signatures of the noted accused person. Then, Millard, please go on to the next page. Millard, there are a lot of other things over here. Please also see, Millard, 21 lakhs payments, global staffing. I won't show your lordship this. I'll just show Millard where it went to, Millard. Please see, Millard, the next page, the fifth para from the top. Millard, the page 6 to 8.
Yes.
The records of bulk posting and fund transfer and sorting of payment records that one person, namely Shondip Ghosh, is a faculty of South Point School as provided by Global Staffing Services, not in other words a teacher, whereas in fact, they said the person was found to be a driver of the custody accused person, Damani, and he's driving a car of the accused. But your lordship has found that someone had hired as a teacher in the school, salary being paid by the school, but he's serving as the driver of Mr. Damani.
His personal driver salary is paying out of the school funds.
Yes.
So, your lordship will find there are several other ghost persons in the educational institution, etc. So, a lot of wrongdoing happening. This is what the attempt is to stop this. Now, there is a lot more than that. Now, please also have a look at this order. It's of more recent. Sort of. But I'll just take your lordship straight to para 10. It prima facie appears that the proposed accused person being one of the trustees of South Point, that is a finding, prima facie appears. Being one of the trustees of South Point Education Society and after referred to society was involved in large-scale criminal conspiracy in connivance with others, where he unlawfully assumed control over the society by sidelining other trustees and also systematically diverted funds from the society and collected as fees and contributions and generated proceeds of crime therefrom. It also prima facie appears that he diverted and routed crores of funds from South Point School and South Point High School to two entities which are owned by the proposed accused person, and subsequently the proceeds of crime was fraudulently paid and distributed to his family members and another entity by fabricating forged records. He is prima facie found to be involved in acts of concealment, possession, acquisition, etc. And then, Lord, your Lord, you will find that Lord Para 12, considering the petition of complaint having regard to the documents seized, I am of the opinion that the notice under first proviso of subsection 1 of 223 should be issued, etc. And notice was issued on this also. So apart from the other criminal proceedings, blood, then blood, these ED proceedings also blood started off, but then because of this blood point of law involved in some matter in the Supreme Court, that has got stayed. So
yes. Yes, come tomorrow. Come tomorrow.
Not one para, if I can show.
Yes, 16.
Not CS 16.
DS
16.
Yes.
GA1, page 12.
Yes.
I'll just read it for your lordship. But what I'm saying is these acts are sought to be defended now by the other camp. I'll call them camp. And their letters will also show that. Lord, your lordship can make a note of that also. Lord, para 19, just the last 4 lines from their affidavit.
Yes.
Please see what they say, Mr. Last 4 lines. Mr. Krishna Dhawan has been wrongfully arrested and detained by police authorities, etc. Continues as a trustee and office bearer. So they try to not defend his action, but without justifying not how and why this money could have been transferred by a trustee to his wife or companies owned by his wife and not daughter. No explanation.
Same thing.
Yes.
Lord, your lordship can make a note, similar thing, para 49. Till date, Krishna Damani continues. So and so. Now, Lord, please see what the plaintiffs say. Page 38, para 49.
Yes.
Please see the last 2 lines of that para. Petitioner states that he is contesting such frivolous and motivated complaints in legal proceedings. But no attempt to say that these are acts which he could have indulged in as a trustee. No attempt to say, very well, I will account for it.
Yes.
No, no way.
Yes.
I will not be able to finish tomorrow. All right. I thought I'll get till 1:30. No, it may not be possible to finish tomorrow. Your lordship has given me 2 dates. Tomorrow it may not be.
Mr. Bachawat has argued the matter length, but due to positive time, hearing could not be completed. Let the matter appear tomorrow at 3.
Yeah.
My lord.
Yes.
Before starting, my lord, I'm paying, my lord, I'm unqualified apology, my lord. In item number 2, my lord, I am appearing for the state, my lord. I just heard principal secretary has made personal appearance in item number 2, my lord. I'm just
Let come.
My lord,
Let come. Let me see.
My lord,
You are not only fault since morning. The court is fed up with the state authority. That's why I called.
My lord,
I call the.
I'm paying.
Just a minute. I call the legal remembrance. He has given the undertaking before this court. Henceforth, all advocate will appear now. I call the GP. He has submitted before this court. Henceforth, all advocate will appear in the matter now. Nothing remains now. Today I am calling the secretary. If the secretary will not do, then I will call the chief secretary.
No, my lord, it's my fault, my lord. I must engage another.
I cannot call the ministers, then I only call the secretary.
It's my fault. Kindly recall the order. Otherwise, my lord, kindly, my lord. My lord, I have just missed the matter, my lord.
No. Since morning, the court is sitting idle here.
Item number 2, my lord.
The state is coming with the paper. That's all. Nothing, no support from the state authority.
Unqualified apology, my lord. Kind.
Yes, call the matter.
Item number 5.
But I appear for the petitioner.
Yes.
Lord, this is on a pure, Lord, on a pure question of law.
Yes.
Lord, whether Section 17 of the Maintenance and Welfare of Parents and Senior Citizen Act is ultra vires to Section 30 of the Advocates Act or not. Duto boi dao.
Not to appear.
Not to appear. Advocates Act dao. But kindly take these two books. But I'm covered by 3 judgments of 3 honorable court declaring it to be unconstitutional. I'll rely on that and I'll rely on a 4th judgment very quickly. But take first Section 17 of the 2007 Act.
Yes.
But this came into effect on 29th October 2007. This act was given effect on 29th December 2007. Now kindly take Section 17 once. Section 17 says, notwithstanding anything contained in law, this. So on that day, notwithstanding anything contained in any law prevailing on that day, no party to a proceeding before a tribunal or appellate tribunal shall be represented by a legal practitioner.
Yes.
Now, Lord, kindly take the Advocates Act now.
Yes.
But Section 30 of the Advocates Act Lord says right to advocates to practice. But I'll again take your lordship back to the 2007 Act. Section 30 of the Advocates Act, which was introduced on 15th June 2011, it says, subject to the provisions of this Act, every advocate whose name is entered in state rules shall be entitled as of right to practice throughout the territories to which this Act extends, in all the courts, including Supreme Court, before any tribunal or person legally authorized to take evidence. Not can mark this. So 30 gives a lawyer correspondingly to a litigant also to take the help of, because taking legal assistance is a part of right to life and right to be represented. Section 30 says a lawyer would have a right to be represented in a court or a tribunal which is authorized to take evidence. Now, Lord, kindly come back to 2007 Act.
Then you are also to consider the Industrial Dispute Act, Section 16 or Section 32. Bar the advocate to
That
appeal.
that has been considered.
That is also the tribunal.
Now, kindly take Section 6 of the 2007 Act.
6.
The jurisdiction and procedure of the 2000 Maintenance Tribunal.
Yes.
The proceedings under Section 5 may be taken against any children or a relative in the district. Now, kindly take 4 of the subsection 4. All proceedings shall be taken in the, so from 3. For securing the attendance of children and relative of the tribunal shall have the power of a judicial magistrate of the first class as provided under the Code of Criminal Procedure. All evidences of such procedure shall be civil procedure. All evidences to such proceedings shall be taken in presence of the children or relative against whom an order for payment of maintenance is proposed to be made and shall be recorded in the manner prescribed herein. Then kindly take note Section 8. Summary procedure in case of inquiry. In holding an inquiry in Section 5, the tribunal may, subject to any rules that may be prescribed by the state government in this behalf, follow such summary procedure as is deemed fit to. The tribunal shall have all the powers of a civil court for the purpose of taking evidence on oath and of enforcing the attendance of witnesses and compelling the discovery or production of document and material objects and for such other purpose as may be prescribed, and the tribunal shall be deemed to be a civil court for all the purposes under section 195 Chapter 26 of the Code of Criminal Procedure, subject to any rules being made therein in this view, tribunal may, for the purpose of adjudicating the deciding upon any claim for maintenance, choose one or more persons possessing the special knowledge and so and so. So the tribunal has a power to take evidence. It is given all the powers of a civil court. Now, section 30 would be applied, so 31(2), that which says that not a lawyer would have a right to appear before a tribunal which is authorized to take evidence.
Yes.
Now the issue first cropped up, my lord will take note of only one date, or my lord may take one date. Kindly take this notification. Section 30 was not there when section 17 was promulgated. So, notwithstanding any section 17 would not apply to 30. 30 was not given effect on 15 June 2011. Section 30 of the Advocates Act was introduced in the Advocates Act on 15 June 2011. So on the day when the section 17 of the 2000
Section 30.
30, yes,
Shall be entitled to right the practice throughout the territories. That has been included in 74.
no, section 30. Not kindly have a look. The questionnaire in the parliament and this answer. Yes, madam, the government has issued notification under 9 June 2011 appointing 15 J of June as the last date on which section 30 of the Advocates Act shall come into force. And the next page, section 30, the notification is section 30. Kindly read the notification. In exercise of the powers conferred under subsection 3 of section 1 of the Advocates Act, the central government hereby appoints 15 day of June 2011 as the date on which section 30 shall be given effect. But section 1 says there are portions of the act which may be given effect later on. 30 was not given effect until 2011. So on the day 2007 Act was promulgated, that notwithstanding any law, legal practitioner shall not be allowed, 30 was not there, giving right tribunal which takes evidence. But take notes of 3 dates only. But the Maintenance Act came in.
In exercise of power conferred on section 1 of section 21.
Yes.
Central government appoint the 15 day as the date.
Date on which section 30 shall come into force. Now kindly come back to the Advocates Act. Kindly see not section 1 once.
Yes.
1 subsection 3, it shall in relation to the territories other than those referred to in subsection 4 come into force on such date as the central government may by notification in the official gazette appoint, and different dates may be appointed for different provisions of this act.
Correct.
So 30 was not given effect in 1961. It was given effect only in 2011. Now that has been considered by 3 of the Honorable High Courts by the division benches. Now just to buttress my first point, that section 17 of 2007 Act, which doesn't allow lawyers appearance and starts with the letter notwithstanding any law. So on that day, section 30 was not available.
Yes.
Now, my lord, kindly the Kerala aage Punjab Haryana. Lord, this is the first judgment. সেলাই করা নেই কেন? এইটা দাও, এইটা সেলাই করাটা দাও, জোসেফের হাতে পিন লেগে যাবে না। এটা দাও, সেলাই করাটা। হ্যাঁ। Lord, this is the first judgment on this point. EIR 2014 Punjab and Haryana 21.
Yes.
Lord, although this is a division bench judgment, but Lord, it was delivered by Justice Sanjay Kishan Kaul. So ultimately, Lord, kindly take paragraph 20 page, internal page 21. Lord, you also will get the top left hand side of the page. There is no paragraph number in this judgment. My lord has got that.
Page?
page 21. Kindly come to page 21.
Yes.
Starting with the heading right to legal representation.
Correct.
The right to legal representation has been specified in section 17 of the said act, which reads as under. Where I am not traveling, your lordships. The aforesaid section, no, we may note that the aforesaid section did receive the attention of the members of the parliament during the course of debate, as is apparent from the perusal, the Honorable Minister, while piloting the bill, referred to section 120 CRPC incorporating the provisions of maintenance of parents, and in that context it was observed that going to the court and engaging lawyers would be a very cumbersome process as well as time consuming apart from cost. The emphasis was put on cancelling conciliation, and thus it was observed there would be no advocates. The tribunal would follow summary procedure and the claims would be disposed of in time-bound manner. In fact, some reservations was expressed in this behalf in Parliament as to how the application would be drafted, serviced, effected, etc. Would be any legal assistance. One of the members, Sri Swansu, observed that since more tribunals are being constituted, the powers of the court are shrinking. In this context, it was observed that Section 30 of the Advocates Act dealing with the right of advocates to practice through forming a part of the original Act of 1961 had still not been implemented and thus was taking away the powers of lawyers. He expressed concern and if the lawyers are not appearing but NGOs appear in the matter of conduct cases and adducing evidence, to the lawyers, they are in the council. We have referred to the aforesaid context under section 30 of the Advocates Act having been brought into force as on the date of discussion on even the passing of the bill of the said act. Learned amicus curiae submits that on a thorough examination of the judicial pronouncement in this behalf, the view which appears to prevail is that there can be such exclusion. He, however, hastens to add that in most legislation like the Industrial Disputes Act 1947 and the Consumer Protection Act, the right to be represented through a legal representative has been left at the discretion of the concerned tribunal. Authority or the consent of the opposite party. He pointed out significance of section 30, where section 30 is quoted. The aforesaid provision confers the right to practice of the advocates throughout the territories before the courts, tribunals, and any other authority before whom such advocate is entitled.
Yes.
Then kindly take the next page. The role of legal practitioner becomes crucial where evidence has been adduced. The first line, adduced and as under provisions of the Act, they no more remain simple proceedings of just determining the maintenance up to 10,000, but deal with the rights of immovable property and the declaration to nullify transfers under the deeming provisions of fraud, coercion, and undue influence. That is where the lawyer's presence is necessary. Then we will kindly take page 26, 27. Page 26. Not the paragraph starting with Learned Counsel, third paragraph. Learned Counsel for the Union of India took time to produce notifications on 9th June, on 27 May. In terms of thereof, his provision had been brought on record, which was 15 June, which I have just shown to the lordships. The question which arises as to the effect of this in this context, section 17 of the Act, it is no doubt true that section 17 of the Act begins with the notwithstanding clause. However, while determining the right of representation by legal practitioner, a complete phrase used is notwithstanding anything contained in any law. The reference in any law can only be a law as on the date when the Act came into force, that is 31st December 2007. Section 30 of the Advocates Act did not exist in the statute book. This is so as to the Parliament in its wisdom had given the right to the executive to notify from which date this provision would be applicable. Thus, Section 30 of the Advocates Act would be any law only if it was in the statute book. The provisions came into effect on 15 June. But kindly take the next page. However, the provisions was not a part. Next page, second line. Was not a part of the law on account of the conscious will of the Parliament to leave the aspect of enforcement of the executive, and the executive therefore in its wisdom brought it in force on 15 June 2011. That is much after the said Act came into force. It is in this sense a subsequent law which has come into force. In fact, while enacting section 17 of the Act, as is also apparent from the parliamentary debate, the absence of enforcement of section 30 of the Advocates Act was an aspect noticed. Thus, there was consciousness in the debate of the parliament, section 30 was not extended. We have to also keep in mind that this provision is crucially significant when we are dealing with the aspect of actual date. While dealing with any tribunal or person who is legally authorized to take evidence, the tribunal under the said act is authorized to take evidence. Such evidence is crucial while dealing with section 30 of the act. You kindly skip over, kindly come to page 28. Page 28, the next page, starting with conspectus. Maras kindly got that?
Yes.
In this conspectus of the discussions aforesaid, we are thus of the view that the decision by section 30 of the Advocates Act has become law on a posterior date to section 17 of the said act, which is sufficient for us to come to the conclusion that there cannot be an absolute bar to the assistance of legal practitioner to a tribunal or the appellate tribunal despite the notwithstanding clause. Both the enactment are central enactments. While the said act was being enacted, the absence of section 30 of the Advocates Act was known. Not having conferred the right under section 30 of the Advocates Act on the legal practitioner, the parliament in its wisdom had found no reason to give such right under section 17. However, the situation has subsequently changed on account of section 30 of the Advocates Act having come into force. Now, kindly now come to the bottom of the page, the conclusion given by the court. The aforesaid anomaly, apart from our observations, aforesaid itself would be requiring the central government to look into the matter of section 17 of the said act, formally still being on the statute book. We thus conclude, page 29, on the provisions of the acts, we would request the central government to have a relook into the provisions of the said act in view of the observations aforesaid, more so in the context of section 30 of the Advocates Act. The right to appeal is conferred on a party aggrieved under section 16. Then 3, section 17 would not come in the way of legal representation on behalf of the parties post 15 June 2011. So section 17 has been read down by the Punjab and Haryana High Court. Now, the matter again came up before the Kerala High Court Division Bench.
No, we thus conclude the provision of that. We request the central government.
The 3, section 17 would not come in the way of legal representation on and from 15 June.
Yes.
In view of section 730 of the having come into force. So today, according to Punjab Haryana, section 17 cannot be a bar. And the request was made to the central government also. Then comes Kerala, 21 Kerala. Kerala, I won't travel a lot with the earlier thing. Kindly come to page para 50 of the judgment.
50.
Well, here the division bench goes one step ahead, declares it ultra vires. 50. ঠিক দিয়েছিস তো নাকি দিল্লিটা দিয়ে দিলি? আমার পেজটা খুলে দেওয়া উচিত ছিল। Internal page 29. Should I open it for your lordships?
Yes. That all have been. Yes.
Contention of the learned counsel for the petitioner and the Bar Council of India. There, the Bar Council of India was made a party. Bar Council that the tribunals are clothed with the powers of civil court for the purpose of taking evidence, enforcing attendance, production of evidence, and the denial of legal assistance to the parties before the tribunal constituted under the maintenance and welfare of parents and seniors in 2007 requires consideration for the reason that the parties to the lease are not expected to know the nuances of law, evidence both oral and documentary to be produced. Legal aid is a constitutional right guaranteed under Article 21 of the Constitution of India, and the legal assistance cannot be confined only to legal advice, which in our view would not be sufficient in the interest of the parties. The contention of the Union of India that since the main intention of the Maintenance Welfare Act 2007 is to provide speedy and cost-effective mechanism to the parent senior citizen to the claim of maintenance from the children, grandchildren, relatives, as the case may be, and the participation of advocates in the proceeding will jeopardize this object, cannot be accepted for the reasons that mere engagement of a lawyer would not delay the process of adjudication of a dispute before the maintenance tribunal. I am completely agreeing with this. They should not go against the lawyer. Now, the cost-effective mechanism cited as one of the reasons for denying assistance also cannot be accepted for the reasons that if a litigant is unable to engage a lawyer of his choice, legal services authority constituted under the Legal Service Authorities Act come into aid of such litigant by engaging lawyers to assist him. Union of India cannot undermine the role of legal services authority and the lawyers engaged by them to assist the litigants in comparison to the lawyers to be engaged by the children, grandchildren solely on the ground that they are financially in a better position. True that the legislation maintenance and welfare 2007 has envisaged that the disputes and differences should be resolved amicably and in the context laid emphasize on the role of the conciliation officer nominated by the tribunal, but he will not be a substitute of a lawyer. Contention of the Union of India that the makers of the act foresaw that engagement of legal practitioner to represent cases will prolong the matter and will be more of a harassment for the parents and the in their last phase of life. Judgment will be delayed in whole Section 30. As Section 30 of the Advocates Act has brought into force on 15 June, advocates enrolled under the said act have been conferred with an absolute right thereof to practice before all the courts and tribunals by virtue of Section 30 of the Advocates Act 1961 coming into force on 15 June 2011. The restriction imposed and taken away in such circumstances, Article 19 of the Constitution of India, which guarantees the freedom of practice, any profession, enables the advocates to appear before all the courts and tribunals subject to Section 34 of the Act. In the light of the above discussion and decisions, Section 17 of the Maintenance and Welfare of Parents and Senior Citizen Act 2007 is declared ultra vires of Section 30 of the Advocates Act, and thus the petitioner is entitled for a declaration that he has a right to represent the parties before the tribunal court constituted under so and so accordingly representation is allowed. So it was declared ultra vires to Section 30.
Yes.
Then comes Delhi, all division bench judgments. Blood 2022 SCC Online Delhi 3221. They also reported in 2022 6 High Court cases Delhi 179. Blood paragraph. Blood kindly take blood paragraph 5. Kerala judgment has been quoted. Paragraph 6 blood Punjab Haryana has been quoted. Punjab Haryana quoted in ultimately can come to para 9. Kerala taken note of, Punjab Haryana taken note of, then paragraph 9. The Punjab and Haryana High Court, by way of the said judgment, have requested the central government to have a relook into the provisions of the Maintenance Act in context of Section 30. We are informed that as of yet, neither any decision has been taken in the respect, nor any appeal has been filed against the judgment passed by the court, Punjab Haryana Court. We are in agreement with the view taken by Punjab and Haryana and direct Section 17 would not come in way of legal representation on behalf of the parties before the Maintenance Tribunal. So Punjab, Haryana and Delhi says it will not come in the way, and Kerala says Section 17 is ultra vires to Section 30. Now, what is the effect of a judgment by one High Court holding a statute to be ultra vires, which is a central statute, to the other High Court? I'll give you one judgment. This is Kusum in Goats. I'll take 2004 6 SCC for 254. Let's take paragraph 22 of this judgment. Para 21.
Yes.
Para 21. 22 is the main paragraph. I don't want to trouble your lordships. So, lordships declares a central statute that would be open country. I'll have a look at it. The court must have the requisite territorial jurisdiction and order passed on a petition questioning the constitutionality of a parliamentary act. To Article 220 of the Constitution of India will have the effect throughout the territory of India, subject to, of course, to the applicability of the act. So the Kerala would have application all over Bengal in terms of Kusum ingots. But today we are faced with a situation. My client has lodged a complaint before the tribunal. He wanted to be represented by a lawyer. But amongst these 3 judgments filed by litigant lawyers, one was filed by lawyer as well as the litigant. I think that Kerala one. Lord, we have filed a supplementary affidavit. Can you take that once? It's 5 of the supplementary affidavit. What data? What 2 page supplement? File করেনি এই যে kindly grant me leave to file it. I'm sorry, my lord. I'm extremely sorry. Copy দাও নিয়ে বসে আছে এখানে. Kindly have a look at page. I'm sorry, my lord. I apologize. Only one page I want to vote in. Page 5. The notice given to me by the tribunal. Take notice that the application has been filed by an applicant under section 4 of the So-and-so Act, claiming maintenance as per So-and-so. The case is posted on 7 May 2026 at So-and-so PM, office of the tribunal at the address stated above. You are required to be personally present on the said date and time together with proof of your identity and statements and objection documents you wish to rely upon. If you fail to appear, so given under So-and-so. Noted below. Tribunal 17 of the Act of 2007, where it has been sent the notwithstanding anything contained in any law on a tribunal or appellate tribunal shall be represented by a lawyer. Lord, I beseech before your lordships, my lord, this is my humble submission that those judgments which has declared it to be ultra vires section 30 would also be applicable to your lordships, my lord. Kindly, my lord, following that, direct the tribunal, and not only this tribunal in all districts of the state, not to insist on not following section 17 because that has been declared to be ultra vires section 30, and allow me to appeal the lawyer. This is the only issue now. Whether I win, I lose before the tribunal, then we'll file an appeal and come back to ultimately disturbing your lordship after some time. That's a different thing. But as of today,
Who are you? You are the senior citizen,
I
mother.
am a senior citizen. I'm
Mother.
the father. Lord, I don't want to go to the nitty-gritties of the complaint right
You are the
now.
father.
Yes.
Against whom you filed?
Not against my children. The complaint, Lord, is at against my children.
Yes.
Complaint yes, complaint is at not page 27 of the writ petition.
Okay. Who is for the other side? No. You're for the wife.
Only wife.
Wife means?
My wife. Lord, the complaint is against
It's also the opposite party.
we have Lord, I don't know why they have been made opposite party. It's a completely question of law. They may not have been even, but we have sub notice on them.
Yes, who is for the other side?
State is here.
Yes. What is your answer? Section 30 and section 17?
Since the
Section
question
30?
of law is involved,
Huh?
since the pure question of law is involved, Lordship, I need to seek instruction on this.
Law, what instruction you will
There
take?
was a bar in the Lordship. Okay, I can say, there is statutory bar. Apart from that, I have to seek instruction on because.
All law.
What instruction?
I don't want. I just want to seek their.
You have to give instructions to the authority, sir.
আইনের মামলা আইনের মামলায় কি ইনস্ট্রাকশন ল ইজ সেটেল তিনটে হাইকোর্ট আল্ট্রা ভাইরাস ডিক্লেয়ার করেছে
Yes.
The provision of law is declared ultra vires by a different high court. Now that is applicable to high court also.
as per Kusuming Board that I have shown.
Therefore, your lordship to decide it.
But only one request, my lord, can you direct the judicial secretary to inform all the tribunals, my lord, I have come, the others may not be able to come. So this insistence should not be there on a provision which is declared ultra vires. Only on that.
Yes.
This is my submission.
Yes. You are appearing in person?
Yes.
Yes, what is the submission?
I would just like to put forward that as it's been proposed by the opposition saying that the Punjab and Haryana High Court have passed this particular like not part any citizen from having a legal practitioner position. But that court belongs to like Punjab and Haryana and we are in West Bengal. So this sort of any order has not been passed yet by the respected West Bengal High Court. And also I would like to highlight that as it says under section 17, any proceeding to a tribunal or appellate tribunal, that the party cannot be represented by the petitioner. That's all my argument is for this. That's
So if suppose if the court will allow, so you will also get the
Yes,
opportunity.
you will also get a
to
lawyer.
But out here the main reason for the opposition to have a legal practitioner is to fabricate and produce everything in front of the.
You will get it. Fabrication will not, because there is a provision for evidence. Evidence means if they will give the evidence, then you can cross-examine rebutting the evidence produced by the party. So that's why the cross-examination is there.
Your decision will be surely accepted, sir. That's
Thank you. Heard the learned counsel for the respective parties and the respondent number. Your respondent number?
Your respondent number, please tell. Huh?
Respondent number 5. No, you. They are the respondent number 5. Respondent number 5 in person. Hearing concluded. CAB. Yes.
But apart from this, there is a concept of committee of courts, which comes from the English law. That one court should follow the, may not be, but in Kusum Ingot clearly says it will be applicable. Even if it was not against the syntax statute, the persuasive value, committee of courts, but one court should follow the judgments of the other court.
Correct.
That's the concept of committee of court.
We are
That's
following.
coming from English
It's
law.
not.
Yes.
Sometimes if it is defer, then it
Absolutely.
has to be referred to the division and
Kusum Ingot is very clear that if it is a central statute, if that is declared ultra vires, that will operate throughout the country. Even my lord declares that will be applicable to any other high court. That's the law. And I'm grateful to you.
Yes.
before the lawsuit proceeds to take up any other matter.
Yes.
then I think you will definitely fault on the part of the speaker.
Sir, this is not only.
I
am totally fed up with the state advocate. Since morning, I am crying.
Morning, sir, I personally think
Since morning, I am crying. I am telling. See, first, I already inform you. State means is all. Not only the police. State means all. Second thing, only by producing one paper, giving 2 lines written by the officer in charge will not solve the problem. Like this, if a law point, the lawyer has to say something. Has to say something. But if the court is telling what is that, the lawyer is keeping mum. Then the court has to act. Something tomorrow that the petitioner's lawyer may comments upon the court. Court is taking the side of the other side.
That will never come.
Maybe
for
I
my
am
law-
telling. Correct. So let them go through the brief. Read the brief. Come. Only by giving the 2-line instruction to the court. I am not blaming you. And with regard to this case, on the last occasion, I requested the petitioner to supply the copy.
Today in the morning, sir, I asked your lordship court. I saw that Advocate General is present. Therefore, Lord, I left.
And petitioner's copy has been served. He has taken the copy. Assured before this court, he will come with the report.
Train not to be here, so that your lordship can be properly assisted.
He told me that whenever you are free, come here and take care of the state matter.
Because
I
the
told
state
him that
lawyers cannot be
whatever
vocal
I can
or
make, Lord.
cannot properly make their submissions. But
kindly-
it's really unfortunate.
Kindly excuse him. He's a junior member. Do not pass that. Do not sign that order, my lord. Kindly, I request your lordship, lord. The government period is here. He is not.
That's why he has come.
He
now.
has to go to every court and
I
now.
pass this order. I directed the petitioner, so he has received the copy in open court. What is the name? Where is the file? What is the name of the advocate?
Lord, learned government period is here. We assure your lordship, lord, will
So
come
now
and
I
take
pass-
care of this court. Don't worry.
Advocate has taken time. I will submit the report, but nobody. Okay, time is asking. Okay, no problem, but nobody is appearing.
এরকম একটা ঠান্ডা মাথার লোক রেগে যাওয়া মানে তো বুঝতে পারছো।
And this court is totally short of time.
আর I told the government period যে এরকম ঠান্ডা মাথার লোক রেগে যাওয়া মানে তো খুব নিশ্চয়ই অসুবিধা হয়েছে। The lordship
Saurabh
not
Ghosh.
always so calm.
Yes.
Saurabh Ghosh.
Lord, Lord, I am
Sukanto Ghosh.
He is additional advocate on record. Now, Lord, Sukanto Ghosh will not appear.
Saurabh Ghosh, Sukanto Ghosh, and Aragya Chatterjee. These 3 persons had appeared on behalf of the state. On my instruction, writ petition was served. They have taken the time.
Yes, but I am told, Lord, that Sukanto Ghosh Lord, is no more appearing in this matter. AOR has changed the learned advocate. Hindu Jana is appearing. Lord, he will
You
take
could have
care.
appeared.
Lord,
Okay, let us see.
Kindly, Lord.
Please.
Kindly, Lord. Kindly.
Not to take, not to.
And wait, but in the,
Let it
that,
appear tomorrow.
Let it come
Yes.
tomorrow. Let it come tomorrow.
I'm grateful.